Malad one mentioned it.
Yes, please. What did you just say?
No, I believe so.
No, when I take up that. Yes. Hold on. This is the matter, Mr. Sharma.
This is my application. Lordship had passed an order on September 4, 2024, which is at page 14 in the section 9 arbitration application.
Yes.
Directing an order of injunction that they will not deal with the shares. Now, subsequently, we have come to know, though the document is not there because it is all on the portal. So we have come to know they have sold 8,000 shares out of the total 10,88 shares.
This is appearing for the first time.
First time. Kindly give me leave to serve them.
Yes. Since
And Lordship, kindly give me leave to file a supplementary. If I can try to
We'll do
some
that, but you have
snapshot or
to-
something.
you have to serve an advance copy of that also then.
Yes, I will.
A prima facie case of contempt has been made out. Full stop. Next para, learned counsel for the petitioner also seeks leave to use a supplementary affidavit in the event other documents are available to substantiate the allegations made in the contempt application. Full stop. Such leave is granted. Full stop. The petitioner shall serve a copy of the present application as well as an advance copy of the proposed supplementary affidavit, comma, if used, comma, on the alleged contemners, indicating that the matter shall next be listed under the appropriate heading on December 20, 2024, when the petitioner shall file an affidavit of service to that effect. Full stop. Supplementary affidavit, if any, shall be filed on the next returnable date. Thank you.
This is my application, Lordship.
Appearing for the first time?
No.
Rule has been. What is the nature of contempt, Mr. Pal?
Lordship, kindly, Lordship, turn, Lordship, order.
Decide on the representation.
Lordship.
Representation was for they're sitting tight over the registration.
Lordship.
What is your answer?
They have not disposed of it belatedly. At the outset, I tender apology for the delay. They should have done it earlier. They have disposed of it. They have come to the finding that there is deficit stamp duty. That decision has been communicated to them, that they have to pay the deficit stamp duty. Upon payment, it shall be handed over to them. If they don't pay, then the matter shall be deferred under section 47A for.
When has it been communicated?
Lordship, yesterday, Lordship, I just got the copy, Lordship.
Copy has been received on 27. 27.
You are guilty of contempt, Mr. Banerjee.
21st.
Why was there a delay?
Delay, is because of the adjudication process. They were called, hearing was given.
Hearing was given before the contempt was filed.
Yes. No, before the contempt was filed, but the decision was taken the day prior to the date when rule was issued. 22nd.
Yes, Mr. Pal, since they have already taken a decision.
Lordship, I want to file the exception, Lordship, because this is not a compliance, Lordship. Lordship, the representation is otherwise, Lordship. They have done this. Lordship, representation.
No, representation. My order was not that the representation has to be, not that the registration has to be done.
No, Lordship.
But that representation.
Consider the representation, Lordship.
That has been considered.
No, Lordship, that has not.
The order does not say that the representation has been disposed of, but it is the decision on the representation.
Mr. Banerjee, put it on oath.
I'll file affidavit.
File next week.
Next week.
Lordship.
Give a copy to them.
Advance copy, Lordship.
Obviously, yes. Learned counsel for the alleged contemnor submits that the order of this court dated April 26, 2024 has been complied, although belatedly. So it is submitted that prior to receiving a copy of the contempt application, the alleged contemnor had given a hearing to the petitioner and subsequently took a decision to the effect that there is deficit stamp duty paid by the petitioners, for which due compliances are required to be done. It is also submitted that subsequently such communication has been made to the petitioner. Next para. Learned counsel for the petitioner contends that there has not been compliance with the order of this court and submits that a communication was received only yesterday.
27.
Only on November 27, 2024 by email from the alleged contemnor. Next para. Since there is a dispute regarding the compliance, the alleged contemnor shall file an affidavit of compliance on the next returnable date with an advance copy to the learned advocate for the petitioner. The petitioner shall use an exception shall use a reply to the same, comma, if the petitioner so deems fit. Full stop. The affidavit of compliance shall be affirmed by December 6, 2024, and a copy thereof shall be given by the said date to the petitioner. Full stop. Reply, if any, shall be filed on the next returnable date. Full stop. The matter shall next be listed on December 13, 2024.
Much available.
The contemnor is present personally.
The contemnor, since the alleged contemnor is personally present in court and an argument of compliance has been made, comma, personal appearance of the alleged contemnor is dispensed with for the present, comma, subject to further orders of the court.
Deeply obliged.
Mr. Banerjee, please take this back, put it everything on, and you also state everything what you have argued.
To explain the delay.
Yes, to explain the delay and also that you have given a hearing and all these are not reflected, so that he can, Mr. Pal can just controvert. Thanks.
The petitioner, let's say good sense of the has been
Prevail,
held on
prevail.
the petition.
My lord, may I only
Lordship.
make one submission?
Yes.
My lord, I'm conscious of the fact that
For who? Appealing for whom?
my lord, I am the borrower whose property is sought to be sold. I have challenged.
Right do you have in contempt?
My lord, that's the my lord. I ideally understand this is not the way I should intervene. But
even-
my lord, what is essentially important that it's not the wisdom that has prevailed in the parties. It is gross suppression and the largesse of the honorable court has been used to make my challenge before the DRT infructuous. Orders passed in writ petition, I am not served with the copy. The bank appears does not inform the honorable court that there is a challenge pending before the DRT since the
Then
inception.
you should file either a review.
My
or
lord,
some-
leave to intervene. This is a contempt proceedings, my lord. I possibly cannot have a right.
Will give a reason and I'll give a reason and I'll refuse that, but I'll give you liberty to take whatever steps against the order or either appeal or whatever.
Very well, my lord.
I'll give-
Ideally, my lord, what is happening, my lord, before the learned tribunal,
Yes.
now they are submitting that learned tribunal is a subordinate jurisdiction. That is what the allegation is. Since the Honorable High Court has ratified the sale, now my challenge, which is pending before the tribunal,
That's a
will
legal argument that can be controverted by you there.
very
And
well,
you
my lord.
already
Kindly,
accepted.
kindly record my intervention. That will
Learn, definitely,
Lordship,
I have to.
Instruction of my client may be kept on record.
Very well. Learned counsel for the petitioner submits in unison, UNISON, in unison with learned counsel for the alleged contemnor that the order of this court has since been complied with. Full stop. A written instruction in that regard is filed by the learned counsel for the petitioner, which is kept on record. Full stop. Next para. At this juncture, comma, you are for the borrower.
for the borrower, mortgagor, owner.
Learned counsel having instruction to appear stroke intervene for the borrower stroke mortgagor stroke owner for the alleged borrower stroke mortgagor stroke owner of the disputed property contents that the said party be permitted to intervene in the matter, since it is argued that relevant facts, comma, including that the borrower has preferred an appeal before the debts recovery appellate tribunal,
My lord,
comma,
tribunal, my lord. The DRT, Debts Recovery Tribunal.
not the appellate tribunal.
Because it's still
Has
before the
filed an
trial court.
appeal na bole, has filed a challenge before the debts recovery tribunal, which was not disclosed to the court, but might have been germane in the adjudication in the writ petition. Push up next para. Upon hearing learned counsel, comma, this court is of the opinion, since the alleged contemnor has complied with the order of this court, comma, although belatedly, comma, the contempt has been purged to that extent. Full stop. Next para. However, comma, in the event the party seeking to intervene has a grievance against the parent order on whatever ground, comma, it would always be open to the said party to prefer an appropriate challenge, comma, either by way of an appeal against the parent order dated January 3, 2024, passed in WPO 1803 of 2023, or by review or otherwise. Full stop. Next para. Nothing in this order shall prevent such rights of the alleged borrower. Full stop. It is further clarified that none of the observations made above shall be an impediment to the alleged borrower to canvass all the points which it has in the pending challenge before the debts recovery
I'm so
tribunal.
grateful. I'm so grateful.
Lordship, may this be kept on record that they have taken the actual physical possession of the property?
আরেকটা লাইনে add করে দিন print out indicating the compliance of the order, comma, handed over by learned counsel for the alleged contemnor in court, comma, be also kept on record.
Grateful, Your Lordship.
Grateful. ওটা বলিনি না? আচ্ছা CC 70 of 2024 is accordingly disposed of. Thank you. लिखे बहुत अच्छा. For the respondent, you're appearing.
Your Lordship. Item number 5, Your Honor.
This is the second successive occasion of, sorry. This is the second successive occasion after November 22, 2024, when none appears for the parties at the time of call. Full stop. Accordingly, GA1 of 2024 is dismissed for default without any order as to cost.
Lordship, I'm being led by Mr. Shashwat Nayak.
My lord, I'm there. My lord, I was also asking for an adjournment only, my lord, virtually. I'm slightly handicapped.
Depending on
I'm
Mr.
appeared-
Bose.
My lord, in that event, my lord, I would be praying for one indulgence. My lord, the arbitration proceeding is continuing. My lord, prima facie, if I may show to your lordship, by which if your lordship can stay the arbitration proceeding for the time being, because it's already one sitting has been held and the other sitting is fixed
My lord,
on.
may I just make a suggestion, my lord? I don't
Yes.
think Mr. Bose's case would be heard by that. I would only say, my lord, that I was praying for the matter to be taken up next Friday. In the meanwhile, my lord, we will make sure lordship need not record it. The arbitration will not take place. It is my section 11 application, arbitrator appointed. They have come forward with a recalling
Mr.
application. So I
Nayak, we are,
understand-
then we can proceed only on your undertaking, but if I don't record it, it will be entirely on faith on you.
Yes, absolutely. Or lordship records my undertaking. In that case, my lord,
In him, if I'm not on any advocates. In fact, I would never say
Right.
I don't
Lordship,
have any.
lordship,
You
lordship
applies to me
records
also.
my lordship records my undertaking that till the next date of hearing, my lord, subject to whatever is the
His
outcome.
undertaking is client's undertaking.
Should I record that?
Yes, my lord. That the
That
client
will not
the-
proceed with what?
till with the arbitral proceeding, we are the claimants in the arbitral proceeding. Till the next date, my lord. Lordship will clarify that.
Very
Till
good.
the next date that the matter is taken
An
up.
adjournment is sought on behalf of the respondent. To sub next para, learned counsel appearing for the petitioner submits that the arbitral proceeding may continue in the meantime. Now, is continuing, comma, and as such, the petitioner seeks a stay of the same in view of the adjournment sought by the respondent. For sub next para, at this, comma, learned counsel for the respondent submits that he is undertaking on behalf of his client, comma, the respondent, comma, be recorded to the effect that till the next returnable date, comma, till the next returnable date, comma, the respondent shall not proceed with the arbitral proceeding. Full stop. Next para. Upon recording such undertaking, comma, accordingly, comma, the matter is adjourned on the prayer of the respondent till December 6, 2024, when it will be listed under the same.
Grateful, Lordship.
My lord, only one small thing, my lord, where your lordship has recorded the petitioner. Lordship will record that, my lord, the applicant in the recalling application, because my lord, the cost title is the same as my section 11, my lord.
আচ্ছা ভেরি ওয়েল যেখানে বাবু যেখানে যেখানে পিটিশনার বলেছেন এখানে দু তিন জায়গায় পিটিশনার বলেছেন ওটা অ্যাপ্লিক্যান্ট করে দেবেন অ্যাপ্লিক্যান্ট পিটিশনার বলে অ্যাপ্লিক্যান্ট থ্যাংক ইউ ইয়েস
Great.
I'm grateful, my lord. I'm grateful.
থ্যাঙ্কস ইয়েস
My lord, this is my review application, my lord. Lord, I'm led by Mr. Bose. Perhaps Mr. Bose is connected. Mr.
Yes, Mr. Bose, you are there. Yes,
Yes, I'm there.
Led by Mr. Joy Shah.
right. Yes, Mr. Bose, what is the ground of review?
But I have been requested
Well,
to
let-
pray for an adjournment for the day.
Mr.
Mr. Joy Shah is also.
On the ground of Mr. Joy Shah, an adjournment is sought for the day. Mr. Bose, what is your response to that?
I have no objection.
Very well. An adjournment is sought on behalf of the petitioners, on behalf of the respondent in the review,
Respondent.
respondents in the review application.
Review
sir.
application.
Accordingly, let the matter stand over till December 6, 2024. 6 December, next
Wait,
Friday. Thank you.
wait, wait.
Lord, may it please your lordship.
Give us half a second.
My lord, my learned friend has already concluded his argument. Only three, my lord, the issues I have to give the reply. And all the issues are so interlinked. So if I demonstrate the first issue, it is connected with the other issue also. And two, my lord, the challenge has been thrown. So far as the, my lord, the present petition are concerned. One, my lord, has been filed by us. We are the claimant herein. They are the respondent, and respondent also filed Section 11 application, challenging certain anomalies in the, my lord, the award, and my lord, the rectified award, and the
Section 11 application.
no. Section 34 application has been filed
Yes.
by both the parties, wherein, my lord, in Section 33 application, in a rectified
yes.
award, certain mistakes are there.
One said Section 11. That's
Oh,
right.
sorry, my lord, I have
Sorry.
mistaken.
So
I have
both of you challenged.
Yes, I have mistaken, my lord.
They challenged regarding that rectification not being allowed.
Not being allowed in Section 33 of
Yes,
application filed by us.
Understood. Very
In a gist, in a nutshell,
Please take your seat. Yes.
in a nutshell, there the point of limitation is not sustainable. The finding arrived at by the arbitral tribunal is correct. Reasoning is wrong. So far is, my lord, the one of the issues that the subject project has been terminated. The finding is incorrect on the basis of the document and the evidence which has been disclosed by both the parties. Third one, since there is no termination and there is no invocation of the clause 3C in any manner whatsoever, therefore awarding counterclaim is completely without jurisdiction. So, my lord, kindly take trouble to have a look at, my lord, my prayer at page 34 of the volume 1 of, my lord, kindly see, take, my lord, side by side 2 volumes. One is ours, other is, my lord, filed by them. So volume filed by the, my lord, us.
You means give the number.
Oh, my lord. So AP number 95 of 2022.
Very well, yes.
Volume 1.
You are Konarak.
My lord.
Page 14 of yours.
34.
Sorry, page 34 of your. Yes, right.
Paragraph 24.
Paragraph 24.
In the light of the above background, the claimant submits the schedule of the claims as under. What are the claims? Claims are refund of the security deposit lying in the custody of the respondent along with the interest. How, my lord, the amount has been derived? I will place it. Because, my lord, on previous occasion there was an anomaly and therefore I was not prepared. Therefore, I could not assist your lordship in the manner it deserves. Then, my lord, the amount is refund of the security deposit. Then delays interest of the principal amount. These are the two principal claims. Apart from these, no claims are there. This is the, my lord, the interest. So principal is the refund of the security deposit. For refund of the security deposit, we have to know how the security.
They were the claimants. Before the tribunal, they were the claimants.
No, we are the claimants.
Oh, these are your claims.
These are my claims.
Very well. They were the counter claimants.
Yes.
Yes.
They sought for counter claim only for the remaining portion of the work which alleged to have not have been executed by the others. Nothing else. So at my instance, my lord, the arbitral proceeding has been initiated. So now we have to know how the security deposit comes. Kindly take trouble. Page 71 of the volume number 1 of the respondent.
Yes.
Similar, kindly see the earnest money. Serial number 1D. Kindly take note of it. The earnest money deposit was deposited by me at the time of the notice inviting tender, which is the part of the security deposit. Kindly take my lord note of it, 4,71,660. Then my lord kindly have a look at the same volume, page 98 of the volume 1.
Yes.
This is the work order which has been issued in my favor. Kindly see, my lord, the nomenclature security deposit. Well, also got it. An amount equal to the 10% of the each running account to be deducted from the bills of the contractor subject to the maximum of the 10% of the contract value. That means each running account bill, including final bill, they are obliged to deduct 10%, which my lord constitute the security deposit. Then kindly see there is a plus mark. Security deposit, security money plus initial security deposit, which I have shown to your lordship, my lord, in the form of the earnest money will be released as per the clause part 3, video number such and such at the printed form.
So security deposit is comprised of both. One is running from the
Deduction.
running and the initial.
My lord.
Right.
So, my lord, everything is clear because my lord, there is 4 running account bills are there. 10% of the 4 running account bills along with 4 lakh something which I have shown to your lords.
Right.
Then, my lord, kindly take trouble to have a look at clause 1P, page 72 of the same volume, 72. My lord, got it, my lord?
Yes, got it.
P. The bidder shall be required to properly maintain the road, including all its component, for the period of the 3 years from the date of the completion and the handing of
P.
1P.
I mean,
At page 72.
It's within the one. Wait, P. Sorry, please continue.
The
Bidder shall be required.
The bidder shall be required to properly maintain the roads, including all the components, for the period of the 3 years from the date of the completion and the handing over of the HDA in the proper format. A security deposit of 10% shall be deducted from the each running account bill up to 10%. Then 2%, Miller. What I have shown 4,71,000 something. 2% EMD may be adjusted such and such of the security deposit. The release of the security deposit should be subject to the quality maintenance such and such of the 3 years. It has been submitted by my learned friend. After successful completion of the work, we would be entitled to get to refund of the security deposit 30%, 30% and 40%. It is not correct. As evident from the clauses, kindly have a look at page 90 of the same volume. My lord, it starts from page 89, clause 17. Just I will refer the, my lord, the first portion of the at page 90. My lord, got it, my lord? The security deposit of the contractor made in the manner provided in the clause 1 hereof shall be refunded on the expiry of the 3 months, 6 months in case of road work. My case is the road work. Then after the issue of the certificate, final or the otherwise, of the completion of the work, subject to the condition that, then my lord, kindly take a note of it, no such refund of the security deposit shall be allowed till the final bill has been prepared and passed. So unless the final bill would not be prepared, I would not be entitled to get the refund of the security deposit because 10% would be deducted. That would be the part of the security deposit.
So primarily you are arguing now on limitation because your cause of action arises only after.
Limitation. Final bill paid on.
You can also show me the any provision, if there is any provision in the contract regarding this, how it is to be prepared and passed or something like that. Is it reflected or the normal
the bills how to
practice?
Bill how to prepare the provision is there. Bill how to
come to that once also. So
yes.
You continue in your own way. Please that how it is prepared and passed, that it has to be passed by their engineer or something like that.
My lord.
Yes.
My lord, final bill paid on 18th of May 2016. Fourth running account cum final bill was paid 18th of May 2016 at page 336, volume 3 of the claimant's document. Kindly take, my lord, volume 3 of my document, that is
Of AP 464.
of my lord AP 95 of 2022.
Yes. Right. 336.
I am coming.
Hmm.
Yeah, the 2 volume 2 of AP number 95 2022, because the measurement book starts from 293. That's why I am referring, my lord, volume 2 of the claimant's document 293. So that your lordship, my lord, I can, my lord, place it 293. Fourth and final bill.
Right.
It starts from page 293. I am referring 336 is the continuation of the fourth running account come final bill. Then, my lord, kindly take once 293 once. Date of completion is 24th of September 2010.
Right.
This is such a document, nobody cannot question the authenticity of the said document, because this is a measurement book completely prepared by them.
All right.
And this document has been signed by both the parties. Mere the letter will not do. The contemporaneous communication can convince or can draw a presumption. But this is such kind of a document which cannot be rebutted unless contrary is proved. So, my lord, this is the date of completion. Good, bad, indifferent. The date of completion is 24th September 2010. Date of measurement, which has been mentioned below that. Only to draw your lordship's attention, I have referred it. Then, my lord, kindly have a look at page 336.
Page 336. Yes.
My lord, kindly take the internal page 89 of the measurement book.
Right.
Kindly see the date has been mentioned 18th of May 2010.
Right.
Above the, my lord, the entry
Got it.
57 something.
Got it.
So, my lord, the payment has been made on 18th of May 2016. The procedure of payment is this. This is the abstract of evidence. So, therefore, the last payment was made on 18th of May 2016. Yes. Since the payment made 18th of May 2016, therefore, out of this one, the amount 10% would be deducted and part would be the security deposit. I would be entitled to pay for release of security deposit after getting the final bill.
Not getting it after it is prepared and passed.
Prepared and passed.
Could have been passed a few days back. You get the money after that.
No, this is the passing of the bill.
Oh, acha, this is the measurement book that.
Yes, yes. This
very
is
good.
the passing of the bill.
Right.
I can take the money after 10 days.
You get entitled from this date.
This date. Then, my lord, so the date of completion is 10th. I have shown to your lordship, my lord, in there at, my lord, the 2010.
24th September
24th
2010.
September 2010.
Yes.
Nobody cannot question the authenticity.
All right.
And subsequently, my lord, the final forthcome running account bill was paid such and such. Immediately thereafter, I demanded within 2 months. And, my lord, this my lord, reference has been made on a subsequent date. I, my lord, draw your lordship's attention. The date of demand release 17th. Demand releasing is the amount. Yes. 1st of July 2016. I, my lord, sought for a demand seeking that you release the security deposit. And thereafter, my lord, 21 notice was issued and arbitral tribunal was constituted. So, according to me, on the basis of this, there is no limitation at all. But the finding, kindly take a note of it, my lord. Finding is at 612 of volume 5. Please,
AP 95 still.
My lord?
AP 95.
AP 95. 612. The reasoning which has been ascribed over there by the larger arbitral tribunal.
612.
My lord,
Page 612.
612.
Yes.
The reasoning which has been mentioned over there prior to the paragraph number Y, that is, there is 3 letters are there my learned friend has placed. That is 238, 239 and 240, which says that I will terminate the contract if you don't the job. I will place it, Miller. Otherwise, Miller, then I am coming. This one. This is volume 2 of their, my lord, of AP 464. My lord, got it?
Yes, page 290.
238. 238 of their volume, that is, my lord, AP number 464. Volume number 2.
5th January letter.
Correct, my lord.
Yes.
5th January 2011. In spite of the repeated verbal, my lord, this has been issued by the, my lord, the respondent addressed to the, my lord, claimant. In spite of the repeated verbal as well as the written request, you have not started the work till today. It is willful negligence of the work from your end. The local people are facing hardship due to the non-completion of the work. It has been viewed very seriously. You are directed to start the work within 7 days from the receipt of the letter. Otherwise, the HDA will have no alternative but to get the balance work done to the other agency at your risk and cost. Any claim of the payment from your end will not be entertained. Then the kindly see the next letter, page, my lord, 239, 9th of February 2011. In spite of the repeated verbal as well as the written request and the video above referred memo, you have not started the work at site till today. It is willful negligence towards the work and from the end, and the hence as per the clause 29 and the 16, all are irrelevant, my lord. I have seen yesterday, but I will place if your lordship desire to, my lord, see. General conditions and specifications. Your contract and them may be cancelled and the balance work may be done through other agency at your own risk and cost. In addition to that, the further penalty may also be imposed upon you by the authority as per the provision of the clause 16. This is also, my lord, irrelevant provision because this is not pertaining to risk and cost. Therefore, as mentioned, the termination clause in the work order, you are hereby served notice to start the balance work within 7 days from the date of the issue of the letter. Otherwise, the contract will be terminated, and the balance work will be executed by deputing the other agency at your risk and cost. This is nothing but one kind of so-cause notice. If you don't do this, in that event, that would be done. Next letter, my lord, kindly take trouble to have a look at, my lord, 240. Dated 1st of March 2011, on the basis of which emphasis was given by the learned arbitral tribunal, saying that the agreement was existed till that date. And this date has been considered by the learned arbitral tribunal as a date of termination. With reference to the office memos under reference, where you are requested to rectify the defective work and to complete the balance work of the subject cited road as per the conditions of the contract, but it is surprising that you have not taken up the work till today. Neither you have submitted your reply. It is viewed very seriously. It is treated as the gross breach of the terms and conditions of the contract. However, you are hereby given the last notice to explain your position within 7 days from the issue of this letter that why the contract will not be terminated for not executing the work as per the specifications as for the gross negligence of the work, failing which it will be presumed that you have nothing to say in this regard of the work order will be terminated without the further correspondence to you. All your dues, including the security deposit, pending payment, etc., will be forfeited. This letter may be treated, my lord, this is very important. This letter may be treated as the final notice prior to termination of the contract. Be that as it may, this is the situation. 3 notices were given, and in Interim, it has been stated that unless you will not do the work, in that event, termination will follow. Thereafter, there is no happening of the incident factum of termination of the, my lord, the contract
Without further correspondence.
without further correspondence. My lord, kindly take trouble to have a look at page 612 of my volume.
Yes, yes.
195. 95. Therefore, my lord, kindly see from W. Therefore, because it took my lord 12 pages, so I will not elaborate upon because. Therefore, the inevitable conclusion from the correspondence will affirm that the tenure of the contract expire on the 1st of March 2011. The last letter I have shown to you, Lord.
Yes, yes.
If that we show, the period of limitation from the defect liability period of the 3 years will commence from the 2nd March 2011. Completely premise was different, although it was not my argument, and neither the argument of mine nor the argument advanced by the respondent. A third case has been made out. That is because the petitional limitation such and such up to the 1st of March 2014. The period of limitation of the 3 years in the instant case will be from the 2nd of March 2017. The present claimant and the resorted to the arbitration admittedly the 13th December 2016. Following the demand letter dated 1st of July 2016 exhibit such and such from the end of the claimant and the respondent seeking release of the security deposit. This date is correct because I have shown to your lordship that I demanded the sum for the release, that is 1st of July 2016. I fully subscribe with the view rendered by such and such learned advocate for the claimant that the principle to be followed in such case will be under the residual article of the 137 of the Limitation Act of 1963, for which no period of limitation is prescribed, but the period of 3 years mentioned therein would be reckoned when the right to apply for the refund of the security accrues. In the
residuary
instant case,
provision, not money claim.
two provisions are there, my lord. One is Article 18, other is Article 137. Since
The residuary clause.
this is a my lord, the article, not Article 18. Article 18 is work done, but payment has not been made.
Since this is security.
Yes, yes.
Very well.
So the refund of the security deposit, in the instant case, the right to apply for refund full accrues with effect from the date of the demand dated 1st of July 2016. So good, bad, indifferent, my lord, according to me, there is no limitation. Since, my lord, the last running final bill was paid, immediately thereafter notice of demand has been issued. My lord, I have already placed, so far as the issue of termination is concerned, 3 documents. Therefore, I will not reiterate for the cost of the repetition. Kindly have a look at, my lord, clause 3, page 580 of volume 4 of AP 95.
This is a continuation of?
This is a continuation of, my lord, the arbitral award.
Oh, this is the award itself going. Very well.
The learned arbitrator, my lord, set out all the relevant clauses which are required to be dealt with by the, my lord, the learned tribunal. Therefore, it is set out, and original portion, my lord, is not readable. My lord, this is not. That's why, my lord, I am placing from here. Clause 3. This is the only provision by dint of which the relationship between the, my lord, the contractor and the employer would be terminated. In any case in which under any
the arbitral award quoting that contract.
Yes.
All right.
There is no dispute, my lord.
In any case?
In any case in which under any clauses of the contract, the contractor shall have rendered himself liable to pay compensation amounting to the whole of his security deposit, whether paid in the lump sum or deducted by installment, the executive engineer authorized officer on behalf of the authority shall have power to adopt any of the following courses as may be deemed best suited for the interest of the authority. First is rescind the contract. Rescission of the notice in writing of the contractor under the hand of the executive authorized officer shall be the conclusive evidence, and in which case the security deposit of the contractor shall stand forfeited and absolutely at the disposal of the authority. The learned arbitral tribunal hold that although subject project has been terminated or 1st of March 2011, but I am entitled to get security deposit, which is contrary, which cannot be done. If I fail to complete the work, in that event, I am not entitled to get security deposit. Security deposit will be forfeited. Next one is, my lord, to employ the labor paid by the authority to supply the material to carry out the work or any part of the work, debiting from the contractor with the cost and the labor and the price of the material for the amount which the cost and the price as the certificate of the executive engineer, authorized officer, and the shall be final and the conclusive against the contractor and the crediting him with the value of the work done. In
This
all
is the risk and cost, basically.
No, the risk and cost is last one.
So what is the difference between this and that?
This is, my lord, they will employ their own labor. It is not engagement of agency.
But still, then they're debiting you with the cost of labor and price.
Yes, yes, but this is not the risk and cost. Risk and cost is the last one, which is the basic principle. I will place one decision also in that regard. What is the requirement which is required to be done in a risk cost principle? Kindly take a note of it, my lord. To measure up. This evidence is not there. What is the remaining portion of the work which remained unexecuted? There should be a strict measurement. And money value would be there along with the bill of quantities. Suppose X, Y, Z work has not been executed. Money value would be 100 rupees. That would be evident from the measurement book. If the measurement book says subject work has been completed, in that event, this is completely osseous, is of no relevance. Measure up the work contractor and take such part thereof.
So we have moved on from the limitation argument. Now we are moving on to the risk and cost.
Yes. No, Miller, so far is the Miller, the limitation point that is over. That is over.
Now
Only I am on. So far is the counter claim is their concept.
Yes.
Yes. To measure up the work of the contractor and the take such part thereof as shall be unexecuted.
Yes.
Out of the hands and they give it to the other contractor to complete, in which case any expenses which may be incurred, kindly take a note of it, in excess. Just I am giving an illustration. Suppose the entire work is of rupees 100. The left out work is 3 items of work has not been executed, worth of rupees 10. For doing or executing the work of rupees 10, they have to incur rupees 14 due to the, my lord, consumption of the time and the expiry of the time. I have to pay then 14 minus 10, 4 in excess. In excess of the sum which would have to be paid in the original contractor. If the whole work has been executed by him of the amount of which the excess of the certificate in the writing of the executive engineer, authorized officer, final and the conclusive, shall be borne and the paid by the original contractor, may be deducted from any money due to him by the authority under the contract or otherwise from his security deposit and proceeds of the sale thereof and the sufficient part thereof. So in the instant case, there is no evidence on record which substantiate the fact that in the measurement book, there is any, my lord, any evidence that the X quantity of the work has not been executed, valued at rupees 10, 20, whatever might be. Rather, it appears from the measurement book, the subject project has been completed and final payment has been paid. Thereafter, forthcome running account bill has been paid. Normally, in the measurement book, in all contracts, all the, my lord, the running account bills are tentative. Even if it is seen that the excess payment has been done, in that event, in case of a final bill, adjustment would be there. Once the final bill has been paid, it would be presumed that the work has been subsequently done and, my lord, the work done and the payment has been made. So there is no evidence at all. So, my lord, kindly take trouble to have a look at claimant's work order at page 98 of the volume 1 of the respondent document.
Respondent means give the number. If
Oh, sorry, my lord. This is below 464. 464 of 2021, volume 1, page 98, my lord. I'm extremely sorry, my lord.
No, no. Right.
This is an work order.
Yes, that work.
I have shown to your lordship, my lord. Kindly see the name of the work. Construction of the road.
Yes.
Construction of the road from Holpukur to Tekhali Bridge via Ahmedabad High School at Nandigram Part 1, Part A. This is the, my lord, the road where the construction work is required. It appears from the nomenclature. Page, kindly have a look at 75 of the same volume. The BOQ, Bill of Quantities, what are the works which is required to be executed. This we can find place from the below notice inviting tender of my work, which has been assigned to me. Description of the item, below kindly got it. Description of the item, that is, my lord, serial number 1, 2, 3. I will not read out. 1, 2, 3, 4, 5, 6, 7, 8. Then, my lord, the total, the money value has been mentioned in the right hand side, and the total quantum estimated cost put to tender was 2,35,82,816. So these are the work I am obliged to execute. That has been mentioned in the BOQ. Kindly take, my lord, volume 2 of AP number 464 of 2021. Volume number 2 ta kothay? Kindly have a look at, my lord, page 263.
Yes.
The work which was given to other contractor, and, my lord, they have taken a point that the, my lord, remaining portion of the work was given to other contractor. It is not correct. It is evident from the document itself. I have completed the work according to the measurement book in the 2010. This, my lord, notice inviting tender was issued 2015-2016. The name and the nature of the work, kindly take a note of it.
This is the NIT for the balance work.
Yes.
Yes.
They are claiming that this is the balance work, but my contention is this is a new work. 2016, after 6 years. Repairing and resurfacing of the bituminous road. Not the construction. Resurfacing, repairing and the resurfacing of the bituminous road from Gholpukur to Ahmedabad High School. The complete nomenclature had to change, because prior to that, it was through Ahmedabad High School in a different location. This is a rectification work. According to me, this is a rectification.
This is a portion of the previous road.
Yes.
Because that was via Ahmedabad to Tekhali.
Yes.
Now this is up to Ahmedabad.
Yes. But the which point is required to be taken into consideration is repairing and resurfacing. That means laying bituminous layer for the purpose of the repairing. Due to natural wear and tear, my lord, after 6 years of the, my lord, the work which has been completed. Good, bad, indifferent, my lord, the work has been completed according to the measurement book of 10th of September 2010.
The balance was calculated on the basis of this. That
yes. Kindly bear for only one thing. Number 283. I have shown to your lordship the notice inviting tender of the new work This is, my lord, the work order at page 283 of the same volume. Repairing and the resurfacing of the bituminous road from the Gwalpur to Ahmedabad school. Then total work is 78 lakhs 90,364. Contract value was, since my lord, he has participated in the tender and quoted the rate less than the estimated cost put to tender, the contract amount was 78 lakhs 14,616. Then kindly have a look at, my lord, from our the total work we have executed in the 4 bills. This is 5. The estimated cost put to tender, you kindly have a look at page 737, volume 5 of AP 95.
Achha.
Paragraph 28, there is a tabular format where from it appears that first running account bill, second running account bill, and the calculated claimant by the respondent. The table has been mentioned. So far is, my lord, the security, so far is the computation of the security deposit is concerned. So in my statement of claim, I have sought for the security deposit 21 lakhs and something and odd figures. But here, the amount which has been calculated by the, my lord, the arbitrator on the basis of the calculation errors, that is 19,71,958. Therefore, to rectify this mistake, we have filed a section 34 application for the rectification of the said mistake. That is as simple, because all the, my lord, the running account bill 10% would be deducted, and the 10% would be the 10% along with the 2%, that is 4,71,000 I have shown to your lordship. That would be the total security deposit. Since there was a mistake, apparent mistake from the calculations of computation of the security deposit, therefore section 33.
That was only regarding the first and the second bills, running bills, because third and fourth apparently correct.
Yes.
Because deducted as per award and claimant is the same.
Yes.
So the first two, then there was an error.
Therefore, the section 33 application has been filed. So I am not on
the part of the section. The section 33 was considered here in this portion of the award.
No. Yes.
This is the part of that award.
No, this is the part of the award, but section 33 rectified award is, my lord, later on that has been given.
This is the original award where
the
mistake is being made.
Mistake is being made, my lord.
No, but here it is stated that in the said table at para 28, I'm sorry, page 737. Similarly, in the said table.
No, kindly bear for a moment.
Yes. It says in the said table at paragraph 35 of the award, this tribunal had calculated. So therefore, this must be the rectified.
This is the corrected.
Yes, it has to be, because it refers to the mistake in the original. Alleged mistake in the original. Yes.
So, my lord, my respectful submission is this. So far is the limitation, because I have concluded, so far is the, my lord, all these, the document which is required to be shown to your lordship, my lord, I have completed all those. So far is the limitation is concerned, the limitation does not lie. The finding arrived at by the learned arbitral tribunal is correct. The reasoning is wrong. The reason I have already, my lord, stated before the lordship and submitted before the lordship. So far is the, my lord, the awarding counterclaim is concerned, that is not at all feasible, because if I entitled to get security deposit, in that event, there would be a precondition that I have completed the work successfully. Otherwise, my security deposit would be forfeited. As per the clause 3A. Unless the subject project would be terminated, the work cannot be given to the other party for the executing the remaining portion of the work. So it is interdependent. So if I entitled to get security deposit, the question of giving or awarding counterclaim in the instant case does not arise.
So there are three components of your counterclaim argument. One is that to measure up and in excess, that was never calculated.
My lord.
One. Secondly, that it was a different work.
My lord.
So that could not have been a basis.
My lord.
And thirdly, your basic point that work was completed, there was no valid termination, so there could not have.
My lord.
Very well.
So this is my respectful submission, and therefore, my lord.
And regarding section 33, it's evidently mathematical, page 730.
No, so this is calculation, my lord. Since, my lord, this is not maintainable, I will not go into it. What is the
No, that correction was made. This was rectified in your favor.
Yes.
Oh, they are challenging that portion.
Yes.
Ask it.
So I will not go into all the mathematics what has been shown by your learned friend, because in my respectful submission, awarding counterclaim is of no relevance without jurisdiction, and contrary to, my lord, so far is the conditions of the contract.
No, this rectification was regarding the security deposit.
Rectification security deposit, he give an inference saying that if this calculation would be there, in that event, they would be entitled to get security deposit which is higher than my amount. So this calculation of supposition and proposition will not come, because I am against the, my lord, the awarding of the counterclaim, because counterclaim should not be allowed, and this is completely contrary to the clause 3C, because neither that has been measured up, there is no evidence at all, and the excess amount has not been figured out. This is a completely new work. After the 6 years, the new work has been commenced, that has been done. There is no relevance at all.
And you say your work was completed?
Yes, work was completed. It is evident. It is evident. It is not I am telling from the bar.
Running bill, the measurement book itself.
Yes. It is I am not telling from the bar. It is evident itself from the document itself, which is unimpeachable. It is not my document. It is the document of the respondent authorities. They cannot question the authenticity of their document. My lord, this is my respectful submission, and only, my lord. So initially, to allay any dispute, my lord, initially, I have submitted before your lordship, if your lordship would be pleased to set aside the award in its entirety, because since, my lord, I have already spent long time, so today my submission would not be there. My submission would be that, my lord, partial, my lord, the setting aside of the award, which is permissible, because this is not a modification. Modification of an award is not permissible, but this is permissible if it is severable. This is the case of
Yes.
Since this is a severable, my lord, there is no dispute at all. So I will not, my lord, the associate builders, NHI, all those decisions I will not place. Only, my lord, I will place one decision on risk and cost, but this is not also, my lord, convincing. But since I did not get anything, therefore it would be better to.
Better something than nothing.
No.
No, not always. Sometimes it's better nothing than something. That's if that something goes wrong.
No, it will not go wrong, my lord. Only paragraph 24. Paragraph 24. This is 2011 3 SCC 507. May I please?
1 minute.
Internal page 590.
Yes, please.
This is the factual aspect, but I have to read it, my lord. We may refer to the sum of the finding of the fact and the recorded by the designate, which were wholly unwarranted in the proceeding under section 11 of the Act, and the fallacy of the such finding the appellant and that did not stay anywhere in the petition of the date on which final bill was settled and that did not produce any document containing such information. The appellant was not expected or required to give such information in the petition under section 11 of the Act and produce the document and showing the settlement of the final bill along with the said petition. Therefore, the appellant and could not be found fault which for the such of the omission and in fact the designate notice and that the work was completed on the 29th of December 2007. The claim was in time with reference to the date and on which the work was completed.
So the section 11 scenario.
Yes, kindly take a note of it. Kindly see the relevant portion would be page 200 to 520. Only 2 paragraphs. Finding. Once a risk and cost tender is issued at the risk and the cost of the person, then the amount which is to be claimed from the person who is the guilty of breach becomes crystallized when the risk and purchase tender at the higher cost is awarded. So crystallization of the amount is required to be done, and which can be found from the measurement book itself. But here, my lord, there is no crystallization that whether there is any remaining work.
That was the finding of the court, impugned order. In the,
Yes.
The order impugned before the Supreme Court, that was the finding.
Yes,
But what
yes.
was the take on this of the Supreme Court on that? This may be
This may be true, the general proposition. This is only. Then subsequently, my lord, but it may not apply if there is a specific provision. In my
but
case, there is
becomes crystallized does not operate as a Supreme Court judgment. It's not a ratio.
No,
The Supreme
no,
Court
no,
is
yes,
quoting
correct,
the
my lord. Kindly see. This may be the true and general proposition.
So
Supreme
that
Court,
could-
yes.
yes.
It may be not apply if there is any specific provision in the contract like such and such. In my case, there is a specific provision like 3C, where measure up and excess has been mentioned. And the same Miller clause.
So therefore, it does not become crystallized then. As per the Supreme Court judgment, crystallized when risk purchase tender at a highest cost is awarded is the
Is crystallized, but
proposition.
unless contrary is there, contrary in the clause.
You say there is something contrary.
Yes.
So this may not apply as a proposition.
Yes.
So it does not become crystallized when risk purchase
No,
tender.
only, my lord, I intend to draw your lordship's attention, which has been mentioned in the italics, that has been supported by the Honorable Supreme Court. These may be the true, the general proposition. This is the basic proposition, my lord.
That is the basic proposition, but here the Supreme Court, on the basis of a like clause in your, as in your case, says that it is not always applicable if there is a special provision.
Oh, in my case, other provision is no, contrary provision is not there.
You say in your case there is a specific provision.
So like 7.0.9.0,
Yes.
this provision is saying in a different thing, but in my case,
But
quantification has been mentioned.
7.0.9 says which requires that the employer should claim as extra cost only the difference between the amounts which would be payable, which is exactly your case.
Yes. So extra cost is required to be paid, but the
So this exception applies in your case. So this cannot be a general proposition.
no, so far is the exception.
Supreme Court here says, quotes a finding of the impugned order, says there it was held, it becomes crystallized when the risk purchase tendered at a higher cost is awarded. This proposition may be true in general, but may not apply when quotes a clause. In your case also similar clause is there. So this general provision does not hold.
There is a departure in my clause. Kindly take clause once. Then that would be clarified.
What is the departure? Just tell us.
Measure up. Measure up the work.
No, the line of distinction is not that. The line of distinction is that if it says that the excess amount is to be paid.
What excess? How the
So
excess
apparently this proposition was that generally, yes, whenever risk purchase tender at a higher cost is awarded, yes, that is the cause of action. That is the crystallization. But if there is the excess is to be paid, then that measure up comes up and the other things come up, which is exactly your case.
Kindly have a look at me, only for cost of repetition.
Measure up and excess is there in your clause. You place that. I have also marked excess and measure up, I remember.
To measure up the work of the contractor.
Yes.
And take such part thereof as shall be unexecuted.
Yes, obviously.
So I will not give the difference amount. I would be only obliged to give the difference amount of the remaining portion of the work when I have failed to do the work. Suppose X quantity of the work, which has been X quantity of the work has been done by the Y.
That is the basic principle of risk purchase.
Yes. So, my lord, that has been mentioned over there. So, my lord, if it creates any confusion in that event, I will not place it.
No, what do gain by gain if it is crystallized on the date when the higher cost is awarded? How does this judgment help you if that is the proposition?
It is if
it is crystallized on that date when they pay the second contractor.
No. So far, my understanding, I may be mistaken. With an intent to, my lord, take sustenance out of that the proposition stated by the impugned order has been upheld by saying that this is the general proposition.
What is the general proposition?
General proposition is there remaining portion of the work. If remaining portion of the work is there, that is required to be measured up and quantified.
No, general proposition here is only once a risk and cost tender is issued at the risk and cost of a person, then the amount which is to be claimed from the person who is guilty of breach from you.
So I have to hold guilty.
Yes, here that proposition you have been guilty or not, that is not the proposition. The proposition in this judgment is only that once a risk and cost tender is issued at the risk of the person, then the amount to be claimed from the person, the guilty of the breach, becomes crystallized when the risk purchase tender as a higher cost is awarded. If there is a risk purchase clause, only when the risk
No,
purchase,
my lord, I
the
understood.
new
your lordship.
tender is awarded,
yes.
then only
Then the amount would
right
be
to claim
crystallized, but
crystallized.
that would not be applicable in my
This proportion is not German in your case. Yes, anyway. So that is.
So, my lord, with an intent to sum up, my lord. So, therefore, my lord, this awarding of the counterclaim is not at all maintainable. And therefore, I pray before your lordship, my lord, to set aside the, my lord, the award, that portion of the award where my counterclaim has been awarded. And if your lordship, my lord, allow me, in that event, I can give, my lord, 2 pages.
Do that. Do that so that something is kept on record. Yes. Yes, in reply.
May I consider this judgment and
No,
No. I've considered this is not applicable. What else? Thank you for being brief. Yes.
May I take trouble?
Yes, you can take trouble. Yes, but you also have to be brief to match his
yes, my lord.
succinctness. Yes.
My lord, so far as 3C is concerned,
Just reply. Don't replace your case.
Yes, my
Re-place your case. One is limitation,
my
first
lord,
point.
yes,
What
my
is
lord.
your answer to that?
My lord,
Yes.
he has shown that the last bill was paid on 18 May 2016.
Yes.
Now, my lord, the clause which I had shown at page 99, which says, my lord, the security money will be released to on properly maintenance of the road, including all its components for a period of 3 years from the date of completion. Now, my lord, I say because before the final bill, there were 3 bills paid. And my lord, the security deposit relates to the amount of bill, not the total contract value. The amount of bill which is being generated, from there 10%, my lord, that is deducted as the security deposit. Now, my lord,
So
so far,
it started from the first bill.
yes, my lord. First, second, third, 3 bills were paid, and also, my lord, 10% security deposit was deducted. So far as the final bill is concerned, my lord, that was paid sometime in May 2016. So, my lord, what my learned friend is saying, that because the final bill was paid in 2016, so, my lord, the cause of action will start, my lord, from that date. Now, my lord, what the learned arbitrator has held, that the date of termination is 1st March 2011, and the defect liability period is from 2011 to 2014, and from 2014 the limitation starts. And my lord, my case was that whatever the security deposit, so far as up to third bill is concerned, even if I leave aside the 4th bill, my lord, so far as security deposit with regard to third bill is concerned, my lord, that was payable within 3 years, because your lordship remembers there is a schedule of release which says completion of first year from the date of completion. My lord, it says from the date of completion. It's not about date of payment or whatever.
So you are relying on the same provisions, page 90.
Yes, my lord.
Which gives the breakup, and you say whenever the breakup comes in, that is the point of time when their cause of action ripens.
And my lord, the security deposit was deducted with regard to third bill, till third bill.
Yes. So first to third, they are time barred.
Yes, my lord. That
fourth bill at best they could claim.
Yes, my lord, at best.
Security deposit for fourth bill.
Yes, my lord.
All right.
And admittedly, my lord, all those arguments, my lord, whatever it is, it was paid in the year 2016, because he was not traceable. My lord, there is a letter which will show that the proprietor who is to conduct
That
the
is
job,
neither here nor there.
but he was not available. He has met with an accident. After 2011, he was not available. He was not traceable. We could not contact him. And in 2015, he had again approached us.
But he says that the work was completed as per your measurement book.
Yes, my lord, that I had argued, that I had told before. I had argued to your lordship, saying that it only says at the work which has been completed as on that date, because there are contemporaneous letters, my lord, where he also admits. I'll show one letter, my lord. Kindly take. Your lordship remembers the date 24th September, which is told as to be
Date of
24th
completion.
yes, my lord, 24th September 2010 is the
I
date.
don't remember actually I've written.
Now, my lord, your lordship will kindly take those pages 238 of my volume 2, AP 464, where those letters, my lord, I had placed.
Letter 280.
Well, these letters were contemporaneous and issued after that date, 24th September 2010, page 238.
Yes.
Where I have categorically said, my lord, that you are requested to start the work.
Yes.
And my lord, 238, 239, 240. There are 3 letters, my lord, contemporaneous after that date. Now, my lord,
Those
kindly
are your
comes.
letter.
Yes, my lord, kindly comes to page 241, which is 7th March 2011.
Yes.
It is their letter. Now, my lord, here, whatever may be the reason, my lord, he says, your lordship takes in the first paragraph also it says, my lord, I had to carry out execution of the work.
Reasons, excuses.
So far the work was completed. So far the work was completed by me. And also, my lord, the second last paragraph, under the above facts and circumstances, I am not in a position to execute any further work in the site. And my lord, volume 1 in 2015, my lord, there is a letter. Although he doesn't say that the work is not complete, but he says that I was met with a severe road accident and under medical treatment for a long time and unable to contact your office for final bill.
That is page?
Page 102. Letter of
same
4th May 2015.
Of the same.
My lord, my section 30.
Page 160?
Page 102, my lord,
102,
volume
sorry.
1.
Yes.
So, my lord, although he says he gives various reasons, but admittedly he also admits that he cannot work further. So that date of completion which is mentioned, my lord, that is only to the extent that the work completed as on that date. Because there are contemporaneous letters which have been exchanged between the parties.
So work completed up to this, for that we are paying this.
Yes, my lord.
What about the other two
Because,
that
my
we
lord,
have not measured? No, not.
Admittedly, your lordship will see
Yes.
it is their case that they have worked, they have raised bills for 1 crore 74 lakhs. Now the contract is valued at 1 crore 96.
But what about that? Even if we suppose that they have not completed the work,
Yes,
you have not measured the balance and all these are not proved. That is another contention.
My lord, so far as that, that is what I wanted to get ready on, only to the extent that because this was, I think, the first time they're making this argument.
They argue it's a factual premise and code 34, under 34, limited scope of looking
Yes,
into
my
that.
lord, whether they had argued this, that whether it was measured or not, that means I need to once. My lord, also that he has relied on the risk and cost clause, which is at page 581 of their volume 4. It says to measure up the work of the contractor and to take such part thereof as shall be unexecuted out of his hands and to give it to another contractor to complete, in which case any expenses which may be incurred in excess of the sum which would have been paid to the original contractor if the whole work had been executed by him. Now, my lord, here what happens, we had continuously were writing to him that you do the work or you repair this or that, and now he refuses to do that. Thereafter, my lord, he was not traceable for like four years, my lord. In 2015, he comes up and say that I have done whatever I had
These
to
on
do.
record.
Yes, my lord.
Not traceable and all.
Yes, my lord.
Arbitrator discussed in the award.
My lord, he has discussed about that one letter, my lord, which I have.
Non-traceability is not discussed.
Traceable means because I had taken that point, my lord,
Anyway.
in my defense. Because, my lord, if your lordship wants, I can show that. from
Regarding measurement not being done and this excess not being calculated, you say arbitrator gave reasons and we cannot look into that and
My lord,
arbitrate for the first
so
one.
far as that part is concerned, if your lordship sees in the contract also, it says that he has to maintain and repair for 3 years, the defect liability period. So what he says that it is repair and reservice.
Yes, that is another argument.
Yes, my lord.
Show us, show me that.
Kindly takes the volume 1 once.
Of yours.
Yes, my lord. Volume 1 of my section 34.
Yes.
Page 99, my lord. Maintenance period your lordship has. Page 99 bottom.
Yes, maintenance period.
The agency will have to maintain the road in good condition for a period of 3 years from the date of completion of the work. Now, he in 2015, my lord, he works till 2010. In 2015, he says, I met with an accident, so I was not available. So the 3 years period, admittedly, my lord, he was not there to maintain. Now, my lord, if your lordship has seen the risk and cost tender, it says repair and resurface.
Shows risk and cost. Where is that, please?
Tender কোন page জানো? 263. Volume 2, my lord, there, section 34.
Their section 34.
Sorry, my lord, it is my volume 2, page 263.
So that is the new work order.
Yes, my lord.
What is the clause in
The
your original?
scheme is repairing and resurfacing of bituminous road.
So you say this is within that maintenance.
Yes, my lord.
Yes. Very
But it's not that it has to be new work. It can also mean, my lord, that it was his duty to repair, which he has not done. So I had to repair it again. Now, my lord, kindly takes volume 6, my lord, of my section 34.
Yes.
My lord, there, your lordship has seen one BOQ. My lord, there are 2 BOQs. Now, my lord, kindly takes page 649 of volume 6, my lord. AP number 464.
Volume 6 does not contain that page.
My lord, volume 5, my lord, 601.
5 is.
Sorry, my lord, volume 5 then.
Yes, sorry, 464 volume 5. Yes, which page?
649.
Yes. This is the award.
Yes, my lord. My lord, clause E, my lord, has it. My lord, there were specific questions put to my witness with regard to the BOQ. Now, my lord, the learned arbitrator holds, now in answer to question number 104, 105, 106 relating to bill of quantity in respect of NIT, RW1 in cross admitted that in the said bill of quantity, the third contractor did additional work in respect of item number.
One is your witness.
Yes, madam.
So why admitted?
My witness was asked questions that
Yes.
what are these works about showing that BOQ. So he says that this is additional work.
Oh.
So it was argued that why do I be entitled to additional work? So my lord, he admits that contractor did additional works in respect of item number 2 and 13 to 22. Now, my lord, I have perused exhibit C19 and found that there is omission of any amount payable against item 17 and 22. So in my view, the total amounts of such additional work is calculated at rupees 11 lakh, which amount cannot be claimed from the first contractor. So my lord, the learned arbitrator
that had not been awarded.
Not been awarded. So my lord, the learned arbitrator takes into account that because my claim was like 73 crores, 73 lakhs, sorry, my lord, 73 lakhs. Now, my lord, admittedly, my lord, my witness had said that work of 11 lakhs was additional.
Yes.
So, my lord, that was reduced. That was deducted from my counterclaim. So, my lord, here, my lord, I would humbly submit, my lord, that the learned arbitrator is the master of facts, my lord. He has seen the evidence. He has seen that he has applied his considered the evidence, my lord, and then decided that 11 lakhs should be deducted and 61 lakhs should be awarded in my favor.
Any other point? Mathematical at section 33, you were challenging, but he showed that that's only
My lord,
mathematical.
what he is trying to argue that if my counterclaim goes, then that calculation.
That is one aspect. Yes, yes, that is his basic.
My lord, I say that if your lordship is not inclined to interfere, so far as with regard to the limitation point and also, my lord, to the regard to the counterclaim point, then, my lord, so far as this calculation is concerned, my lord, it is absolutely perverse in the face of it, because your lordship has seen there are two figures. Now, if the second figures is changed in the section 33, the third figure is the difference between the first and the second figure. So the third figure should automatically, by logical conclusion, it should change.
Alright.
Because, my lord, the third figure is not there in any evidence. The third figure was included in the award based on the difference between the first and the second figure. Second figure is the, my lord, the amount of work done, the bill raised. That was incorrectly.
Let's come to that page once.
Yes, my lord.
What is
Page,
it?
my lord, my volume, that same volume, my lord, page 647 of the award. Clause C, my lord, the first para. Lordship has it.
So not the same volume.
My lord, my AP 464.
464, yes.
Page 647.
$647 from the above figures. That
Yes, yes,
oh, that
yes,
very, yes.
My lord, will kindly see, it appears that though the contract value as per work order was for a total sum of rupees 1 crore 96, the claimant did the work according to the measurement book of the respondent amounting to rupees 1 crore 41. So, my lord, this was incorrect. The claimant filed an application under section 33 saying, look, I have not done for 1 crore 41, I have done for 1 crore 74. So, my lord, this third figure, which is 55 lakhs, is the difference between 1 crore 96 and 1 crore 41. Now, my lord, if the second figure is increased, which ultimately was allowed, my lord, by the learned arbitrator in the section 33. So, my lord, I said that then this 55 lakhs should also change.
It will become less.
Less, it will become less.
So you get more now.
Yes, my lord. So eventually what happens, I become entitled to an award.
So please put in your brief written notes about
I'll check that, my lord, whether that measurement point was at all taken, because
you've argued that that was not taken.
Yes,
so
my
put
lord.
that line.
Yes, my lord.
If you see that it was argued, then don't put that line in.
Yes, because, my lord, he had challenged that document. He had put questions to my witness saying that XYZ you have done additional work. He admits. Then he says that
Evidence
no,
is there, elaborate evidence is there that we have seen.
So, my lord, then the learned arbitrator said if you have done additional work, you are not entitled to. But for the others, the other side, the claimant does not put any question that now these are not payable or these are also additional works. There are no such questions.
No,
my
they
lord.
can argue from the evidence which is already on record also.
Yes.
On the basis of interpretation of the contract. I have to look into that. Well, oral arguments are concluded. Full-stop. Learned counsel for the parties shall file their written notes of arguments next Friday on December 6, 2024, when the matter shall be listed under the heading to be mentioned for such limited purpose. এটা to be mentioned থাকবে পর।
Well done, Gupta. Very well done. Very proud of you.
Mr. Taka, I'll take that break and then come back.
Please,
Right? It will be
please.
better.
Yes, yes, yes.
Let them collect first, then.
Then we'll decide the menu.
34 application, which your lordship had occasion to consider on a previous occasion quite extensively. Now, my lord, may I just recapitulate very briefly, my lord? A works contract was issued in favor of the award debtor for carrying out repairs of a vessel owned by the port. Disputes arose. The award debtor referred the matter to the Facilitation Council. In course of facilitation, we took a point that the MSME Council did not have jurisdiction on it because of it being a works contract. Admittedly, there's no dispute that it's a work contract. So that was turned down. We challenged that decision before this honorable court. During the pendency of that decision, the MSME Council proceeded to make an award. This is the long and short of the matter. So I have primarily 3 points, my lord. One which I will take only for the sake of taking, that is that this is a works contract and does not have jurisdiction, because by now I'm enlightened by your lordship's judgment that even a works contract falls within the scope of the MSME. But I will take that point, your lordship.
Definitely, yes.
Yes. So second issue is, my lord, it is 29A. The award is beyond the period stipulated under 29A. And under the MSME Act, once the matter proceeds to arbitration, all the provisions of the Arbitration Act come into play.
Yes.
Third is, my lord, it is liable to be set aside for denial of an opportunity to contest the proceedings. I had no opportunity to contest the proceedings, in fact, even till today, but that is not very relevant since a scanned copy of the award was sent to me. The original award has also not been handed over to me till date. The main hurdle which I need to cross, which I think is what my learned friends will argue very vociferously, is that the Section 34 application was filed without depositing 75%. That deposit was not there. The subsequent Section 36 was dismissed on the ground that the 34 by a coordinate bench of this court. The subsequent Section 36 was dismissed with the language that my 34 is stillborn. So I understand that this is the first argument which they will advance. So may I trouble your lordship first with the decision in the Section 36 application and why it should not come in my way in your lordship hearing the 34 finally. Subsequently, I have deposited the amount. After the 36 came to be dismissed, I wrote to them. Because the award is again the typical, if I may use the word, typical MSME Facilitation Council West Bengal award, that it does not quantify the interest. It leaves the matter of interest quantification to the chartered accountant of the claimant, which is another ground, my lord, which itself is bad. You could not have delegated your decision-making authority A on the rate of interest, B on the quantum of interest. So that is another argument on, my lord, on the at least a part of the award being ex facie bad. So, my lord, after the 36 dismissal, we wrote to the claimant that please let us know what, according to you, what is the amount of the award. The claimant informed us immediately the monies were deposited. When the monies were sought to be deposited, they raised objections that this cannot be done now. This should have been done at
75%.
That 75% cannot be done now. It should have been done at the time of filing the 34. That objection was kept open to be decided at the time of consideration of the 34. Your lordship will now kindly have the order dated, judgment dated 31st July 2023, by which my Section 36 came to be dismissed.
Yes.
That is perhaps separately handed over to your lordship.
Yes, it has.
Your lordship has
Yes.
a bunch of documents, my lord. Kindly have the issue which was before the Honorable Court at that stage, my lord, was summarized at page 3, my lord, whether compliance of Section 19 of the paragraph 6 at the bottom of page 3, my lord. Whether compliance of Section 19 of the MSMED Act is mandatory for seeking stay of an award. Whether filing of an application under Section 34 of the 96 Act without the pre-deposit under Section 19 of the MSMED Act makes the application for seeking stay of the award under Section 36(2) of the 1996 Act imperfect in the eyes of law. These are the only two issues. Why I trouble your lordship with this is, the issue is not on the validity of the 34.
Imperfect and eclipsed.
Imperfect.
Eclipsed is in the last paragraph.
Imperfect in the eye of law.
And page 11, para 30, eclipsed. So if there's an eclipse, after the eclipse is over,
Yes.
it may be open again.
Yes. And my lord, the Honorable Court was only considered with the validity of the section 36, not with the validity of the 34. Her ladyship was not called upon to adjudicate whether my 34 was valid or defectively
It
filed.
was an issue. Issue B was formulated.
Issue?
In the issue B, because
Yes.
the issues for adjudication, one of the issues was imperfect in the eye of law.
Yes,
So
my lord,
that
but
was an issue.
the application on the 36(2) is imperfect, not the application on the 34. Kindly see, my lord.
The issue is whether filing of an application under section, yes.
Makes the
Yes,
application for seeking stay under 36(2) imperfect.
All right.
So
Right.
not on the validity or the maintainability of the 34 application without the pre-deposit.
All right.
That was the only issue.
Hmm.
That was not the issue. Only issue was whether the 36(2) can be entertained when the 75% deposit has not been made. These were the issues. So validity of 34 has not been decided here. This was not an issue. It could not have been decided. It
Could not have been also maybe.
could not have been
That's,
decided because the application wasn't there. Now, my lord kindly sees
So this is not binding on the 34 court.
it is not binding. And there are judgments of our court and the Supreme Court and the Delhi High Court, which have conclusively held, taking into consideration the language of section 18 of the MSMED Act, which prescribes the pre-deposit, that the bar comes in only at the stage of entertaining the 34. And the distinction is drawn between entertaining and filing. Entertaining has now been held, my lord, in the context of other acts, which are the earlier judgments which have been used to interpret the section 18 of the MSME Act. Entertain means when the Honorable Court applies its mind to the matter, takes up the matter for hearing, which is a stage subsequent to filing. So the 34 cannot be taken up for consideration without the deposit being there. That is, my lord, now the division bench judgment of our court. So this decision, my lord, is relevant only for the decision on these two issues. There are some paragraphs here, my lord, which I'll just draw your lordship's attention to.
Yes.
Which they will rely on, perhaps. Kindly come to paragraph 19 onwards at page 8.
Right.
I'm sorry, kindly see the decision on issue 1 at paragraph 12, please, my lord, page 5.
Yes.
The above leads to the unerring conclusion that a buyer...
This is page?
Paragraph 12 at page 5 is the decision on issue 1.
What?
Issue A, sorry, my lord.
A.
Whether compliance is mandatory for...
Right.
The above leads to the unerring conclusion that a buyer must first deposit 75% of the awarded amount as a one-time deposit or in installments before inviting a court to entertain an application for setting aside of the award made by the facilitation. So here the court also uses the word entertain. Now, my lord, kindly sees
the language used in section 18 is
entertain.
Entertain.
And this is discussed now, my lord, when your lordship kindly turns to the file versus entertain dichotomy relevant at paragraph 19 at page 8. The file versus entertain dichotomy relevant to the present discussion. On a conjoint reading of section 19 of the Act and section 36(2) of the Act of 96, there appears to be a dissonance in the words entertain in section 19 and file in section 36(2). The conflict, however, must be resolved in favor of section 19. That is, the section 34 application must be entertainable for maintaining a section 36(2) application in view of the overriding effect of section 19 as provided under section 24 of the MSME Act. So here, her ladyship is also considering the entertaining or maintainability of the 36(2) application, not the 34 application. The 36(2) application cannot be heard. It's like a building which doesn't have a foundation. The plinth must be there to have the superstructure, or there must be a plaint to entertain a petition. That is the kind of scenario her ladyship is considering here. Then, my lord, kindly come to paragraph 24, where the reasons are given. The filing of a section 34, and filing is in apostrophe, my lord. The filing of a section 34 application for the purpose of stay of an award under section 36(2) cannot be construed to imply the mere ministerial act of filing an application for setting aside of an award under 34 of the Act. This is by reason of the statutory window within which an award has to be filed under section 34(3) of the Act. Now, this is another argument which they might advance, that the money deposit is beyond the 3 months plus 30 days. Section 34(3) requires an application for setting aside to be made within 3 months from the date on which the party receives the arbitral award, with a proviso for the court assessing the sufficiency of the cause shown by the applicant for making the application within an additional period of 30 days. The word entertain comes within the wording of the proviso. For easy reference, section 34(3) along with proviso is satisfied. Now, your lordship will find the word entertain is only in the proviso. Provided that the court is satisfied the applicant was prevented by sufficient cause from making that application within 3 months, it may entertain the application within a further period of 30 days, but not thereafter.
But the original section says made, may not be made.
May not be made. But here, her ladyship does not. If your lordship now takes further, my lord, the court indicates, the above indicates that the court can entertain an application for setting aside of an award only if the application is filed within the time provided under section 34(3) or on the extended time frame under the proviso, on the court being satisfied of the sufficiency of the cause shown. The court is thus statutorily barred from entertaining the application if an application is filed after 3 months without leave being taken for the additional 30 days or the final window of 3 months and 30 days. Further, the only possible construction of the word of filing, of the filing of a section 34 application for the purpose of stay of an award under section 36(2) would be an effective and valid section 34 application which has been filed within the limitation period under section 34(3). Naturally, therefore, an application filed under section 34 after 120 days or contrary to the requirement of section 34(3) would cease to be an application at all under section 34 for fulfilling the necessary condition precedent for section 36(2), namely for the court to consider, entertain or consider grant or stay of the award. To draw an analogy, prerequisite of a valid section 34 for considering stay under is akin to a suit instituted in the original side remaining unentertainable until the plaint is presented and upon leave being granted by the court and scrutiny. Without that, merely remains.
I suppose this made in section 34 is not so germane as entertain in section 18 itself.
Yes.
Because we have to look at section 18
9,
to
the bar,
ascertain.
yes, the bar
The
there,
bar.
yes, because the bar comes from the MSME Act, not from the Arbitration Act.
Yes, yes.
It is a condition imposed by the other act.
Right.
So the condition there has to be tested, my lord, not the.
Absolutely.
Not
Agree
the,
with you on that subject to hearing.
yes, my lord. Then, no, my lord, this I'm just talking from the decisions.
So obviously, it has to be because the bar arises from that.
Yes.
If the bar is there in the first place, then this question comes.
Then this question
making
comes.
a note.
That
Very
the what is the bar is what is to be decided.
Section 34, I think should be looked into after section 18.
Yes.
Interpreting that entertain. Very good.
Now, the conclusion doubtless is, as a general proposition, the section 34 embedded in an application for stay of the award must be a valid section 34 application.
Mr. Thakkar, you made the section 34 application within time.
I made it within time.
But
my time has not even started because I have not even been served the original. The Act requires service of original on the party. I have merely received a scanned copy by email, that too about a year after the award was made. After filing the 34. The conclusion specific to this case, the application under section 34 must be a valid application in terms of, now this is where perhaps they will lay stress on, my lord, must be a valid application in terms of section 19 of the Act for the court to consider stay of the award under section 36.
But this does not exactly go against you in the
doesn't.
section 34.
Yes, my lord, because it says for the court to consider stay of the award.
Yes. For 36(2), yes.
Yeah, for 36(2), yes, but not for 34. So there is no difficulty here also, my lord.
In preemption also, preemption cases, there is a line of judgment.
10%.
It's made good.
Yeah.
I mean, no
order.
Cannot be proceeded with.
No, cannot be proceeded. No order can be
No
made.
injunction can be passed.
Yes. 10% deposit.
Yes, is that.
Yes, my lord. So conclusion, since then, and your lordship sees, since the petitioner has admittedly not made the pre-deposit under 19, the section 34 application filed by the petitioner remains eclipsed in the eye of law as the foundation for a prayer for stay of the arbitral award under 36(2) of the Act. Therefore, the present application for stay of the impugned award filed under 36(2) cannot be entertained, as the said application is foisted on a stillborn section 34 application. This is again something which perhaps they will rely on. The petitioner,
but the next sentence
petitioner must first comply with section 19.
So you have breathed life.
to breathe life into the application.
You have now breathed life.
I have now. My
You're
30
putting the money.
Yes, I
money
put
is life.
money is the
Very good.
AP so-and-so is accordingly dismissed. AP 179, your lordship will kindly see. AP 179, which is for setting aside of the award, is accordingly detagged. The petitioner shall take appropriate steps therein. Yes. Similar, this judgment cannot come in one way, possibly, in spite of the, in spite of, my lord, stillborn and other such terms being used. This is not a defective application, to say the least. Now, my lord, then kindly consider the MSME Act, please.
Yes. Give a copy.
I
MSME copy nahi.
My lord, I have.
Adhik jinish nahi.
May I have?
Yes. Thank you. Regular bench সব ছিল এখানে।
Kindly have section 19, please, my lord.
19.
No application for setting aside any decree, award, or other order made either by the council itself or by any institution or center providing alternate dispute resolution services to which a reference is made by the council shall be entertained by any court unless the appellant, not being a supplier, has deposited with it 75% of the amount in terms of the decree or award, or as the case may be, the other order in the manner directed by such court. Provided that pending disposal of the application to set aside the decree, award, etc., the court shall order that such percentage of the amount deposited shall be paid to the supplier. This we are not concerned with. And the overriding effect your lordship will find is in section 24. The provisions of section 15 to 23 shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being enforced.
Right.
So, my lord, 34, filed for setting aside the award, shall not be entertained by any court unless 75% has been deposited.
Yes.
This entertained, my lord, has come up for consideration. I'll not trouble your lordship with the other judgments. There's a judgment of our court, my lord, division bench, considering this very act. Compilation? I have a compilation, my lord.
Yes, better than hand that up and
Please, my lord. Serial number, compilation. Development. Yes, my lord, the first judgment in that compilation, my lord, Development Consultants Private Limited versus Rama Engineering.
Right.
This kindly see paragraph 1. This is the very issue which came up for consideration before the Honorable Division Bench. This appeal is against the judgment and order dated so and so, whereby the application filed by the appellant under 34 of the Act of 96 for setting aside of an arbitral award has been dismissed on the ground of non-compliance with section 19 of the Act, hereinafter referred to as the Act. This is the very same issue, my lord. Then paragraph 2, 3, 4, my lord, all the provisions of the Act are noticed. 6. Now, my lord, kindly come to paragraph 12. The learned single bench very rightly observed that the rules of the council could not have overridden the mandate under section 31(5) of the Act that obliges an arbitral tribunal to deliver a copy of the arbitral award to a party there.
This is on your other point.
This is on my other point. Under section 34(3) of the Act, an application for setting aside, this is where the division bench concurs with the judgment of the learned single judge, could not have overridden the mandate under 31(5) of the Act that obliges an arbitral tribunal to deliver a copy of the arbitral award to a party thereto. Under section 34(3) of the Act, an application for setting aside may not be made after 3 months elapsed from the date on which the party making that application has received the arbitral award, or if a request has been made under 33 from the date since. The provision to subsection 3 enables the court to entertain an application. It is well settled. The limitation starts running from the date on which the applicant applying for setting aside of an award receives a copy of the arbitral award from the tribunal in terms of 31(5) of the Act. The learned single bench did not, however, deem it necessary to go into the question of whether the application was at all barred by limitation, since the single bench found that section 19 of the Act of 2006 requires the applicant applying for setting aside of an award to make a deposit. The learned court found that such deposit had not yet been made. Till such time the deposit made, the petition could not be accepted to arrest the clock of limitation. A petition would be regarded to have been belatedly filed if statutory precondition thereto was not complied with. The learned single bench dismissed the application under 34 of the Act as not maintainable, since it was the admitted position that no deposit in terms of Section 19 had been made till then. Section 19 of the 2006 Act prohibits the court from entertaining an application for setting aside of the award unless the applicant has deposited with it 75% of the...
22 crystallizes.
Yes, 22 is Malad
22 is,
crystallized. Yes.
yeah.
And it considers the... It considers, Malad,
The other judgments
Lakshmi
also,
Ratan.
Yes, yes.
Lakshmi Ratan is there in my compilation, Malad.
Nehadeep and Lakshmi Ratan considered,
Yes.
saying they are on different points.
Yes. Lakshmi Ratan is on the point, Malad, of what is the 37, it is serial 5 in my compilation, Malad, 37 to 45. Lakshmi Ratan, Malad, defines as to what entertain means.
All right.
In the context of an appeal from the Sales Tax Act, under the Sales Tax Act.
Right.
Furthermore, the judgment in Lakshmi Ratan has been rendered by a larger bench of the Supreme Court of 3 judges. Nehadeep is on earlier decisions. The expression entertains as the stage at which an application is first taken up for consideration cannot, in our view, be receive or file. The judgment and order under appeal cannot be sustained. Same is set aside. The appellant shall, however, deposit 75% of the...
I've seen, we can move on to the next.
Yes.
Yeah.
So, Malad, this is to deal with the entertain argument.
Yes.
Now, Malad, and your lordship will kindly serials 1, 5 and 6 are on this point, Malad. 1, 5 and 6 and 7 on the entertain point. Now, Malad, coming to the merits of the matter.
And one additionally contains the other point, certified copy of the
certified copy.
The award has.
Yes, the award has to be made. Yes.
Yes.
Now, if your lordship has the on the merits, my lord. Kindly take, my lord, page 59, please, my lord, of my application. The invocation.
59, yes.
This starts at, my lord, page 53 is the letter.
Right.
16 January 2015. Kindly come to page 59, please, my lord. Paragraph 18.
Yes.
You are therefore requested to convene a meeting at the earliest or within the time as prescribed under clause 18.2 of the general conditions of contract in respect of the aforesaid grievance of Marine Craft Engineers Private Limited, in order to provide us with an opportunity to agitate our grievance before you and also to produce relevant documents in support of our claim. Well, the general conditions of contract provides an arbitration clause, but provides a mechanism by which the clause is to be invoked. So he calls upon me, Malad, to convene a meeting, which is the kind of conciliation meeting, before the dispute can be agitated to the next level, which is the arbitration. Now, Malad, kindly see 18.2, please, Malad, which he refers to. Kindly have page 96. General conditions of contract starts at 93. The relevant clause 18.2, which he refers to in his letter, is to be found at page 96.
Yes, nice.
Interpretation of contract documents, dispute and arbitration. In all disputes, matters, claims, demands or questions arising out of or connected with the interpretation of the contract so-and-so, and whether abandonment or breach, the decision of the engineer, your lordship will find at 18.1, the decision of the engineer shall be final and binding on all parties to the contract and shall forthwith be given effect to by the contractor. If the contractor is dissatisfied with any such decision of the engineer, he shall within 15 days after receiving notice of such decision require that the matter shall be referred to the chairman, who shall thereupon consider and give a decision. If, however, the contractor be still dissatisfied with the decision of the chairman, he shall within 15 days after receiving notice of such decision require that within 60 days from his written notice, the chairman shall refer the matter to an arbitrator of the panel of arbitrators to be maintained by the trustees for the purpose, and any such reference shall be deemed to be a submission to arbitration within the meaning of the Arbitration Act of 96 or any statutory modification thereof. So this is what he invokes, my lord, by his letter. He seeks a meeting. as prescribed under 18.2. That is reference to the chairman.
Or with a copy to the chairman also.
With a copy to the chairman also.
All right.
No further steps were taken in this. Now on 8 December 2017, he files a claim before the council, which your lordship will find at page 62.
There was no section 11 in this case.
There was no section 11. But since he is registered under the MSME, he opted to go to the council for the conciliation and not go by the contractual arbitration clause. That was permissible, perhaps.
Yes, yes.
Now, my lord, kindly see. So he files the claim before the council, which starts at page 62. He files this claim on 8 December 2017. Kindly permit me, my lord, to draw your lordship's attention to some paragraphs of the statement of claim only on my argument that this is a works contract. Paragraph 6, my lord may only make a note of, my lord, paragraph 6, 8, 9, and 12. These would show that incontrovertibly the contract in question was a works contract. And apropos this, my lord, the contract document is at page 91, starts the relevant clause of the contract document at page 91, scope of work, clause 12. These clauses would show that it is a work contract. This issue has gone up from our court, my lord, to the Supreme Court. That appeal is there, my lord, it's pending. On whether a works contract can be the entity.
Still pending.
It's still pending, my lord. But as of now, my lord, we are bound by your lordship's judgment, so I'm not troubling your lordship, but kindly make a note only of the clauses. Now, my lord,
yes.
Page 301, 24th April 2018. 301 is in volume 3, my lord. I filed an application for the matter to be referred. Kindly see my application, please, my lord.
Yes.
Prayers are at 310. Because the statement of claim was filed straight away, I said the matter has to be first referred to conciliation by the Facilitation Council, and a reference cannot start without, my lord, proceeding under 18.2, please, my lord. Kindly see 310. This was my application. An order be passed by the council directing that the reference to arbitration in terms of section 18.3 of the Act be set aside and conciliation be recommenced in terms of section 18.2 of the Act.
Were recommenced?
Because, my lord, it should have been commenced.
You had referred to the chairman, probably, or that was also in your...
That was in my mind, my lord, at that stage nothing happened. But they came straight away with, my lord, a reference to the...
Yes, so you want a conciliation
process. I wanted a conciliation
18,
process.
Section 18, yes.
18.2, if your lordship will see.
Right.
It's
mandates a conciliation.
It's mandatory.
Yes, yes. So this was done.
This was not done. Conciliation, yes. Now conciliation commenced. Now, during the pendency of the conciliation, now your lordship kindly sees the next date which is relevant. I filed, my lord, page 314, I also filed my statement of defense.
Yes.
Kindly see.
Okay.
313 starts at 314. I filed my statement of defense and counterclaim.
Right.
Now, my lord, after all this filing is done, now the council tells us that now you try and reconcile the matter and starts conciliation proceedings. This, in my respectful submission, was putting the cart before the horse. A statement of claim could not have been filed before exhausting the conciliation. Kindly see the minutes of at page 404, please, my lord.
You participated by filing your statement of defense and counterclaim.
My lord, this filing of this, my lord, filing of my statement of defense and counterclaim in the arbitration case, my lord, would not override the mandatory provision of the Act to first attempt conciliation.
Counterclaim was in the nature of a claim.
Counterclaim was in the nature of a claim. Yes.
All right. So it's a statutory requirement.
It is statutory. The council cannot proceed in the parties can do whatever they want, but the council is supposed to proceed in accordance with the terms.
Inherent lack of jurisdiction in a sense, 18.2, unless that is complied.
Yeah, unless 18.2 was complied with. Now, my lord, 18.2 compliance starts now, my lord. After all this pleading is done, kindly see page 404 once, please, now. Yes.
এখানে এটি।
The written statement was, of course, filed without prejudice, my lord, to the maintainability of the proceedings. 404 in the same volume, please, my lord.
Right. So this is a regularization of the.
Yes. Now this comes a regularization.
Hmm.
After thorough discussion, it was decided that as prayed by the buyer unit, counsel asked both the parties to sit together and try to amicably settle the matter. Buyer unit was asked to make positive effort for amicable settlement within 21 days. Supplier unit was asked to submit the outcome of the reconciliation meeting between the parties. Matter shall now be taken up for hearing on 17 July 2018. Now, my lord, I made an offer to make payment of about 26 lakhs. This is to be in full and final settlement, which your lordship will find at the next page.
But ultimately it failed.
It failed. That offer was not accepted. It fails.
Yes.
Now, my lord, kindly see page 407, please.
Yes.
In this contest, advocate for the buyer, the last sentence of that first paragraph. In this contest, advocate for the buyer unit claimed that he was not ready to contest the matter and only came up with settlement proposal and prayed for time to contest the matter with proper documentary evidence. Decision of the council. The council opined that amicable settlement proposal offered by the buyer side was failed owing to non-acceptance by the supplier unit. Council allowed the prayer of the buyer unit and decided to take up the matter for final arbitration hearing, providing natural justice to both the parties. So now we proceed to arbitration after this. Now, my lord, kindly sees. This was kindly see the date, my lord. This is 26th April 2019.
No. This order is
24th September 2019. Sorry, 24th September 2019. Yes. Now, my lord, kindly see the next, which is now the next minutes is at page 49 of the petition, and this is very important. My lord, kindly come back to the first volume of the petition. Page 49, please. Proceedings of the meeting held on 12th May 21. In between COVID intervened, my lord, after 19, now comes 12th May 21, which is the next meeting. Mr. So-and-so's appears, my lord. At the outset, learned advocate of the buyer unit explained the council is governed by the special act and there was an arbitration clause in the contract. Arbitration is alternative remedy signed by both parties. So, my lord, my contention there was that the contractual clause will prevail. The parties should be relegated to arbitration in terms of the contractual clause.
Turned down said MSME Act prevails.
Yes.
And all.
Now this is turned down. Kindly see page 51.
51. Overriding effect and all.
Yes. So council, learned advocate raised the issue. So council overruled the jurisdiction of point of jurisdiction raised by the learned advocate for the buyer unit. So it is decided that council does have the jurisdiction to adjudicate the instant matter. Thereafter, member of the council opined that buyer unit did not release security deposit and rupees 16 lakhs approximately is due for deduction. So now adjudication procedure should be focused only on merit. Thereafter, it was unanimously decided that the matter would be taken up on the next hearing to adjudicate the point only on merits. Only on merits. Now, my lord, so this is on 12th May 21. The matter proceeds for discussion on merits. Now, after 12th May 21, my lord, I filed an application under section 34 challenging this. Challenging this, treating it as an interim award on the issue of jurisdiction, which my lord did not meet with much success, which your lordship will find at page 409. I informed the council, my lord, that this application has been filed on 8th October 21, my lord. I informed the council this was 12th May, and then on 8th October, I informed the council that I have filed this application and I request you, your lordship will kindly come to. The sitting was fixed on 27th October 21 at 3:10 p.m. I received the notice for online arbitration hearing dated 8th October 21, at 3:38 p.m., wherefrom it appears that the hearing of the above arbitration has been fixed on 27th October 21. So after 12th May, my lord, the argument on merits was to be held on 27th October 21. Immediately on receiving the notice, I informed them that I have filed this application for setting aside of that jurisdiction award. Now, my lord, kindly see. 411 is the order of 10th November 21 for fixing the matter on 16th November 21. The question of maintainability is left open. On 27th October 21, my lord, which was the date fixed for hearing the matter on merits, no hearing took place before the Facilitation Council. They did not hold a meeting, my lord. I don't have any minutes of this, but I have stated this on oath in paragraph 31 at page 14. The petitioner states that no hearing, at page 14, petitioner states that no hearing took place on the scheduled date fixed on 27th October. However, the next date was fixed before the council on 18th of November. 18th of November also, my lord, no hearing took place. As the chairman was in some other official work, this I have stated in paragraph 33. And I prayed for an adjournment which was fixed. Now the matter was further fixed for hearing on 7 December 2021. 7 December 2021 also, my lord, the hearing did not take place before the council, but the matter was heard at length on 7 December 2021 and 7 December and 16 December, and it was fixed for filing written notes on 4th of January 2022. This is stated in paragraph 34, please, my lord.
Yes.
Thereafter, application on the 34 was heard at length on such and such dates before the learned single judge. After hearing, speaks to fix the matter on 4th January for the limited purpose of filing the notes on submissions. Judgment in the matter was reserved. Now, my lord, I received a notice on 14th April 22 again, informing me that the hearing would take place on 28th April 22 at 4:10 p.m. This annexure is page 409.
Why surprisingly? You are surprised. You are entitled to being surprised.
I was perhaps hoping that they would stay their hands till the outcome of the 34,
Yes,
my lord.
wait.
So,
Right.
so this I received, my lord, or at fixing the date on 28th April 2022. This notice is to be found at page 409. I'm not troubling your lordship with this notice, my lord. 409. I'm sorry. No, this is 8th April, 14th February. No, this is not 409. I'm sorry, my lord. I'll give your lordship the number, but this is not so relevant.
Need not.
Yes. Now, my lord, again, I prayed for an adjournment, which your lordship will find immediately on receipt of the notice. Learned advocate prayed for an adjournment by his letter in view of the understanding between the parties. Council, the hearing was been concluded. Judgment had been kept reserved. 27th April 2022. My lord, I'm troubling your lordship from this because there's no opposition to this. These are more or less admitted positions.
You are seeking the adjournments because of the
pendency of the matter before the court on the, my lord, which clause will prevail, the contractual clause of arbitration or the statutory clause. This letter of mine is at page 608, my lord, 27th April 2022 letter. Now, in what now turns is, in spite of receipt of the said application for adjournment dated 27th April 2022, the council observed that hearing in the matter is concluded. This is where, my lord, the twist in the tail comes. And the council shall pass an award in due course. It may be noted that none of the parties made any submission as to the merits of the case, although in the order dated 12th May 21, the council recorded that the adjudication procedure should be focused only on merit and the matter would be taken up for hearing next or to points only on merit, but on 27th April. So the next date of hearing was, your lordship has seen that minutes. Now they say we are going to make the award, enough is enough. The petitioner states, also submitted a further letter dated 29th April with a prayer to fix a date of hearing of the arbitration on the point of merit without prejudice to his rights and contentions in the pending application. This letter is at page 610. Kindly now take this letter, please, my lord. खत्म करना है अरे फिर next Friday क्या होगा पता है 610 page is my letter of 29th April 2022. Kindly see the third paragraph at this page. 1 and 2 are reiterating the facts which were of the pendency of the 34 application. In the meantime, the buyer unit received the notice for online arbitration by email dated 14th April, wherefrom it appears that the hearing had been fixed on 28th April. Accordingly, by letter dated 27th April, I, on behalf of my client, prayed for an adjournment for the hearing fixed on 28th. Above arbitration was taken up for hearing on 28th when we prayed for an adjournment as the judgment had not been delivered by the High Court. Our prayer for adjournment was refused, and it was observed by the learned counsel that hearing is concluded and the counsel shall pass an award. Immediately thereafter, I mentioned the matter upon notice to the learned advocate for the supplier unit on 29th and before the Honorable Judge in presence of so-and-so advocates, and prayed for appropriate order so as to give an opportunity to the buyer unit to make submission as to the merits of the case, as we were not allowed to make such submission on 29th April. However, the advocates for the supplier unit has verbally consented to submission on merit by the parties before the council in terms of the order dated 12th May 20. In view of the above, I, on behalf of my client, the respondent, request you to fix a date for hearing on the above arbitration so that the buyer unit may be allowed to make submission on merits in terms of the order dated 12th May 21, passed by the council without prejudice to the rights and contentions in the pending Section 34. Please allow us to make submission and fix a next date for hearing. Otherwise, my client will suffer irreparable loss, prejudice, and injury. Now, Malad, this letter addressed to the council was copied to the learned advocates of the claimants. No response. Facts stated here, my lord, are not controverted. This was a fact position. Then, my lord, comes the order of 17th May 2022, page 612, by which my jurisdictional challenge failed. Primarily on the ground that this was not an award. That was the operative portion, my lord, that this is not an award and cannot be challenged under 34. Quite rightly so, my lord, it would have to wait till the final award was made. Challenge on jurisdiction failing. The operative
to be a section 16 scenario, basically.
Yes. Contemplating that this is a section 16, therefore you have to wait till your till the final award has been made. Then, my lord, kindly come to now, after all this is done, 16th February 2023, all of a sudden I receive at page 628. With reference to the above, you are well aware that the instant matter was duly heard on several occasions. And finally, an arbitral award was made in favor of so-and-so. In this connection, the certified copy of the arbitral award had been duly sent to the address of the buyer unit through speed post. Vide this office memo dated, kindly make a note of the date, my lord, 17th November 2022 is the first date of sending. Second date of sending is 9 December 2022. Third date of sending is 29 December 2022. But all the letters were returned with the postal remarks not known. Port Trust Building, address not known.
Happens. We are saying in court also.
And they have sent email to every time to every time.
Anyway, my lord, now the certified copy of the award is being now the certified copy of the arbitral award is being sent herewith for your information.
Thakkar, you're frankly speaking, you're not being heard, not being given opportunity of heard. Argument is not so impressive because you are behaving like an ostrich. You file an appeal that does not automatically operate as stay. You know that very well. And you seek time after time after time.
I follow that, my lord, but there has to be a minutes which records the arguments of my learned friend. He also had to be heard. 12th May 21 says, now this is the issue which has to be, the issue is crystallized at the hearing.
But a date was fixed for filing of written notes also.
No, 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 for filing of it.
Came up some.
No, that is the written notes by the learned our court, my lord, under the 34. That was written notes by our court under 34. So there, my lord, on 12th May 21, when they rejected my challenge to jurisdiction, said now the hearing will proceed on merits, but the merit hearing never took place, neither for them nor for me. And the council proceeded to make this award. Now, if your lordship kindly sees this award. Kindly see the date of the award at page 30, please, my lord. First volume. Award on 28th April 2022. And kindly see the date when it was first sent to me. The last letter at page 609, which I showed your lordship, my lord. The 3 attempts made and all found undelivered. Starts at
17th November is the first admitted date.
First date. So 28th April and the award is communicated on 17th, attempted to be communicated for the first time on 17th and admittedly not served.
Yes.
Now, the facts, I'm not troubling your lordship with the award where the facts are noticed. Kindly come to just two paragraphs on a page, paragraph 9 on the first page, then paragraph 12 on the second page of the award, 31. These are all works contract, just to show your lordship that this was a works contract.
Yes, yes.
9, 12, 15, these all refer to works contract. Now, my lord, kindly come to page 32, please, my lord. Minutes of hearing of conciliation. 16th February 2016 is the minutes of hearing of conciliation. Mr. So-and-so advocate representing the supply unit, none appeared for the buyer due to high levels, etc. Then 16 November, none appeared again for buyer, they say. Decision of the council revealed as a buyer unit did not appear in the two
These are
successive.
procedural mostly.
These are procedural.
Procedure
Now
followed.
kindly come to the arbitration process,
Yes.
which starts at 33.
Right.
As per letter dated so-and-so, 4th December 2017, both parties were informed of the termination of conciliation, initiation of arbitration, and asked to submit statement of facts. Buyer's unit submitted the statement of fact. I'm not troubling your lordship with, my lord. Kindly come to the next page. Then the statement of defense is noticed, my lord. Page 35, your lordship, if your lordship sees the narration of the statement of facts, all of this would go to show that it's a works contract. 35, my defense is considered. Then the arguments are noticed. These are all arguments, my lord. Now kindly see the decision on the claims. Total claim is noticed, my lord, at page 37. Now, buyer unit denied and disputed. All these denial disputes are there. Regarding letter, requested chairman to look into the matter. Additional work was not approved by the competent. Now comes the decisions, my lord. The work contract ঠিক আছে, ছেড়ে দিন না. Minutes of the arbitration meeting now, page 38.
Yes.
These are all claims are enumerated. Now, my lord, kindly see.
Minutes of hearing are recorded here.
Yes. Beg your pardon, my lord?
Minutes of hearing.
Minutes of hearing, 26 February.
We paid for time and all.
Yes. So-and-so appeared for the supply unit. So-and-so appeared for the advocate for the buyer unit, paid for some time to submit written statement. So this I have shown your lordship. It was ultimately submitted.
Yes.
Now, so this is what happens on 26th February. This is like a order sheet, my lord. It has all the details here. 26th February, then 24th April 2018, 6th June 2018, decisions of the council. All this is considering. Kindly come straight to page 41, please, my lord. Arbitration. 12th May 21.
Yes.
This is the hearing where the jurisdiction issue was decided. And at page 43, your lordship has seen this minutes earlier. This is reproduced here.
Right.
Now kindly come to 43. The date before 28th April, your lordship will see thereafter, member of the council appoint, buyer unit did not release so-and-so. So adjudication procedure should be focused only on merit. It was unanimously decided that the matter would be taken up for next hearing to adjudicate the point only on merits. So this is where I said, my lord, the issue was crystallized and the argument to proceed on merits. Then 28th April 2022. Now kindly come to what happens on 28th April 2022. The recording is there. Kindly come to the last 5 lines. My lord. Learned advocate for the buyer unit.
Yes.
Contended that they did not submit their submissions on merit, and as per order of the last dated hearing, the matter should be heard in merit and supplier unit should place the case on merit. But on reply, learned advocate for the supplier unit argued that they had already pleaded the matter 5 times during arbitration hearing on merit. Learned advocate for the buyer unit requested to go through the order of the High Court. Now, no, your lordship has seen the minutes before this. They never made any submissions on the merits.
In the High Court order, it was recorded. Something was recorded regarding this, that it has been heard on 5 dates.
No, man.
You are you are requested to go through the order of the High Court.
Learned unit advocate of the buyer unit requested to go through the order of the High Court. That is, my lord, his submissions that there is no stay. I'm sorry, my lord, I should have placed from the beginning. If your lordship comes to the recording of the minutes of that date, Mr. So-and-so, learned advocate of the supplier unit, attended the hearing. Mr. So-and-so, learned advocate. So, at the outset, advocate of the buyer unit raised the issue of undertaking done by both the parties, but advocate of the supplier unit denied the same and contended that only on one day, that is 18 November, they agreed not to take any further steps, but they did not give any undertaking before the court and there was no stay.
You are requested to go through the order of the High Court.
Yes,
What order?
because my lord, I contended that both of us have consented before the High Court that till the High Court delivers judgment, we shall not proceed with the arbitration.
All right.
So the supplier contended that no, that was only a concession given for a day, and that was not repeated on the subsequent hearings. Therefore, please go through the order. Our concession was limited to a day. So when they did not agree to, my lord, a deferment on 28th April 2022, our submission was that very well, you're not agreeing to a deferment, then you should place the case on merits. Please start with your case on merits.
But you raised the plea only after several opportunities were given to you.
Beg your pardon, my lord?
After several opportunities were given to you, at the last stage you were raising.
No, my lord, kindly see. My lord, kindly see the council holds on at the minute before that. Kindly see the minutes before that, 12th May 21. The council rejects my application on jurisdiction and holds that now the matter will proceed on merits. At page 43 top. So till merit on the argument on merits has never commenced. What he says, I've already argued on merits on 5 occasions at the conciliation stage. Wait. After my lord, 12th May, the next date is 28th, and he says, I've already argued on merits. No argument on merits ever took place. They did not even open their case before, my lord.
All right.
This is the point, my lord, I was asked. Now, decision. Member of the council opined it has already been decided that council does have the jurisdiction to adjudicate. This is, my lord, where on that date itself, the order is made. Your lordship has seen the date of the award, 28th April 22. So I requested argue the matter on merits. He doesn't open his case on merits. And the council closes the hearing and proceeds to make an award.
But no reasons are given apparently.
Now, my lord, kindly see the reasons. Members of the council, kindly see 43, last paragraph.
Yes.
Members of the council opine that the matter had thoroughly been heard on several occasions on merits and jurisdiction. Council meticulously scrutinized all the written submissions made by the parties and heard the oral submission of both the parties during the adjudication process. It was decided that since GC3 can only be submitted by the supplier now on receipt of pending dues from the buyer unit, and as the buyer unit did not release the dues, so submission of GC3 was not acceptable. So amount claimed by the claim for security deposit by the supplier unit is tenable, and regarding the claim of 16 lakhs, deduction made by is not acceptable. Claim amount of 16 lakhs is justified. It was finally decided to pass an award in favor of the supplier unit based on the available documents before the council. The council records that have heard the argument on merits on several occasions. The minutes which they have reproduced, like a running order sheet, does not show any arguments on merits. 28th April, I could have understood my prayer for adjournment was declined. Then a matter would have to be heard on merits. I should have been told that now you argue, he doesn't want to argue, you place your arguments on it. Nothing of that sort. Then your lordship will see, it was finally decided after failing the conciliation, process was initiated. Council has given sufficient advance notice through speed post for the purpose of submission of evidentiary documents before the council, appeared to before the council. Supplier unit submitted the statement of facts, buyer unit statement of defense. Council hold 9 arbitration hearings and both the units appeared, both the units verbally deposed their contention, submitted their written statement before the council. Your lordship will not find any arguments recorded anywhere, or it is even recorded anywhere that this is what was argued, because what is reproduced earlier is just
these are probably regarding the jurisdiction.
Yes,
that
jurisdiction arguments. Because the arbitration process starts at page 33. Before that is the conciliation. The claim and the defense are set out. There's no difficulty with that. But then the minutes of the sitting start only on 26 February 28 at page 38. That is the first sitting in the arbitration.
Yes.
Now, even after, my lord, all this, after initiation of the arbitration, the parties are again then referred to conciliation, which your lordship will find at the 6th February 2018 sitting. This is where their arguments are noticed, and I must place this before your lordship, my lord, lest it is contended. Kindly see 6th February 28 sitting. This is their arguments which were advanced.
What is that page?
Page 39.
Yes. 6th,
6 June.
6 June, yes.
6 June 2018.
Right.
But decision of the council, your lordship sees, after thorough discussion, it was decided that as prayed for the buyer unit, council asked both the parties to sit together, try to amicably settle the matter. Buyer unit was asked to make positive efforts for amicable settlement. Within 21 days from today, supplier unit was asked to submit the outcome of the reconciliation meeting between the parties. Further decided that the matter would be taken up for hearing on 17th July.
All these were included in those 9 hearings.
All these was included.
Because I counted.
Yes.
From page 30, it's probably 9. Yes.
And during this time, when they are submitting documents, making some piecemeal arguments, the conciliation is still pending on. Which your lordship will see on 7 December 2018. Supplier unit was advised to submit their response regarding amicable proposal of the buyer unit. Buyer unit was asked to clear the residual dues within 1 month. It was further decided to take up the matter after submission of both the units.
Yes. Very good.
Now, I will kindly come to the interest decision, the point where the interest has been awarded. Hence, it is ordered that the operative portion at page 48. Whereas from the above facts on record, it has been established that the petitioner has done the job as per the order of the buyer unit. Whereas pursuing the findings of the case, the claim for the petitioner is found true and logical for the job in respect of the tug. Buyer unit is liable to pay rupees 8,74,000. 50% of the security deposit amount would also be liable to clear the rest 50% on submission of GC3 form by the supplier unit. Buyer unit is liable to pay 16 lakhs against deduction made for extra work for different bills, plus interest thereon at 3 times of the bank rate of RBI compounded with monthly rest under section 16. Interest will be calculated after 45 days from the day. As regards the claim, supplier unit is not entitled for any interest on delayed releasing of the same. Supplier unit is directed to submit their claim interest to the buyer unit on the due amount as per direction given in the above paragraph, duly quantified and certified by chartered accountant, along with the claim of due amount of rupees 25,51,000. Thus, the award amount comprises of the due amount and the interest accrued thereof. The buyer unit is directed to pay due amount along with interest within 30 days from the date of submission of claim by supplier unit, failing which the supplier unit is realized to us. They are also liable to pay rest 50% of the SD amount on submission of the GC3 form as and when supplied by the supplier. Now, immediately upon receiving a scanned copy of this award by email, my lord, we filed the 34. It was filed within the time after receiving. Now, my lord, after the 36 came to be dismissed by a letter, compilation compilation in a letter. Compilation of orders was perhaps handed over.
After that,
page 13, yes. 5th August 2023.
Right. Right.
Kindly come to page 2. For your reference, a copy of the judgment so-and-so. Since there is no impediment for honoring the award passed by the council, you are hereby requested to make over the awarded sum immediately. Upon receipt of the instant letter, a copy of the statement of claim in terms of the award dated so-and-so is enclosed for your reference and immediate. Now we are raising our claim as on date, that is 31st July 23, in accordance to the order. So now, till this date, they had not even bothered to give their claim computation to us. There is a question of deposit under section B. The amount is unquantified. If this letter comes, certification comes only after, my lord, the dismissal. And then, my lord, this was received on 5th of August. On 8th of September, my lord, the amount was secured. And then your lordship sees the order dated 5th September. This was, of course, pursuant to leave granted by the court at page 17, my lord. The court had delivered a judgment on 31st July on an application of the award debtor for stay of the award pass. Application for stay in petitioner now seeks leave to deposit 75% of the awarded amount, which comes to 1 crore and 2. Learned counsel appearing for the award holder, however, takes a point of maintainability. Pre-deposit cannot be made now. That would be contrary to mandate of section 19. So leave is granted, money is put in. So this is the whole sequence of facts. Now your lordship will find that the statement of defense was filed on 6 June 2018, which is page 314, the document which I showed your lordship, that is filed on 6 June 2018. This fact is not disputed. The award was ostensibly, and I say ostensibly, my lord, because it was quite surprising, sent after 7 months at least of the date of making, 2022. So statement of defense filed on 6 June 2018, award made on 18th April 22, clearly hit by 29A. And if your lordship sees that once just the provision of the MSME Act, which provides that once the arbitration commences, it shall be guided in terms of the all provisions of the Arbitration Act will apply.
Yes, yes.
That is well settled.
Section 18.
Yes, and this is post the 29A. So 29 clearly hit by 29A.
Post 2015.
Yes. Now, my lord, on the point of whether the computation of interest could have been left to the claimant, there is a coordinate bench judgment of our court, my lord. It's there in the compilation. Eastern Gases Limited, my lord, serial 3, page 10 of the compilation. Eastern Gases Limited, 2022, SCC Online, Calcutta, 332. 2022, SCC Online, Calcutta, 3342. 42. In this matter, my lord, the claim was only on account of interest. The principal had been fully paid. The claim was on account of interest. The interest was left to be computed by the claimant, and the award on this score was set aside. Which your lordship will find on paragraph 12 now. Can come to. One was the issue of whether it was a registered under the MSME Act and could have at all gone, but kindly see paragraph 12 at page 17. Another ground on which the award has been challenged is that the award passed by the council is bereft of any quantification or certification on the amount of interest claimed by the award holder, and that the council has proceeded to accept the claim put forth by the award holder and left it completely upon them to get the claim quantified by a chartered accountant and ordered the award debtor to pay such amount as may be claimed. This court believes that without giving any thought to the principles of natural justice and disrespecting the trust that the parties place in an arbitrator when they seek his assistance to arrive at a decision regarding a dispute, the council in the present case proceeded to simply throw these principles out and left it upon a third party to decide the amount to be awarded. At this case, court feels then a decision of our court is noticed. In paragraph 14, a decision of the Andhra Pradesh High Court is noticed. The arbitrator must exercise his judgment, cannot delegate his right to make an award. When people go to arbitration, they bind themselves by a decision. And then the other sections are noticed. Paragraph 19. Furthermore, as discussed in paragraph 14, the delegation done by the council is flagrantly in violation of the principles established in law. Accordingly, award is illegal and bad in law. The award was set aside. There is a similar, on these lines, there's another decision of our court, my lord. Serial 4. But on the question of, this is an unreported judgment, my lord, on what is the amount to be secured at the stage of 36-2 when coming up from the council's award, my lord. Here, my lord, the court declined to grant any security for interest. Kindly come to paragraph 25. I'm sorry, my lord. Paragraph 23. Yeah, unreported. There. Bol de, Paragraph 23. It is thus clear that the rate calculation of the rate at which and the date from which the buyer is liable to pay interest under section 16 is no child's play. The Facilitation Council anointed as the arbitral tribunal for the purpose of the 96 Act must deal with the interest component head-on by engaging with the relevant dates and figures and come to a considered decision on the specific amount of interest which a buyer must pay to a supplier under Section 16. This adjudication would form an inalienable part of the award and be treated as integral to the decision of the Council. This shows that the Facilitation Council, this same, my lord, kindly see the buyer unit is liable to pay total principal amount plus interest thereon three times of the bank rate of RBI compounded with, this is identical with the operative portion of our award, my lord. This shows that the Facilitation Council has delegated the determination of interest to the chartered accountant of the applicant award holder's choice. The Council as the tribunal has failed to adjudicate the amount of interest payable by the petitioner to the respondent and made the decision entirely dependent on the computation to be done by the chartered accountant. The delegation of adjudication was despite the respondent supplier claiming interest on the principal amount as per its reference before the Council. Then the paragraph 27. This court is of the view that the delegation of an important part of the adjudication process of the tribunal is not permissible under the provisions of the 96 Act. Section 31 of the Act delineates the form and contents of an arbitral award and makes award of interest an inseparable part thereof. The 96 Act does not envisage adjudication of the quantum of interest in an award to be a function which can be decoupled and be delegated to another forum or entity and thereafter accept the determination as a part of the award. The impugned award in the present case depends entirely on the calculation of the chartered accountant. In the same way, 18.4 makes it clear that the deeming fiction contained therein would bestow the Facilitation Council with all the trappings of a tribunal for the purpose under the Act of 96. This means that the Council was under an obligation to adjudicate on the entirety of the claim, including that of interest, and not shift the responsibility on the chartered accountant. Coordinate benches have noticed the infirmity of partial adjudication. Hindustan Engineering Metaflux and Usha Martin have showed your lordship, my lord. Hindustan Engineering is also part of this, my lord, compilation.
Mr. Thakkar, can you please satisfy me from the section also? I am bound by these judgments. These are coordinate bench judgments, unless I differ.
Well, this was on the 36th stage, but on
no, even then,
yes,
that principle has been laid down.
Principle is laid down.
But from section 16, is there any uncertainty in the components? I mean, from section which requires section 16 of the MSME Act, which is the premise of calculation of interest. Please try to satisfy me, Mr. Thakkar, that there is a component of uncertainty which requires adjudication, not a mere arithmetical calculation. Appointed day concept is there. Is there any scope of adjudication left if the principle is decided? I'm just looking into
I follow,
it.
my lord. Where a buyer, kindly permit me to read this one. Where any buyer fails to make payment, fails to make payment of the amount to the supplier as required under Section 15. The buyer shall, notwithstanding anything contained in agreement between the buyer and the supplier or any law for the time being in force, be liable to pay compound interest with monthly rest to the supplier on that amount from the appointed date, or as the case may be from the date immediately following the date agreed upon.
So two things are there.
Something which I need to,
no, you will get the recess.
I'll get the
Appointed day, probably there is some scope of argument. Appointed day requires some adjudication.
Yes,
what is the day of
there's a
acceptance?
definition. Appointed day is defined.
Yes, to be. I'm looking at that only.
Yes.
So there probably you have an argument. I mean, that has to be decided. There is a scope of adjudication.
Yes.
We'll come back after recess and continue with this. We'll come back after recess and continue. You have an argument to make. We'll pass the judgment and resume the original side matters we are hearing. I was hearing. Yes, this is only for the purpose of passing this judgment.
My lord, may I be permitted to mention a matter, my lord?
Division bench matter.
Yes, my lord. Appellate side division bench, my lord.
This is only for this limited purpose we are sitting. When we sit next, please mention. Because we are sitting after some time. Justice Kumar will not be there for 2 weeks. I'll be taking up with a different honorable judge. So mention then on Monday.
Your lordship, very well. Grateful.
Matter wherein your lordship had passed a direction that the paper books may be handed over.
Don't mention any matter. This is only, we are sitting only for passing this judgment. We have been assigned this bench for that one.
It has not been given.
Mention on Monday, please. Mr. Chakraborty, please mention on Monday. When you take up this. In an appeal set matter today, where we will consider that
we have opted to stay against the order.
if you can't finish the original side matters before that, before rising, then we'll consider if we can take up from 3:30 or something like that. Please be keep somebody for those content matters which cannot wait till the next day. Call for division list. Accordingly, FAT 448 of 2019 is allowed on contest, thereby setting aside the impugned judgment and decree dated August 20th, 2019, passed by the learned additional district judge, 3rd court at Berhampur, district Murshidabad, in testamentary suit number such and such, granting probate of the will to the plaintiff, propounder, appellant Madhav Kumar Shah. Interim orders, if any, stand vacated. Appellant will be at liberty to ensure that ministerial acts in consonance with the present probate decree are completed expeditiously. Formal decree be drawn up accordingly. তুমি থেকো অরিজিনালটা শেষ হলেই বই Yes.
If your lordship, here is Mr. Thakkar, my lord. But my junior is there, my lord. He'll take notes.
Yes, yes.
But and my lord, just one more thing, my lord, which I would, my lord, want to mention.
Quick. What?
My lord, all the papers that were before the tribunal, my lord, are before your lordship, my lord, except one rejoinder. My lord, that, my lord, is really important because they have taken the point of works contract, my lord.
If it was a part of the law before the arbitrator, then yes.
Yes, my lord. So we would want to file it, my lord, by way of supplementary, my lord.
No, just give a copy to Mr. Thakkar's learned opinion.
I just have one copy.
If he agrees, we can take that on record without even a supplementary affidavit. If it was a part of the arbitration.
I'll get it photocopied in the meantime, my lord.
If they are being taken by surprise, Mr. Huda, at this stage we will not permit it.
It's they have annexed all.
We'll consider that. We'll consider
all the.
We'll consider that.
Pleadings except that rejoinder.
We'll consider that.
Before the.
We are keeping it open for consideration, not like this. Not like this. You should have done that previously. Yes, Mr. Thakkar, please continue.
Before the lunch recess, my lord.
Yes.
Your lordship's query was, my lord, as to whether any adjudication is required to be done on the part of the tribunal on the quantum of interest.
Give us half a second. একটা note লিখছিলাম ওটা কোথায় এটা? Sorry, please continue. Yes.
The lordship's query was whether any adjudicatory function is there for the calculation of interest, given the prescription in section 16 now, my lord.
Yes.
So section 16 stipulates the rate of interest notified by the Reserve Bank and stipulates it is the appointed date. The appointed date is defined in 2B, means the date following immediately after the expiry of the period of 15 days from the date of acceptance or the demand of or the day of deemed acceptance. Day of acceptance means, well, in the definition of appointed day itself, it is my humble submission that the day of acceptance needs to be determined for starting the for the start point
Hmm.
to determine the appointed date.
At least
when-
two variables I can find.
Yes.
One is this appointed day itself because of the definition and explanation.
Yes.
And the other is probably this in section 16 itself from the appointed day, or as the case may be from the date immediately following the date agreed upon.
Yes.
Maybe some scope of adjudication.
Some scope of adjudication, and to determine what is the appointed date
That
itself,
itself.
there is.
Yes.
Itself, there are multiple, my lord,
Right.
multiple variables. Because if there's an objection, your lordship sees if there's an objection, then from the
Yes.
day on which the objection is removed by the supplier. So all these things have to be
Have
gone
gone
in.
into-
Have to be gone into by the
Right.
chair.
Yes.
So, my lord, on that score, my lord, there are.
You have cited those.
I have
arguments.
cited the decision, my lord.
Yes. Both the
So may I
judgments of
just
this.
sum up, my lord? First is the argument of 29A,
Two judgments you have not cited, item 2 and 7.
2 and 7. Can you
2 is Tirupati Stills.
Tirupati Steels is, my lord, Supreme Court on this that it is not a stillborn or the money can be put in, my lord. Paragraph 13 of
That is
Tirupati.
also on 75. That deposit.
Yes, the pre-deposit 22.
And 7.
7 is also on pre-deposit, my lord. This is Delhi High Court.
All right. Good. So please sum up.
So, my lord, summing up,
Yes.
29A clearly applicable
Yes.
and beyond the period prescribed. Therefore, it is the award. The tribunal was non-est in the eyes of law,
Yes.
lacked any authority. Number 2 is, my lord, denial of natural justice. And number 3 is, my lord, interest was not computation.
Delegated.
Yes. That is all.
And on limitation, you have made your argument.
Limitation I made. Limitation as in for filing the 34. my lord.
Yes. for
Yes, that is that, my lord, the scan.
Covered by
Yes.
this.
Covered by our division bench, my lord, when it was considering the, and in my case even better because admittedly no, the original under 31(5) was not served on me till date. What I have received is only a scanned copy because their mail says tried to serve but could not be delivered. In that case, they should have called a meeting. That is how it is otherwise done. A meeting is called, the parties are called, and
this includes the stillborn aspect also.
stillborn in aspect is
75%
yes,
pre-deposit.
covered by the division bench.
Great.
Those are my aspects.
Thank you. Yes, he wants to rely on a rejoinder.
I am not aware, my lord, of
Let's give a copy to them.
what the rejoinder is, but I don't think perhaps they'll seek an accommodation today, my lord.
Perhaps.
Looks like.
We'll get a.
May I just see that?
Actually, what has happened, there was a we had filed before the MSME Facilitation Council, which we would be relying upon for the points of the works contract.
But they did not have a
But the
copy of that.
No, the rejoinder was before the Facilitation Council, and it was, I do not know if we have provided because I was
Give a
not
copy
there.
to them so that
But
they
we
can
will be
come prepared on
providing
that. Yes. Would you like to give the reply today?
Your Lordship, I'm being led by Mr. Chaudhary.
Very well, then give a copy to them so that in the meantime they can look through it. It'll be easier that way.
You can leave me 2 minutes on the next day, my lord, instead of taking up your lordship's time today.
So you have to, yes, you have to
Just I'll consider this and come back for 2 minutes only on.
do that. Yes, absolutely.
Your Lordship, I've given.
When should you keep it next?
Your Lordship, anytime convenient. to Your
Friday.
Lordship, next.
They will have to be also Friday, my lord. I will not take.
Friday. No.
Your lordship,
Yes,
take up
next
these
Friday.
matters on
Oh,
Friday.
yes. Right.
Friday, my lord.
Sorry. Yes. Hard in
That
part.
copy code again.
So at this juncture, comma, the respondent seeks to rely on a rejoinder used by them before the arbitral tribunal. Push up next para. A copy thereof be served on the learned advocate for the petitioner during the course of the day in order to enable the petitioner to come prepared on the same. First off, for further arguments, comma, the matter be listed on December 6, 2024.
My lord, I've handed over a compilation of the judgments to my learned friend also.
Yes, we are not recording that, but yes.
My lord, one point I forgot, my lord. The first point was that works contract, but
Oh, yes, that too.
3 points plus 1, the jurisdiction lacking on
So,
account of
Mr.
works
Thakur, you
contract.
can come prepared with the brief written notes of arguments also.
On the yes, I will do.
On all the points, but 1 or 2 pages because I have detailed
Yes,
notes
yes,
of
your
your
lordship,
arguments.
I'll
Just
come
as
with
a
the-
reminder, yes. Just the points, 2 page. You can also come prepared with the written notes of arguments if you so want.
Grateful.
Great. What is it? চলবে হ্যাঁ এখন তো চলবে
এটা জেরক্স করে দিন আমাদের আরেকটা আছে আমাদের 18
None appears for the parties.
I appear on
Matter
behalf of
stand
the
adjourned for the day.
respondents.
Next.
I appear on behalf of the respondents, my lord.
You have appeared after the matter and order was passed. Sorry. Yes. Next. Same. Same. Same.
Then I appear for the respondent, my lord. So section 11 application, directions for affidavits were given.
Affidavits have been exchanged.
I have filed my opposition, my lord.
You have filed or it is?
My lord.
Very well, we'll take it up on the next day. Although the respondent is represented through counsel, none appears for the petitioner. Let the matter stand over for the day.
Right now, 17, my lord.
None appears for the parties. Let the matter stand adjourned for the day. 19. Same. Same. Same order.
23 minute, I pick to one of the respondents.
Which respondent?
Respondent.
State.
State.
Learned counsel for the state appears. However, none appears for the petitioner. So let the matter stand over for the day. None appears for the parties. Same order. No, 25 is same. 26 is same. Same. Same order. দেখে দিন অর্ডার রেকর্ড করবো না নট টুডে করে দিন নট টুডে অর্ডার করতে হবে না রেকর্ড করতে হবে না কোম্পানি ম্যাটার লোক নেই অর্ডার রেকর্ড করতে হবে নট টুডে অ্যাপল সেট
Well, I am for the petition in this matter. I beg to represent the alleged contemnor, my lord. In this matter, Lordship was compelled, my lord, to issue a rule, my lord, against the alleged.
They were not coming.
On 13th September. My lord, for not coming. Lordship, may I hand over, my lord, a rule, cost to the rule I have shown, my lord.
You are the petitioner.
I am for the petitioner.
You are for the petitioner.
We have preferred a cost to the rule, Lordship.
You have preferred a yes.
Lordship. May I respectfully hand over, my lord?
Now, Aditya.
Lordship. My lord, Lordship was pleased to issue the rule on 13th September 2020.
But your client was the person.
Yes, this is my present Lordship, if you allow.
What is the cost shown by you?
This gentleman, he has received, my lord, the contempt notice.
This is also, in the morning he was in another matter.
He was there.
Similar thing, probably. Yes, what is the cost?
So he received this, my lord, this contempt application 3rd September 2024. Officially.
So what is the cause for non-compliance? This is
he could not appear on the day when your lordship was compelled to issue the rule, my lord.
No, the parent order, why didn't he comply?
Parent order, my lord, two respectful submissions. One, my lord, his first endeavor to comply was made on 11th November 2024.
When Mr. Kali, be your entitled.
And my lord, secondly, my lord, state has preferred an appeal, my lord, on 20th November.
You have disclosed those in this?
I have, lordship.
Give a copy to them.
No copy. We have already.
I'll dispense with his personal appearance for the present.
Lordship.
Let them consider and come back.
No copy of the appeal has yet been served. No notice has yet been served.
No,
order has been passed.
Order record code.
This one has been served.
Nothing has been served.
Learned counsel for the alleged contemnor files an affidavit showing cause to the rule. Full stop. Next para. A copy thereof be handed over to the learned advocate for the petitioner during the course of the day. Full stop.
This was handed over, lordship.
It has been handed over.
Cost to the rule was handed over to him.
Be handed over na has been handed over to the learned advocate for the petitioner. Full stop.
There is no mention appeal has been filed.
No, appeal was filed after filing this, my lord. That's why I am filing this
There is
pending.
no cause, no appeal has been filed. No statement has
After
been
filing, my lord, on 20th November, they filed the appeal, lord. State.
Continue করে যাও learned counsel for the petitioner learned counsel for the alleged contemnor further submits that an appeal has been preferred against the parent order and the matter was fixed for hearing on November 25 2024 as per an information slip handed over in court today and kept on record. What happened on that date?
No, nothing happened. It has
So,
not-
however, it is submitted that the appeal could not be taken up by the concerned division bench on the said date. Push up next para, learned counsel for the petitioner submits that he is unaware of the appeal being preferred. Push up next para. In order to enable the petitioner to respond to the causes shown in the affidavit and or file a rejoinder, if any, the matter is postponed till December 6, 2024, when such rejoinder, if any, shall be filed by the petitioner with an advance copy to the learned advocate for the alleged contemnor. Push up next para, in view of the cause having been shown and it having been explained sufficiently to the court as to why the alleged contemnor could not be present on the last occasion when the rule was issued, being that the order was communicated, the order was communicated late.
Lordship, order was communicated. No, he, my lord, communicated after receiving for engagement a lawyer late.
Being that there was a communication gap between the alleged contemnor and his lawyer, personal appearance of the alleged contemnor is dispensed with for the present until further orders. The matter will be listed on December 6, 2024.
Lordship.
Please use a response if you want, rejoinder to this.
6/24.
Next Friday? Yes, next.
Look, 2, my lord, I appear for the alleged contempt number 2, my lord. Pursuant to the rule, the alleged contemnor is present, my lord. But before I say that the order has been complied with, my lord,
Complied with?
Before I say, my lord, it has been complied with, my lord, I tender my unqualified apology, my lord.
I have complied with late.
Well, there is some delay, my lord. I must very.
Some means?
My lord, initially, my lord, this, my lord, pertains to giving of electricity connections, my lord. My lord, the pathway, my lord, had to be the reason the district magistrate was directed. In case of any difficulty, the district magistrate was directed to pass a reasoned order. But somewhere the file was not.
See, we do not find any fun in calling district magistrate. They are sufficiently capable.
I know.
Otherwise, they are sufficiently responsible also.
I know, my lord.
We are aware of that.
I know.
And we don't have any fun in calling these people.
Absolutely, my lord.
But
I know.
unless we are compelled, we don't issue a rule. You know that very well.
We also know, my lord. My lords always, my lord.
A rule because a public official need not come to the court unnecessarily.
True.
Not at all. For normal matters, we don't do it.
True.
But in contempt, if you don't comply, then we have to issue a rule.
True.
So give a copy of this report to them. For the time being, we'll dispense with personal appearance.
My lord, kindly do that.
Let them consider that and please come back on the next date with your response to this. The alleged contemnor, you are for contemnor number 2 or both?
2, my lord. 2.
What about 1?
I'm for the 1, my lord.
1, what is your stand? He is also present in court.
Yes, my lord.
Why not complied?
I have complied, my lord. As per my lord's order, my lord, we have gone to.
They had to refer the matter to the district magistrate.
You have done that within time.
Yes.
Within time, my lord. And my affidavit in opposition is there, my lord.
Is there?
Yes, your lordship has taken note on the previous occasion.
Opposition টা বার করে দাও অনিন্দা কোনখানটা ছাড়লাম আমি কি বললাম লাস্ট Opposition, what do you say? You are for the petitioner?
For the petitioner.
What do you say to the opposition? Have you got a copy?
Order has been complied.
Very well. Next para. Learned counsel for the learned counsel for the alleged contemnor submits further that the order of this court has been complied with in the meantime. Push up next para. It at the time of call, both the alleged contemnors are personally present in court. Push up next para. Learned counsel appearing for the alleged contemnor number 2 tenders unqualified apology for the said alleged contemnor being late in complying with the order. However, it is submitted that in the meantime, the order of this court has been complied with. Next para. What was the reason for the delay?
Lord, somehow, Lord, I must be honest, Lord, the file was misplaced.
It is further submitted that since the file was misplaced in the office of the alleged contemnor number 2, the order could not be carried out within the time as stipulated in the parent order. Next para. Insofar as alleged contemnor number 1 is concerned, it is submitted, by placing reliance on the affidavit in opposition filed by the said alleged contemnor, that insofar as the part of the alleged contemnor number 1 is concerned, the same was complied with in terms of the parent order. Next para. Learned counsel for the petitioner submits that the order of this court has been complied with in the meantime. Next para. Upon a careful consideration of the stance taken by the alleged contemnors and perusing the affidavit in opposition of the alleged contemnor number 1 and the report filed on behalf of alleged contemnor number 2 in court today, the court is satisfied that there was no palpable contumacious action on the part of the alleged contemnors, and the delay in compliance of the order was due to sufficient reasons. Next para. That apart, since the order of the court has ultimately been complied with, which is agreed to by the petitioner, no further purpose would be served in keeping the contempt application pending, contempt application as well as the rule pending. Hence, WPCRC number 139 of 2024 stands discharged. Further appearance of the alleged contemnors stands dispensed with. CPAN 1142 of 2024 is also treated to be disposed of accordingly.
We are grateful.
Copy of the report, my lord.
Let a copy of the
Report of the DMI.
to you.
I've handed over. My lord.
Grateful.
I'm grateful, my lord.
Thank you. Next. Yes. Yes, please. Yes, Mr. Chakravarti, you are at the receiving end now.
But I am for the petitioner.
Yes.
My lord, the alleged contemnor preferred an appeal against the last order of my lord, where the rule was issued. And the matter is contested before the learned Chief Justice.
Regarding the parent order also there is a challenge.
No. The last order, the order.
But the parent order stands.
They have preferred the point of dispute is that they have preferred under clause 15, which we have challenged. The maintainability of that particular application is pending, and there is a limited stay till 11th of December.
Oh, then there is no question.
No, I tell you.
Yes.
When it was first moved on 11th of November 2024.
Yes. Mr. Chakravarti, this was the matter you are submitting. Yes. You are waiting.
Then the questions I had the privilege to formulate whether an appeal lies against the issuance of rule of contempt and the doctrine of merger in view of special bench judgment of this honorable court issue. Third is the other issue is whether this can be questioned before the appellate court.
So this is pending before the appellate court.
I just tell you. Yes. Just 1 minute.
Absolutely, yes.
On the first date, their lordships were satisfied prima facie because I had the privilege to argue that an appeal lies under clause 15 of the latest patent even against the issuance of rule.
Yes.
Now their lordships were pleased to hold that at present no coercive action shall be taken.
Yes.
And on the prayer of Mr. Sakko Sen, this matter was posted on 20th of November. But it was ultimately taken on 27th. And then the lordships have been pleased to stay of the operation of the order appealed against issuing rule of contempt.
Till?
And the matter is...
The matter will be appearing on 11th of December and the stay...
No, for final hearing of
the... Yes,
stay is still?
Stay is till that period.
So we'll keep it after the vacation?
Yes.
Very good. It is pointed out by learned counsel for both the parties. It is pointed out by the learned additional solicitor general as well as learned counsel for the petitioner that an appeal has been preferred against the order whereby rule was issued against the
This is the first number is given.
whereby rule was issued against the alleged contemners. Full stop. A server copy of the order of the appellate court dated November 11, 2024, passed in the said appeal bearing MAT 2003 of 2024, and the connected application is handed over to court by the learned additional solicitor general. Full stop. Next para. It is submitted by both sides that the appellate bench has granted an order of stay
On 27 November.
On the personal appearance.
on the personal appearance of the alleged contemnor on November 27, 2024, and the appeal is now sub judice before the concerned division bench. Full stop. In view of the pendency of the said appeal and the stay granted, comma, the demands of propriety, in order to meet the demands of propriety, comma, let the contempt application and rule stand adjourned till January 10, 2024, when the rule will be listed under the same heading. The second Friday after reopening.
2025.
Oh, thank you. Thank you. 2025.
Number 5. I prefer the petitioner.
Petitioner, yes. For the first time, contempt application?
No, no, second time.
Second time.
This is my evidence. Contemnor, my lord.
What is the
This is my
evidence,
evidence,
sir?
sir.
Yes, why did you commit the contempt?
Lord,
Oh,
the
Lord-
new
Lordship,
incumbent,
kindly-
the new incumbent has joined on 17th May 2023.
Can you give the furnished particulars to him?
Yes, my lord. I shall
Do that during the course of the day. He will make out the necessary corrections and we'll take up the matter next week.
May I kindly see the order?
The last order?
Yes.
Yes. Compensation directed. Why
Yes.
are you not disbursing the compensation?
Yeah.
New incumbent should do that.
Lordship, kindly see the page 26 once.
On the next date, my lord, I shall.
Kindly see page 20. This letter has been issued in the year 2021.
But the previous incumbent was there when the order was passed. What
Yes,
is
my
his
lord.
justification?
At that time, he was present.
What is his justification? Why didn't he comply?
Yes, my lord.
Now this practice will change. That I'll change that substituting the current incumbent for the previous.
Yes.
Previous incumbent will remain and this person will
Yes,
also
my
come in.
Both.
Because otherwise they are both guilty. May be guilty.
Yes.
The affidavit of service filed today be kept on record. Full stop. Learned counsel for the alleged contemnor submits that a new incumbent has joined in the post of the alleged contemnor who should be impleaded. Full stop. Next para. The particulars of the new incumbent shall be furnished by the learned advocate for the alleged contemnor to the learned counsel to the learned advocate for the petitioner during the course of the day in writing.
Yes, my lord. I can at present.
Thank you. Full stop. Next para. Necessary consequential amendments to the cause title of the contempt application shall be carried out by the learned advocate on record for the petitioner, impleading the new incumbent along with the previous incumbent as alleged contemnors in the contempt application. Full stop. Next para. You have instruction to appear for the new incumbent also, must be. Since learned counsel for the alleged contemnor has instruction to appear for the new incumbent as well, comma, no further service is required on the new incumbent. Full stop. Next para. Any particular reason why you could not comply?
My lord, I shall take instructions on this.
But well, kindly see page 26 once. This letter has been issued in the year 2021 in favor of me. Till date, no steps has been taken for disbursing the payment.
I'll direct them to use affidavit in opposition directly because on the next occasion they'll give something. But you should know the reason you are appearing for him. 2022 is the service only.
No, 2021.
What was the direction?
That to consider and establish and thereafter, my lord, pay the compensation.
Compensation to who are you?
The land acquisition has been taken by the PH department.
I'll direct them to use affidavits. Both the alleged contemnors shall file their affidavit in opposition within a fortnight from date, explaining the alleged act of contempt, if any. Full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed on January 3, 2025 for hearing. Immediately after the opening, the first Friday, and before that, exchange your affidavits. Next.
Lord, I'm for
Text,
the
my lord, I beg
petitioner-
to appear for the alleged
I'm for the
contempt.
petitioner, my lord, led by Mr. Kaustubh Bagchi, and on his behalf, my lord, I would like to pray for an adjournment. And
Why?
my lord, he won't be available till the 15th of December. due
But
to some-
there was a direction by your lordship
my lord,
on
and
8 November 2020.
regarding
We
that
complied with the order. The matter, my lord, relates to payment of certain remuneration
My
to
lord,
the
with
immunization
regard to that-
volunteers.
Yes.
We filed affidavit of compliance. My learned friend filed opposition that he's not happy. He says it has not been complied, letter in spirit.
Right.
Now, my lord, on 9th November, if I may respectfully invite your lordship to the order on 8th November's order, lordship. My learned friend comes up with a plea. My lord, kindly, my lord, comes to paragraph 5 of your lordship's order, my lord. Learned counsel for the petitioner disputes the contents of the alleged contempt and submits that several days payment has been withheld. Now, my lord, kindly comes to, my lord, paragraph 9, my lord. 8, 9, it has not yet been complied with till.
My lord, with regard to that, I have some instructions I would like to place before this court, my lord. The instruction is that the petitioner number 1, that is Upendranath Mahato, my lord, against him criminal proceeding has been initiated. It's fault criminal proceeding just after the order was passed.
Disclose those, that's
Yes,
why
my lord. That's why we are taking some time, my lord. And secondly, my lord, since he is
that is no reason for taking some time.
no, my lord, since he is now in process of obtaining anticipatory bail from the
Understood,
Learned
but
Court,
others are also there. Other petitioners are also there.
Yes, my lord. That's why we require some time, my lord. Just some time.
No, the petitioner number 1 was conducting.
Yeah, along with others.
So then the others could have affirmed on behalf of.
We have got some documents, but some documents are still.
But you are to comply. They are held under the guillotine of contempt, and you
My
take
lord,
time. This is not proper.
No, my lord, I do
No
understand.
question of granting you so much time. You are asking for time till.
My lord, just after the vacation, my lord.
No.
My lord, or at least 50.
You have to use that opposition within a week.
My lord, just
we can advise. I can advise section for a week. One cannot be held under the hanging. This guillotine
my
of
lord, I
contempt.
completely bow down, my lord.
You have filed a contempt petition. You have to be diligent. Just because Mr. Bagchi is not there, that is no excuse. You are there. You are Mr. Ghosh.
Yes, my lord.
Mr. Ghosh, you are there. You had appeared on the last occasion.
Yes,
You
my
know.
lord. Yes, my lord.
So you have to file that affidavit.
At least 15th of December, my lord. That's my only humble request, my lord.
Yes, what do you say, Mr. Yogali?
I leave to your lordship.
Learned counsel for the petitioners seeks an adjournment in the matter. Whose of learned counsel for the alleged contemnor submits that in the order dated November 8, 2024, in view of the stand taken by the petitioners that certain payments have still been withheld from the petitioners by the alleged contemnors, the court had granted an opportunity to the petitioners to bring on record the relevant documents which were sought to be relied on by the petitioners. Full stop. However, till date, no such documents have been brought on record or any rejoinder has been filed by the petitioners pursuant to the leave granted by the court. For some next parallel, counsel for the petitioner submits that subsequent to the previous order, criminal proceedings have been initiated against the petitioner number 1, who was primarily dealing with the matter. For sub next para, the petitioner seeks adjournment till December 15, 2024 for filing the affidavit of filing the rejoinder as directed earlier. Full stop. Upon hearing learned counsel, as a last chance to the petitioners to bring on record the relevant documents and file the rejoinder in terms of the order dated November 8, 2024, the matter is adjourned till January 3, 2025. Full stop. The affidavit, the rejoinder, if any, along with relevant documents shall be filed latest within December 13, 2024. Full stop. Reply, if any, further reply, if any, to the same shall be filed by the alleged contemnors within a week thereafter, that is by December 20, 2024. The matter will be listed on January 3rd as that. Next.
Number 7. My lord, this was adjourned last time. Already 2 times adjournment has been done. So, my lord, kindly don't adjourn it. We are waiting for justice for last 6 months. Kindly dispose of the case.
Lord, today it is appearing at serial number 19. Today's list before Honorable Chief Justice.
No, nothing doing. We have waited sufficiently.
But Mr. Banerjee has instructed me.
Last chance was given on the last occasion.
It was 2nd time adjournment last time.
So we will give a last chance then. If it's appearing before the Chief Justice, what can we do?
Lord,
Cannot direct the Chief Justice to dispose of early. An appeal is pending. That's appearing in the list. What
But
can we
there
do?
is no interim stay order, so it is not mandatory to adjourn it any
No,
further.
not mandatory, but it's not.
Still, we have got already 6 months has been lost, my lord. We are suffering from.
We'll
delay
record
in
your
getting
submission, but keep it after the vacation. The petitioner appears in person with the leave of court. Push-up. An adjournment is sought by learned counsel for the alleged contemnor on the ground that the appeal preferred against the parent order has still not been heard by the concerned division bench where it is appearing. Push-up. It is further submitted that the appeal is appearing as item number 19 of today's list before the concerned division bench. Push-up. Next para. The petitioner submits that the petitioner has been waiting for justice since long and the matter has been adjourned at least on 2 previous occasions. Full-stop. It is submitted that no further adjournment be granted in view of the predicament of the petitioner. Full-stop. We find from the records that on previous occasions as well, adjournments were granted on the prayer of the alleged contemnor on the self-same ground. Full-stop. The petitioner is justified in submitting that filing of an appeal does not automatically operate as a stay of the order impugned, and as such, there is no legal hindrance at the present juncture to proceed with the contempt application. Full-stop. However, as a last chance to the alleged contemnors to move the appeal and obtain any order from the appellate bench, if any, the contempt application is adjourned till January 3, 2025. Full-stop. It is, however, made clear that the petitioner cannot be made to suffer longer, and in the event the alleged contemnor stroke appellant fails to obtain any order from the appellate bench in the meantime, appropriate orders will be passed by taking up the contempt application for hearing on the next available date.
My lord, kindly give us a date in the December only. It will be better for us.
Won't be done. Again, the same thing will happen.
It will be
You
hard.
have given a last chance, Mr. Gop. Let us see. And I have recorded in the order all your submissions and also given a last chance. Just point out to me that this was a last chance on the next occasion.
Okay.
Take out a server copy, point it out, and we'll pass appropriate orders.
Okay, ma'am.
Number 8.
Yes.
I appear for the petitioner, ma'am. The respondent contemnors were supposed to file compliance report.
They have not complied according to you.
No, they have not complied. What they have done, now they have preferred an appeal against an order dismissing the review petition.
And against the parent order, what happened?
Parent order, my lord, appeals have been dismissed as withdrawn.
And they preferred review.
My lord, your lordship.
What was the direction? To pay money?
Yes, release of incentives.
Yes.
My lord, WBIDC and state has preferred appeal. My lord, I'll not say anything, but I'll leave it to my lord.
Will issue a rule of contempt. What else can be
Yes,
done?
ma'am.
My lord, kindly gives us 1 week's time.
For what?
If we are not able to do it, get the
The state has filed this appeal against the review.
both state and WBITC both have filed their.
You did not commit the same mistake twice. Previously, you had not preferred an appeal.
No. Both the parties, yes, both the parties preferred appeal. Both the appeals were dismissed as withdrawn.
On the ground that the issues raised,
whatever may be the ground, dismissed as withdrawn, without any leave to prefer appeal against the main order.
Yes, were not taken before this court, but without any leave, that amounts to affirmation of the order.
My lord, then we preferred a review. My lord was pleased to dismiss it, saying that this are not new issues. Could have been this. Yeah, no, that's what we have preferred an appeal.
My let rule be issued, my lord. That will expedite the hearing of the appeal. Yes, my lord. Let a rule be issued. My lord, this will go on. This will go on forever. I am telling. I am making this submission, but with some kind of experience behind me. Kindly issue a rule,
yes,
and then, my lord,
Majumdar, a lot of experience with this, has dealt with these matters.
My lord,
from which end?
From this side.
My lord, we are like switches, my lord. My lord, kindly issue a rule right now.
No.
And
it is appearing in the list.
Nothing. There is a delay application, condonation of section 5.
Rule has to be issued.
The delay is not of my lord, because in the intervening puja vacation we could not file. It was.
Well, I do not know.
You file a condonation application then.
My lord, it has been filed 2 weeks back. We have filed the. I do not have All the applications.
Why do you have why have you filed a
Well,
completion application?
Well,
There is a
intervening puja vacation had come. Well, it is our fault. We did not apply for the
Well,
certificate.
today,
It was delayed on our part.
today is 22nd, subject to
Well,
correction.
if
But if it is 2 weeks back, as Mr. Chakravarti is pointing out, on 8th November, this matter appeared before Lordship. So they must have preferred the appeal
after that, one after that.
Then it is not 2 weeks back.
My lord, I was only praying for a week's time. If in the meantime, my lord, Monday and Wednesday are the dates. If we are not able to get the matter moved, my lord, whatever.
It is not even appearing in the list.
No.
It will appear, my lord. Where's the court? My lord, as the last chance, my lord.
But we will obviously use an affidavit in opposition against the Section 5 in this matter.
Learned counsel for the alleged contemnor seeks an adjournment in the matter on the pretext of appeals having been filed against the order dismissing the review application filed by the respondent in the writ petition by this court. For next part, it is however, submitted that the said appeals are accompanied by applications for condonation of delay in filing the same. For next para, learned senior advocate appearing for the petitioners contends that the preference of the appeal against the order dismissing the review application is nothing but a ploy on the part of the alleged contemnor to procrastinate the matter. It is pointed out that initially 2 appeals were filed by the state as well as the WBIDCL against the parent order, which were subsequently dismissed as withdrawn without any leave to file afresh. Although learned counsel for the alleged contemnor contends that the withdrawal was since the points urged before the appellate court were not taken before this court, the records indicate that whatever might have been the reason for the withdrawals, those were not accompanied by leaves to prefer challenges on the self-same cause of action. Next para, that apart, subsequently the review applications filed by the both of you filed review.
Yes.
Review applications filed by the state as well as the WBIDCL were dismissed, even on November 8, 2024, when the matter was last taken up, no indication was given with regard to any contemplation of appeal being filed against the said order. Next para, the appeals have been preferred only subsequently, evidently to stall the process of contempt. There is no reason why the petitioner in the contempt application should be made to wait further for justice. Accordingly, since neither has the delay in preferring the appeals against the dismissal of review been condoned, nor are the applications for condonation of delay or the appeals appearing before the concerned division bench taking up such matters, this court finds no impediment in issuing a rule against the alleged contemnor for deliberate and contumacious violation of the order of this court. Accordingly, a rule to issue calling upon the alleged contemnor to show cause as to why penal action as sought in the contempt application should not be taken against the alleged contemnor. The rule is made returnable on January 3, 2024, when the matter shall be listed next for being taken up at 2 p.m.
10 January then, 10 January.
10 January, very well. January 10, 2025, to be taken up at 2 p.m.
I am sure the appeal by then would have been moved.
And?
Appeal would be moved by.
Yes.
And my lord, obviously, my lord, order dismissing review petition. I need not make any further submission.
No, we never know.
But a statute has to be changed, man.
How much money you are spending, Mr. Chakravarti, the state is spending in these appeals and on their counsel? Instead of that, pay the litigants.
I cannot say much in open court, my lord.
Don't say.
In excess of 2,000 crores.
We cannot compel. The Constitution prevents us from implicating yourself.
Mr. Mujumdar knows it better than me, my lord.
Yes, he does. Next.
Argument number 11.
For the petitioner.
Don't say that so proudly. You may be appearing for the alleged contempt also some other day.
On 27th September, my lord has been pleased to pass an order directing exchange of affidavits.
Before my learned friend, I have to tender apology. The affidavit, though affirmed, but could not be served, my clerk attempted, but could not. I can serve it here and now. If my lord so.
I'll reply within a week and we'll take it up week after that.
As well, my lord, make it 10 days. Reply within 10 days.
Very well. Learned counsel, for you are filing it for alleged contemnor number 1.
Yes.
What about 2? You also could not serve on him.
No, I could not serve because the affidavit affirmed by some other person who is not the contemnor, because the contemnor is in Geneva for audit purpose, my lord.
Before going to Geneva, you should have done it.
He left before.
He'll come back from Geneva or he'll stay there forever.
1/3 of it.
When he comes back, then we cannot wait for him. He has gone to Geneva or wherever.
Filing by
By?
He will come back on 3rd.
3rd of January?
3rd of December.
Thank God. Well, we'll give you another week, then we'll give you 2 weeks after that. We'll put the matter immediately after the vacation. Learned counsel for the alleged. Yes.
As far as I am concerned, I represent my lord the district magistrate Poschim Bardhaman. My lord, the issue relating to his payment, I should be candid before your lordship, that issue relates to 2 districts, Poschim and Purba Bardhaman. He retired from Poschim Bardhaman, it is fact, but he served while the district was at 1 district. So his service records are partially lying within Purba Bardhaman 2. And we have complied.
His service records. The petitioner. Yes.
We have complied.
It was a court staff.
Yes. We had complied to the extent we could.
No, not a court staff. He was a.
No, not court staff. Not court staff.
Audit and accounts department. Yes.
We have complied as far as we are concerned.
Your part.
To our part. If
we'll consider that he'll have to deal with that.
I have to make myself clear.
Learned counsel for the alleged contemnor number 1 disputes that the said alleged contemnor is guilty of any contempt. Push up. It is submitted that due to certain unforeseen circumstances, the copy of the affidavit in opposition, although affirmed in the meantime, could not be served on the learned advocate for the petitioner. Push up. Service of the said copy is effected here and now, and the affidavit in opposition of the alleged contemnor number 1 is filed in court today and kept on record. Full stop. Learned counsel for the alleged contemnor number 2 seeks an extension of the time to file affidavit in opposition till December 5. We are making it. You'll come back on 3rd. December 5, 2024. Full stop. Accordingly, such time is extended till December 6, 2024, by which time the affidavit in opposition of the alleged contemnor number 2 should also be affirmed and a copy thereof served on the learned advocate for the petitioner. Full stop. The time for filing replies, if any, to the said oppositions is extended till December 20, 2024. Stop. The contempt application shall be listed for hearing next on January 3, 2024.
Grateful to your lordship.
My lord, I am for the alleged contemnor.
My lord, I am for the petitioner. That, my lord, mid-day meal cooks, return of 9,000, we have returned, they have accepted, we have been allowed to function. Now only one hinge. Our
opposition you have filed, the opposition on the last occasion.
On earlier occasion, I have.
Yes. But only, my lord, we have been allowed to function, but our bank account has not been made operate. There should be activated.
I am not the authority, my lord.
No.
Even in the mother order, my lord,
even
in the order,
yes,
my lord, there is many direction upon me, my lord. Kindly see the order, my lord.
Let's see.
Kindly see the order, my lord.
Yes. Though there is no scope in the contempt, but
the school
for the ends of justice, we have been allowed our.
I am not authority to defreeze his account.
Let us just see that. Immediately release the money meant for.
My lord, kindly see the page number 20 of the
20, yes.
Paragraph number 8, my lord.
Right.
Accordingly, such and such is deposited by the directing to the petitioner number 1 to immediately release the money meant for other group members of the Alamin group to the tune of 9,000 within a week. But who will receive?
No, that has been accepted.
Money. Who will receive that money? who is the authority, but that portion is silent, my lord. On
That was silent.
Let him
Oh, yes.
You are disturbing him like anything. Please take your seat.
Sorry, sorry.
Yes, please
On
continue.
that issue, my lord, I submitted by stating that fact in my opposition, my lord. Kindly see the opposition, my lord.
No, just explain whatever you have stated in the opposition. Explain from this order. Continue with this. After such release,
After such
petitioner number
release-
1. You had the petitioner number 1 there.
I'm the contemner.
Yes, contemnor may be the petitioner also, but depending on the order.
Yes, my
But you had directed, so they did not. Petitioner number 1 was to release first.
Yes, my lord.
She did.
Yes,
She released the money, but you did not accept. That was the contempt.
Yes.
According to them.
Now subsequently it has been accepted.
Yes. What was your dichotomy? I mean, your dilemma? Why?
My lord, upon me there is no any direction, my lord.
You are whom?
I'm the headmistress.
Who else is to receive?
My lord, the petitioner. My lord, I state the fact, my lord. My lord, petitioner filed this writ petition before your lordship to take into part in the cook, the SSG as a SSG group member, my lord.
Yes.
The court given direction in his order to deposit the amount of 9,000 to the authority, but to whom that has not been mentioned in the order. And in the paragraph number 9 of the order,
previously they were really
previously that has been released and given to the SSG member. And this is the, my lord, copy, my lord. Kindly see this. In presence of BDO and his school mistress, my lord.
Ultimately, what happened? You took the money.
Yes, my lord. Petitioner took the money.
Petitioner.
We have returned the money.
Given money to the SSG member.
Very good.
Well, this is the letter.
According to you, you had no role to play. It was to be released directly in favor of it. So that has been done by him.
Yes, ma'am.
Hard,
24th
actually.
November.
So after that, what happened?
And now we have been allowed to function. We are functioning, but my lord, only the bank account has not been made active.
Who will make that active?
There is good too.
Will
Video
make that
blocked
active?
our video shall do it.
So that's a different cause of action.
Yes, cause of, but my lord, without further my lord, litigation.
Learned counsel for the petitioner submits that in the meantime, comma, the petitioner number 1 in the writ petition, stroke present petitioner number 1 has released the amount of rupees 9,000 as per the parent order of this court, and subsequently the petitioners have been allowed to function as cooks in the under the midday meals scheme in the concerned school. Full stop, next para. It is, however, submitted that the bank account is required to be made operational by the concerned BDO. Full stop. However, comma, it transpires that the said grievance is beyond the scope of the main writ petition and the parent order, and as such cannot be dealt with in the contempt application. Full stop. Since it transpires that the order of this court dated May 15, 2024, passed in WPA 13-228 of 2024, has since been complied with both by the petitioner number 1 as well as the alleged contemnors, comma, no further cause of action remains for the present contempt application. Accordingly, CPN 111141 of 2024 is disposed of as infructuous. Thank you. Next.
Video me kore dibo. I'm grateful, man.
Thank you. Next.
Item number 13.
Yes, Mr. Ganguly, what have you done now?
My lord, already on the last occasion, we have submitted that we have fully complied with the order, my lord. Compliance of the same has already been filed, my lord. Is before your lordship, my lord.
Yes. What do you say? You have taken instruction?
Yes.
Complied?
Yes, ma'am.
So sad.
Complied.
You are so sad for that. Learned counsel for the petitioner submits that the order of this court has been complied with. Full stop. The said fact is also borne out from the compliance report in the form of affidavit filed by the alleged contemnors. Full stop. Accordingly, no useful purpose would be served in keeping the contempt application pending. Stop. CPN 1238 of 2024 is, comma, thus, comma, disposed of as infructuous. Thank you. Next. Sorry.
Number 14.
14, I am for the petition in this matter.
Yes, Mr. Bhattacharya.
Madam, your lordship was directed me to serve the copy of the contempt application of the alleged contemnor. My lord, I have served the copy, my lord, and that was the item delivery. A tag report says that the item was delivered.
Delivered. What is the contempt alleged?
My lord, with regard to district register, your lordship was directed to the district register to my lord the correction to meet certain correction in the my lord the deed, and my lord on the basis of my representation, my lord order page number 13, order dated 7th of February 2024, and last order your lordship was
You are saying that the item has been delivered.
and I delivered to the sender.
Who is the sender? What do you mean by sender?
Item delivered, my lord. I have seen. I have just seen, my lord.
Sender means if you send the copy of the application, who is the sender?
Well, that is my. I am the sender, but
You said merely that it has been served.
my lord, the item
This
delivered.
itself is a contempt disorder.
Item is delivered, my lord. I have seen just the second paragraph, my lord. Subject to correction.
You said that it is delivered to the sender. You yourself said.
Yes, delivered to a sender, my lord. I think that the sender means, my lord, the person who have been addressed to, my lord. These are the second paragraph I have said, my lord.
The affidavit of service shows that delivery has not yet been effected on the alleged contemnor. Accordingly, the petitioner is directed to serve afresh a copy of the contempt application on the alleged contemnor, indicating that the matter shall be listed in the listed on January 3, 2025 next under the same heading, when a further affidavit of service shall be filed by the petitioner. Next. Press service. This was also delivered to the sender.
No, this is appearing, my lord.
Sendee is appearing. Yes. Yes. What is the matter?
Page 23, my lord.
Yes, 23. This was the order under contempt.
Yes, when a sub matter is appearing on the last occasion,
yes.
My learned pen appeared and says that the company has been amalgamated and new company has been formed.
The alleged contemnor company.
Achha. So, my lord, accordingly, your lordship directed us to correct the cost title that we have done and served again.
So you have instruction to appear for the
serve again to the contemnors.
My lord, thing is that when the REIT was moved, then times there was no such company, namely Britain Engineering.
You have inherited whatever was there.
My lord,
if you don't comply, it's non-compliance, you are in contempt.
My lord, I know.
If it has been amalgamated, you inherit
three
everything
companies,
from
the 3 companies, my lord.
Whatever.
Been amalgamated, my lord. Now, my lord, I have to get the copy of the petition. I will file affidavit of petition.
Contemnors.
Received.
My lord. Within 3 weeks, my lord, I will file the affidavit, my lord.
Affidavit.
Because there, my lord, there are.
Why didn't you comply?
Well, some difficulties there because
What sort of
after amalgamation, the company is a government company. And
when was it amalgamated?
That I have to take my lord instruction, my lord, just now, not with me. But my lord,
what happened before amalgamation? May 3rd, 2024, the order was passed.
Before it was amalgamated prior to filing of the writ petition.
You have served the copy
some
filing of the writ petition.
Writ petition. Some other lawyer was appearing in the matter. Since the law officer was ill, my lord, lawyer could not take instruction and he could not appear. But after that, it has now been assigned to me. My lord, the thing is that the Britannia Engineering Company and Westinghouse XB Pharma Limited and Macintosh Bank, 3 companies have been amalgamated. And entire company, now Westinghouse XB Pharma Limited is a company, government company. 99.97% share of the government. And only 0.03% share.
Service has been effected. Notice has been served on you. If you don't comply, then we'll issue rule of contempt. They will personally come and.
My order will be complied with. But thing is that difficulties because the fund has been amalgamated. Now, my lord, file is lying with our AG for opinion, legal opinion, how it is to be disbursed.
We'll direct him, your AG to be implicated also then.
My lord, only 3 weeks time.
Let him come and explain. If he has taken responsibility, let him take responsibility.
I have taken instruction over the telephone, my lord.
Who is your AG? Throw him out of the window. You have to comply the order of the court, sir. It is not dependent on your AG, PG, whatever.
My lord, definitely, my lord. My lord, order.
What do you mean by your AG has advised you? Who the hell is your AG? You have to comply with the order of the court. Why didn't you comply till date? You have been appearing all along for these parties. Why didn't you comply? Answer the question first.
Last occasion, there was some
last occasion.
Correction need to be corrected, my lord. Corrections have been
These
made.
are dues for work done by you.
Yes, and money has been paid by the Haldia Development Authority to them. This is not their money.
Who are these people?
They are the Britannia Company Limited.
Why aren't you paying them up? There was a specific order of the court.
My lord, order will be complied with. My lord, I need only 3 weeks time, my lord.
To comply?
Yes, my lord. It will
You
be
are saying to file affidavit in opposition. There's a difference between the two.
My lord.
We won't give you 2-3 weeks time to use affidavit in opposition. We can give you 1 week time at best for filing affidavit in opposition. But if you say it will be complied, then we can grant you 3 weeks time for that. You decide. Affidavit in opposition is only directed in a contempt application if we are prima facie satisfied that you had a reason for not complying. You are being unable to do that, sir. You have been served, the new party has been served. What was the previous instruction on your part? Somebody must be instructing you.
My lord, previous instruction means last day.
Somebody must have been
petition was
instructing you.
defective. That's why your lordship directed.
Yes, somebody must have instructed you that the petitioner was defective. What was their instruction regarding non-compliance of the court order? Don't rely on technicality so much. One day it will ditch you, technicality, and you will be behind the bars.
My lord, let I understand, my lord.
Why have you not done it? What is your instruction on that? They could come all the way and give you instruction that there is a technical fault in their contempt, and they could not instruct you why they did not comply with the specific order of the court.
Even my lord, no one appears at the time of taking
Despite service.
We'll ensure that they'll appear. We'll issue a rule.
No, my lord. My lord,
Learned counsel for the alleged contemners
my lord, kindly don't issue, my lord.
submits that
With, my lord.
Although he also has instruction to appear for the added contemners, there is no specific instruction as to why the order of this court was not complied with. Full stop. The affidavit of service filed by the petitioner today be kept on record, which indicates that service have been effected satisfactorily on the newly implemented contemners as well. Full stop. It transpires that although the respondents are very keen on pointing out technical flaws in the application for contempt and even pointing out that the original respondent company in the writ petition has since been amalgamated and new parties should be implemented, the alleged contemners are not at all equally willing to comply with the order of this court or even furnish an acceptable explanation for not doing so. Full stop. Next para. Since notice of the contempt application is served and no explanation is coming forth for the non-compliance of the order of this court, rule to issue calling upon the alleged contemners to show cause as to why penal action shall not be taken against them in terms of the prayers made in the contempt application. Full stop. The rule is made returnable on December 20, 2024 to be taken up at 2 p.m. Yes. Please put in the requisites immediately. Next.
I'm going to much of this.
Yes, next.
Yes. I appear for the alleged contemners.
Yes,
I'm
sir.
filing the opposition, but unfortunately the copy has not been served on my learned friend, my lord. That is, but order has been complied with. But I tell you, lordship, my lord, what happened on 13th of March 2024, your lordship was pleased to dispose of the writ application, directing the KMC to deal with the unauthorized construction and dispose of the same. That is your precise order. But that at that point of time, since there was the instruction to me or the learned advocates for both the parties, private and respondent, it was not informed to your lordship that on 14 June 2022, in this matter, the coordinated bench directed to make an inspection and to take steps in terms of that order. Accordingly, in 2022, the unauthorized construction inspection had been taken place. These steps have been taken. Parties were heard, and an order of demolition, part detention was there. Whatever the unauthorized construction was detected, that was not dealt with. But the order was not communicated because of the reasons that that order is subject to approval of the mayor in council. It was forwarded to the mayor in council, but that did not come back to the department. Therefore, my lord, when 14th March 2024 matter came here before lordship, your lordship was not informed or intimated that the unauthorized construction had been dealt with and the order has been passed. Then there could be only the communication of the order could be made.
It has been demolished.
Part detention, part demolition order has been passed. By the order of
Why is the mayor in council holding up the file?
Hello?
Why is the mayor in council taking so much time for doing it?
Normally, it was the number of matters goes somewhere or other. It remained.
We can ensure that he does it quickly.
But after that
order,
order,
we can include him as a party to the.
No, but after that order that has been forwarded. We have
It was
got
not
it.
pointed out at the time when the order was passed.
But I could not, Malad, that
You were represented by counsel, Mr. Ghosh.
I was not informed that hearing had taken place.
You have
Now,
to
Malad,
comply.
they also, Malad, they are also duty, Malad, that too, that they participate in the proceeding.
You forget about their duty. You first comply with the order of the
But
court.
I comply. Your Lordship order has been complied with.
What was the order?
Your
What have you
Lordship,
done?
Malad, that they deal with the unauthorized construction. Since the
Let us
order
see the order first. Yes. Yes, please move the application. Where is that order? Which page of the contempt application? Mr. Ghosh, please take your seat. We'll
My
just
lord.
look into the order, then we'll call upon.
My lord.
Yes, where is the order annexed?
Lordship, page number
24th
14
of June.
onwards. For 14th, page number 14 onwards, Your Lordship, of my contempt application.
Fourteen was
My contempt application, Your Lordship.
yes. Page 14 is the direction to file a report.
The contempt application that I have filed, Your Lordship.
This is the contempt. Oh, sorry. Fourteen starts. Yes.
Yes, Your Lordship. Lordship,
What
would
was the
come to
allegation that there was
page
an
number
illegal
16.
construction?
Yes, Your Lordship. It is a flat wherein a club has come up
Yes.
in the ground floor.
Right.
With they have made constructions, and the main case was that they are obstructing the way out. So that was the
They
main
were
thing.
directed to give an opportunity of hearing and to
Yes,
come
Your
to a reasoned conclusion.
Lordship,
Mr.
if-
Ghosh now says that that exercise was completed in 2022.
Lordship comes to paragraph number order point number 15 at page number 17 of your Lordship's order,
Yes.
wherein your Lordship was pleased to direct that in the event there is any perceived violation of law, the KMC shall proceed further and take appropriate steps in accordance with law.
According to you, nothing has been done.
Lordship, the hearing was done.
Yes.
The order was also given. Lordship comes to page number 19 of my contempt application.
Yes.
Last paragraph.
Hmm.
May I read from the bottom line, third bottom line?
Absolutely.
It may be stated that there is a violation of municipal law executed by the private respondent, and hearing is concluded with direction to both the parties to comply with the order of the special officer building dated so and so.
What was that order?
Lordship, demolition was to be carried out, Lordship. I'm just
The
coming. to that.
13th December order, I hope they have annexed to the.
No, I have not
opposition.
annexed to the.
So in the opposition, they must have annexed.
I have not got the opposition copy, Your Lordship.
I think this was order, Malad, in my opposition, Your Lordship, Malad, get it at page, Malad,
No.
24.
You have got a copy of the opposition?
No, I have not.
Why didn't you give a copy, Mr.
No, at the outset, Malad, I told Your Lordship, Malad, by mistake, Malad, it has not been served on him.
Maybe a costly mistake for your client. Your client is deliberately doing, and you have to face the ire of the court, Mr. Ghosh. You must take out a contempt application against your client now.
Pardon.
We cannot shut our eyes.
No,
forever.
of course, Malad,
Cannot shut
Your
our eyes
Lordship, Malad, that is.
You know what the KMC is doing in. You have to face the ire of the court every time. You're at the receiving end.
That's true.
You must do something about that.
That's
Anyway, let us see what order was passed by him.
in 20, page, Malad, 24. Malad, that was, Malad,
Please come to page 24 because let us
in
read it
presence
together.
of both the parties, it was, Malad, order was passed.
Demolition order was passed, yes.
Well, demolition and detention. One part, Malad, demolition, one part
Demolition has been done.
That part, Malad, that is, since it was a subject to, Malad, the subject to, Malad, the order that has been now been approved. Now, after your Lordship, Malad, order being passed, my lord, then the chief manager, deputy, because in due deference to your Lordship's direction, the matter was taken up, both the parties were given notice, because your Lordship directed to consider. Even then, I cannot, Malad, go back to the order. Therefore, I took into consideration, after hearing both the parties, directed to comply with the order.
May I humbly
That is, Malad, that page,
Have you
Malad,
complied with the order
order of the
of 13/12 to 2022
yes,
by
my lord.
demolishing that portion?
Yes, Malad. That direction is, Malad, 9th of June 2024.
Mr. Ghosh, let us be clear on
Just
this.
a minute. Yeah.
This court had directed you on March 13, 2024,
Yes, my
when you
lord.
were represented by yourself. You were
My
there.
lord. My lord.
You had not pointed out that there was a previous order of
Right,
13th
my
of
lord,
December, right?
yes, my lord.
So you are very much there. It was not pointed out, and it was not the fault of anybody that you were directed to give a hearing and take necessary action. If there is any perceived violation, then you will proceed further and take appropriate steps in accordance with law. That means whatever order you take, if there's a violation, you take steps.
My lord.
You in your order, first of all, this itself should be a contempt, because instead of giving a, you have given a hearing, but instead of re-adjudicating on the direction of the court, despite you having not pointed out that there was a 13-12 direction, you rely on that previous order, and you say that that order dated 13th of December 2022, taken by your officer, special officer building, that has to be complied with. We agree to this. That's, yes, you can rely on that. But then what happened? This, you have taken this decision on July 9, 2024.
Now I understand. I'm told, my lord,
13th of December 22 order, there was a demolition. Why didn't you demolish so long? And even after this July order, the court icks you, and then you rely on that order. And from July till we are in December, for these so many months, why didn't you comply?
I am told, my lord, that appeal has been taken, an appeal has been taken out against this order.
You have complied with the order.
I have not complied so far as the that
appeal has been taken out against your order.
Against the order of part detention, detention.
What is the number you have disclosed? Must have disclosed in your opposition.
Yes,
is there any stay order there?
Well, that I have not just ascertained.
Mr. Ghosh, let us be very clear. Even if there is an appeal, the High Court's order is binding. We'll give you 1 week's time to demolish, Mr. Ghosh. We'll take it up next Friday. If it is not demolished within that, your person will
give that in terms of that with the order 13 December 2022.
Do that and come back first, then we'll consider. An affidavit in opposition is filed today in court.
Just your lordship, to inform your lordship, their number is, my lord, BT appeal number 65 of 2024.
BC appeal number?
BT appeal. BT appeal.
BT appeal, yes. 60. BT appeal number? Should have disclosed that in your opposition. Anyway.
Yes, madam.
You have disclosed. Actually, you are pressing from the opposition.
Yes,
yes. Learned counsel. The affidavit in opposition filed today by the alleged contemnor be kept on record. Learned counsel for the alleged contemnor hands over a copy thereof here and now on the learned advocate for the petitioner. Next para. Deprecating the late service of affidavit in opposition on the learned advocate for the petitioner, however, the time for filing reply is extended for a week from date. Next para. Upon being asked, learned counsel for the alleged contemnor submits that the order of this court, to the extent of giving a hearing and taking a decision with regard to the alleged illegal construction, has been carried out by the alleged contemnor in the meantime. Next para. Learned counsel places reliance on an order.
Page number 25.
Dated July 9, 2024, annexed at page 19 of the contempt application, and submits that by the said order, a previous order dated December 13, 2022, passed by the special officer within bracket building, bracket closed, has been directed to be complied with. It is further submitted that when the order under contempt dated March 13, 2024 was passed in WPA 9863 of 2021, due to communication gap, it was not pointed out to the court that there was a previous order of part demolition and part retention of the building dated December 13, 2022. Next para. Be that as it may, even if the version of the alleged contemnor is correct, it transpires that by the order dated July 9, 2024, the alleged contemnor had relied on a previous order dated December 13, 2022, passed by the special officer building. But this is the 5th December order, Mr. Ghosh. 5th December order, page 24.
Page 24 of the contempt.
Oh, it was signed on 13th. Very well.
Signed on
9 July. Signed
Next
on 9
para. Next para. It transpires from the annexure at page 24 of the affidavit in opposition that an order was passed on December 13, 2022, yes, by the special officer building, whereby it was directed that the northern side wall and shift, northern side wall was to be demolished and shifted towards south, and the brick wall on outer periphery of parking space as marked in D sketch to be executed within 30 days from the date of receipt of the order. Push up, insofar as the remaining portion of the building was concerned, comma, the same was allowed to be retained on payment of necessary fees and charges as applicable under section 400 within bracket 1 of the KMC Act, comma, 1980, comma, failing which the KMC was to take necessary action as per the KMC Act. Full stop. Next para. Unfortunately, comma, although the said order was passed by the special officer bracket building on December 13, 2022, comma, that is 2 years back, comma, no action has been taken till date on the same, comma, despite the specific nudge NUDG by this court in its order, which is now under contempt, comma, for the KMC to take appropriate action if there was any perceived violation of law. Full stop. Next para. The reason sought to be advanced by the alleged contemnor for such inaction is that an appeal bearing BT appeal number 65 of 2024 is pending against the said order. Full stop. Next para. However, comma, it is evident that since December 13, 2022, comma, when the order of demolition, part demolition and part retention was passed by the special officer within bracket building, comma, at least for 2 years, comma, no appeal had been preferred. Full stop. Hence, comma, the inaction on the part of the alleged contemnor till date is unexplained. Full stop. Next para. Furthermore, comma, there is nothing on record to indicate that any stay of the demolition order has been passed in the connected appeal. Full stop. Also, comma, the alleged contemnor fails to bring forth before the court any material to indicate that any effort has been taken till date to demolish the portion of the building as per the direction dated December 13, 2022, passed by the special officer building, and stroke or that any payment of necessary fees has been made by the by the person effecting the illegal construction for being allowed to retain the remaining portion of the building till date. Push up. Next para. Thus, comma, although it transpires that the alleged contemnor is actually in contempt in the absence of any justification for not complying with the direction of this court by taking necessary action for demolition in terms of its order dated December 13, 2022, comma, a last chance is being given to the alleged contemnor to comply with the order of the special officer building dated December 13, 2022 by demolishing the northern side wall in terms of the said order as reflected in the said order. Full stop. Also, comma, in the event there is no material on record to indicate that any necessary payment of fees has been made by the guilty party in terms of part B of the said order dated December 13, 2022, comma, the remaining portion of the illegal construction shall also be demolished by the alleged contemnor. Full stop. Next para. It shall be ensured by the alleged contemnor that such demolition work is positively done within a fortnight from date. Full stop. Next para. The matter shall next be listed on December 13, 2024 for passing further orders. Full stop. The petitioner shall file affidavit in reply to the affidavit in opposition, comma, if any, within the said period. Next.
Only submitting certain facts have been.
The parties shall act on a server copy of this order, coupled with the communication of the learned advocates, instead of insisting upon prior production of a certified copy, comma, for the purpose of compliance. Yes, Mr.
Only recording of certain facts and mystery, my lord.
Yes.
Because after the order being passed 13 December 2022, there is a noting, my lord, that order is subject to the approval. That approval came lately, my lord, because it was, I just pointed to Lordship, it was in the office of the mayor. It came, my lord, 28 February 2024. That is the reason, my lord, further steps could not be taken after the order being passed by the
mayor. Is your person.
No, my person, no doubt, but
your mayor.
No,
is an instrumentality of the KMC.
No, I'm not
disputing. Mayor is not someone special.
No, I'm not on that, my lord. That
Your
order.
mayor, you are stopping by one hand what you are directing by the other.
Well, I'm submitting that order could not be communicated because of that reason. At that point of time, after your lawsuit being passed order 13th March, then my lord, issue my lord came into the surface, and immediately the order was communicated on 20th.
Mayor or no mayor, Mr. Ghosh, it has to be demolished.
No, that I'm not, with that portion, well, I'm not, but I'm submitting the.
Regarding the other portion also, if they have not paid the fees as per your direction, your special officer building is the only honest person, it seems.
Yes, after your lawsuit 9th July, my lord, of course, my lord, that if there is no stay order from the tribunal, of course, my lord, the order was.
There is nothing on record to show is there is registered. Why this inaction on your part? Your own order, your own mayor, your own council. Yes, next. You also take steps to communicate this order to the whoever is the alleged.
Definitely.
And Mr. Ghosh is there, he is present. So in his presence, it has been passed.
Item number 17.
Yes.
For the alleged contempt, order has been complied
I am
on the part of the Punjab National Bank.
in the read petition.
My lord, this is a contempt arising out of an order passed by my lord where I was not being allowed to operate my bank accounts, my lord. And my lord had. Huh?
Now allowed.
No, my lord. The unfortunate part is that, my lord, on the last occasion, we were directed to file an affidavit of service, my lord. My lord, affidavit of service may be taken on record. Now, my lord, there are two banks involved here, my lord. One is the Punjab National Bank and the other is the Bank of India. Now, my lord, the Punjab National Bank has been served, and I believe my learned friend is appearing.
Lordship, Punjab National Bank has not yet been served at the address, my lord. We do not have the copy of the contempt application, but having this matter, my lord, getting the knowledge, my lord, I have communicated with the bank and I have been informed that order has been complied by communication dated 17/20/24, my lord. The petitioner was asked to come in the office and to provide the KYC. They have provided, my lord, account has become
What
active.
about the other bank? What was the other bank? You are for the other bank?
No, my lord,
Lordship, I appear on.
We'll come to you. We'll come to you. Yes.
Lordship, I appear on behalf of respondent number 4 and 5, that's Bank of India. Your Lordship, I'll request them to serve a copy upon.
Lord, service has been refused, my lord. They had been served, my lord. The branch, the envelope, my lord.
That's good service. Why should we be served again? Why didn't you comply? What is your explanation?
Lordship, then I'll return with instructions because I am.
Return. Let your client return that.
Lord, as far as my lord Punjab National Bank is concerned, my lord, what I have been given to
Bank
understand.
of India is complying.
No, my lord. There has been no communication,
PNB?
nothing from PNB, my lord. They have written us that please provide us certain documents.
Lordship.
We have, my lord, provided those documents.
And the
Right
account is
now, my lord,
active.
the latest instruction that I have is, my lord, we have applied for a checkbook. The checkbook has not yet come. Once, my lord, we can withdraw funds and operate that account, my lord.
Ask your client to withdraw today and check.
You know, the checkbook has not yet come. We have applied for the checkbook. Once it comes, my
You
lord,
can make online transaction. What is the age of your client? Not it's an institution.
It's an institution.
Do an online transaction and see.
Lord, I do not, my lord, know if online transaction is enabled or not, my lord. They have
You
only.
enable your go to the bank and enable. Anyway, let us come back on that. You are for respondent 6. What is your role?
There is no contempt, my lord. My lord has passed an
My lord,
order.
he is not a contempt.
You're not an contempt. Not a contempt.
Property belongs to me, my lord. I am for the my lord.
In contempt, you are not
There is
deciding.
process, my lord.
In contempt, you are not deciding your property.
They were refused.
Anyway,
My lord,
give a copy to your learned friend.
Thank
No, we won't reopen the main matter, please. In contempt,
Paragraph 16
you don't have a right of hearing. Even you are not.
Paragraph 16 of lordship order.
They have also committed they are alleged contemners.
No, my lord, they are not
No.
treated as a contempt.
You don't have any right.
My lord had directed on the last
If, my
order
lord,
to
this may
serve
be
them. My
taken
lord,
on
we have
record
served
in
them.
order to show that the account is active.
At the outset, learned counsel for the petitioner submits that service on the Bank of India has returned as refused. Full stop. Next para. Insofar as the Punjab National Bank is concerned, the said bank acted in terms of the order to an extent, and it is submitted that certain documents were asked to be produced by the petitioner. Full stop. Upon the petitioners having done so, the Punjab National Bank has been acting on the same. Full stop. However, till date, no checkbook has been issued. Full stop. Next para. Learned counsel for the appearing for the alleged contemners representing the Bank of India seeks a copy of the contempt application. Full stop. Next para. Although in law, good service has been effected on the Bank of India, for the ends of justice, the learned advocate on record for the petitioner is requested to hand over another copy of the contempt application on his counterpart appearing for the Bank of India on his counterpart appearing for the alleged contemners pertaining to the Bank of India during the course of the day. Full stop. Next para. Learned counsel for the respondent number 6 in the main writ petition
One paragraph of your lordship order.
seeks to argue on the entitlement of the petitioner as regards the said contempt application, puts up next para. However, comma, this court is of the opinion that the respondent number 6 cannot, comma, being not a party to the contempt application, comma, reopen the merits of the main matter in connection with the contempt application.
Paragraph 60 of your lordship order.
What was there?
The operation of the accounts in the meantime shall be subject to outcome of the writ petition. These two accounts, they are operating other accounts, my lord.
My lord, in Punjab, my lord, in Punjab National Bank, there are only two accounts, my lord, which are being operated by the petitioner.
So, moreover, comma, the writ petition is pending. Moreover, comma, since the writ petition is already pending, comma, the matter is sub judice before the court taking up the writ jurisdiction at the present moment, full stop. As such, comma, the respondent number 6 cannot be heard on the contempt application at this juncture, full stop. In any event, comma, no orders are being passed on the merits of the writ petition and or touching the previous orders passed therein. Full stop. The present contempt application only pertains to the alleged non-compliance by the alleged contemners of the order already passed by this court. Full stop. Next para. Next para. As such, comma, it is expected that the alleged which contemner pertains to Bank of India?
My lord, contemner number 2, my lord. But, my lord, if I may point out one thing, my lord, honestly, there has been, my lord, a typographical error in the contempt petition, my lord. It has been inadvertently typed as Indian Bank, though it should be Bank of India. If my lord kindly grants me leave, my lord.
Your service is not proper.
My lord, it has been served on the Bank of India. My lord will kindly check the envelope, my lord. It's a
next para.
typographical error.
At this juncture, comma, learned counsel for the petitioner fairly points out that in the contempt application, comma, instead of the Bank of India, comma, the Indian Bank was named as the entity where the alleged container number 2 is in service. Full stop. Next para. Be that as it may, comma, it is submitted that the service of the contempt application was sought to be effected on the Bank of India itself. Full stop. In view of the above direction to serve a copy of the contempt application on the learned advocate appearing for the Bank of India, comma, it is expected that the alleged container number 2 shall also comply with the order of this court at the earliest. Full stop. The matter shall be listed next on December 13, 2024 under the same heading for passing further orders. Full stop. Affidavit in reply, if any, shall be filed by you have used an opposition.
Lordship, we are complying.
Very well. The affidavits of compliance shall be filed by the alleged contemners on the next returnable date with advance copies to the learned advocate for the petition.
My lord, one leave, my lord, if I could file in a notarized manner, your lordship, because the manager is in Patna, my lord. If leave be granted by your lordship,
2 weeks time.
2 weeks time, my lord. As your
Affidavit
lordship
compliance
please.
on 13th of December. We are on 29th.
Lordship.
2 weeks.
Lordship.
You take back these documents, Ms. Rachudri, you will annex those to your
As your
compliance.
lordship please.
Lord, and the affidavit of service may kindly be taken.
We have stated that. Next.
That amount will be siphoned off, my lord.
Nothing else. Yes, next.
Number 18.
18, what happened?
It is up for final hearing, my lord. I am supposed to mix up. Well, I have circulated a copy of the notes
yes.
to Mr. Chakraborty. May I file my notes?
It's not a contempt matter.
Unfortunately, no.
But I may be at the receiving end.
Habit of issuing.
But I may be at the receiving end, my lord, at the end of the matter.
Yes. Mr. Chakraborty, this is the ideal size of the written notes you will file also.
But we have already filed.
You have already filed?
Yes, my WBST DVC is the last.
And this is your...
Yes. No, judgments are annexed. Notes are...
Yes.
No,
Mr. Mojumdar, you had already filed a...
He had filed 2 notes, in fact, subject to correction.
WBRC's respondent number 3.
Oh, একটা দুটো note filed.
You are respondent number 3.
Yes.
Oh, WBRC, this is your... Yes, very well. So commensurate with counsel.
Yes, my lord.
One second. These are additional preliminary written notes of arguments. What are these? Just sort out. Let me sort out. This is your copy of judgments, Mr. Chakraborty, the petitioner.
Yes,
Well, I will,
And this is an additional preliminary written note of argument on behalf of the petitioner.
one page, my lord, I had taken a leave, my lord had granted the leave.
This will also be a part of
Yes,
your
yes,
written
yes.
notes. So these are your written notes.
Written.
Mr. Dhar has already filed this written note, and this is your written notes you're filing
Yes.
today. Yes. So what do you want to add? You already filed your written notes.
Yes, sir, I have completed.
Very good.
Nothing to add.
Yes, Mr. Mujira, please come.
my lord will kindly take my notes.
Yes.
I'll go by my notes. Well, first, একটা প্রতীককে দিয়েছো notes? Lordship will find, my lord, there are two print of challenge, my lord, if I may say so. My lord, one is the constitutional validity of regulation 4.4 of WBERC terms and conditions of tariff regulations 2011, which your lordship will find at pages 76 and 77 of the writ petition. And secondly, my lord, demand on account of restricted drawal as specified in bill dated February 2, 2023, which is at page 62 of the writ petition. But for that purpose, my lord, first, my lord, may I take your lordship to the, my lord, the power supply agreement which the petitioner had entered into with DVC.
Mr. Mujumdar, if they win the first point, then the second point they win automatically.
And if they win the first point, they will not succeed in the second point.
Achha, independently also you have something there.
Independent, because that is a factual. My lord, your lordship may recollect on the last occasion, my lord, no statutory provision or no provision as such can be held to be unconstitutional even if simply for the reason that it can be misused or abused.
No, Mr. Mujumdar, suppose they win on the first.
Suppose they win on.
Validity of 4.4 is.
Then it is gone. Obviously, I'm so sorry.
Yeah, that was my question.
My lord, apropos, my lord, I'm so sorry, my lord, I stand corrected.
Yes.
So, my lord, do I address on the first point first or second point first?
No, you address both because we are hearing the
yes, my lord.
The entire thing.
My lord, what I have done, I have dealt with both the points.
Yes, don't take a chance. Even if you win on the first point, then also the second point remains. Otherwise, also.
No, it doesn't remain.
Achha, automatically.
If I win on the first point, the second point.
So it's entirely interconnected.
Interconnected.
Very good.
Yes.
Power
May I just take your lordship firstly to the agreement. My lord will kindly take the agreement which starts at page 46. 46 of the writ petition.
Yes.
Now, if your lordship kindly take clause 3 of the agreement.
Clause 3.
May I just read out clause 3?
Please.
Electrical energy. Sorry, first, my lord, the recital. I'm so sorry, my lord. First, the recital.
Yes.
My lord, kindly take the recital, only this part. The second one, and whereas. And whereas the corporation has agreed subject to availability of power to supply such energy and continue to supply such energy to the consumer for a period of 5 years as the first block from the date of commencement of power supply. So, my lord, supply would be subject to availability of electrical energy. That's a written clause. Then, my lord, kindly read it along with clause 3. Which your lordship will find at page 49. Electrical energy supplied to the consumer by the corporation shall be on 3-phase 50 cycles alternating current AC system at normal pressure of 132 kV. The frequency, harmonics and pressure of electrical energy at the point of supply to the consumer shall be subject to the variations that are ordinary, usual and incidental to generation and transmission of electrical energy, but such variation shall not except owing to extraordinary reasons beyond the control of corporation be more than those permitted by the Indian Electricity Rules 2005 or any other statutory modifications thereto as may be enforced from time to time. So, my lord, so this is the terms under which I make supply of electrical energy. Now, kindly come to clause 24, page 59.
Yes.
The above agreement is subject to the provisions of Electricity Act 2003 and regulations, the consumer agrees to pay all the charges payable in accordance with the regulations and the schedule of charges of the corporation.
Yes.
So, Malad, these are the obligations, duties and obligations of the corporation, I mean DVC, and also the consumer. So, Malad, in this backdrop, Malad, kindly take what has happened actually factually. May I take your lordship? Well, it is a matter of fact that this fact is not disputed by anybody, that maintenance work was carried out by DVC on 5th January 2023, 6th January 2023, 10th January 2023, 11th January 2023, and 21 January 2023. So, there were on 1, 2, 3, 4, 5 dates, this kind of maintenance work was carried on. For that, during that period, restricted drawal was imposed, that the consumer cannot consume electricity or consume power beyond the restricted drawal as specified by the corporation.
Yes.
Question arises is that whether the consumer was given sufficient notice or not. If the consumer was given sufficient notice, the consumer should have arranged his affairs accordingly, because what is most important is that this is a case of private interest pitted against public interest. They are there to manufacture, carry on their manufacturing activity, and obviously they are entitled to make profit out of their business. There is no doubt about it. Nobody has any cavil to that commercial principle.
Yes.
But whenever that commercial principle is pressed into service, one must have regard to the national grid, the maintenance of the grid. So if you want to, if a consumer wants to consume electrical energy beyond the restricted drawal and carry on with his manufacturing activity as specified or as planned, then certain additional charges are to be paid during this period. You make profit, but you have to, one has to pay for that. That is the condition imposed. Because otherwise, if the consumer had complied, at least substantially complied with the restricted drawal, he would not have been subjected to this kind of charges. The total hours for which this restricted drawal period was violated by the petitioner is about 51.75 hours in total for these 5 dates. Now, kindly come, now, I am answerable to your lordship that whether I had given as a supplier, as a service provider to my service recipient the adequate notice that you arrange your affairs accordingly. Kindly come to paragraph 7A of my affidavit in opposition. Page 6 of my affidavit in opposition. I have to place this paragraph. This is very important. Because, my lord, even if, even if we succeed, even the petitioner fails on the first issue, I am answerable with respect to the second issue. Kindly take, paragraph 7. This shutdown was necessitated by reason of winter overhauling maintenance by Mejia Thermal Power Station to Barjora. A request to this effect was sent by Mejia Thermal Power Station to the concerned authority in the transmission department, and the permission in that regard, I'm so sorry, my lord, was obtained. The permission sought for and obtained was for 5th January, 6th January, 7th January, 10th January, 11th January, 21st January, 31st January. The supporting mails in this regard are annexed here to and collectively marked as Annexure R1. Remember 7A. These are the details of the maintenance work.
Mejia is another consumer.
No, Mejia is thermal power, MTPS. That's a thermal power. That is my thermal power station. Now, your lordship will find these are the details of the maintenance work which was carried out during these 5 or 6 periods.
Yes.
Date-wise. The table ends at page 8. My lord has seen that.
Yes.
So, my lord, now kindly take from page 8 onwards. Hence, around 100 megawatt load needed to be regulated to maintain healthy power flow through the other line If one of the 220 kV transmission is under repairs or shutdown, then the maximum load of 590 amp is required to be maintained to avoid overloading, conductor jumper failure in line. So to maintain constant supply of consumers and to avoid load shedding, it should be or load shielding load restriction, and it may be a technical term, my lord, was imposed upon 132 kV consumers who are supplied power from Bajora substation. Bajora substation is the distribution point, and Mejia thermal power station is the generating point. It is to be noted that all other consumers who were under the load restriction 7 except the petitioner had adhered to the load restriction imposed by DVC. Pausing here for a moment. The petitioner in his affidavit in reply points out certain instances that in these cases also you were lenient. I was lenient. I have in my rejoinder, because these points were taken, new points were taken, I am rejoinder explained that in those cases the compliance was substantial, and we have given details therefore. Now, my lord, kindly take it is to be noted that all other consumers who were under the load restriction, 7 except the petitioner had adhered to the load restriction imposed by DVC. On every occasion, when the load restriction was imposed by the licensee, the representative of the petitioner was informed over telephone about the load restriction to be imposed by DVC. Now, my lord, kindly come directly to page 61. This is the communication which was given. Telephonic communication, my lord. My lord will kindly take for my lord on 4th January, it was intimated. 5 and 6 and 7 were the shutdown days. I mean, for certain period. Then 9th January, another intimation was given. Again, 10th January was, I think, 10th and 11th. Your lordship will find the last column. These are the dates of load restriction and these are the dates of communication. Now, my lord, your lordship will find for 9 January, on 9 January, it was communicated about 1942 hours. And the load restriction was on 10th January and 11th January. Then, my lord, on 19 January at about 19:05 or 7:05 p.m., again for road restriction on 21st January. So, my lord, in my most respectful submission, subject to your lordship's kind consideration, adequate notice was given to the consumer to arrange his affairs accordingly, but the consumer decided to, my lord, continue with the usual power arrangement and defied this kind of, my lord, what should I say, restricted drawal or a drawal lockdown. Now, my lord, kindly take, my lord, along with this. This is, my lord, my page 61. So, my lord, my case is that at least 10 to 24 hours notice was given in each and every case. And in total, 51.75 hours. For 51.75 hours, the petitioner consumed electricity in excess of the restricted drawal imposed by DVC during this period. You want to say something? It's a time restriction. Your lordship will find the table also speaks about the time restriction. My lord, this is কোনটা যে দেখাচ্ছ? ঠিক আছে. My lord will kindly along with this, my lord. I'm sorry, my lord, I should have pointed it out. Page 60 also. I'm so sorry, my lord. I'm so sorry. These are again, my lord, the details.
What is percentage, LR? The first, second column?
Percentage of load restriction. LR is load restriction, my lord. So, my lord, adequate notice was given as would be evident from page 60. My lord, now the petitioner files an affidavit in reply. My lord, kindly take the petitioner's affidavit in reply at para 13.
Yes, 13.
Just 1 minute, my lord. Yes, para 13, if your lordship kindly takes. With reference to the statements made in paragraph 7A of the said affidavit, 7 except what are matters of record, all allegations contained therein are denied. the petitioner denies that any maintenance work was done in respect of line 230 and 231. It is denied that if one of the 220 kV transmission is under repair or shutdown, then maximum load of 590 amps is required to be maintained to avoid overloading, connector jumper violation in the line. It is denied that to maintain constant supply of consumer to avoid load shedding, load restriction was imposed upon 132 kV consumer who has been supplied power from Barjora substation. It is denied that the petitioner other consumers.
These are WhatsApp calls, Mr. Mujumdar? Regular calls or WhatsApp?
Regular calls.
May I just say one
But they've annexed the phone bills.
Yes, man. What they have done? What they have done? These
One
are
sentence.
outgoing
I had-
call registered.
I had in the first day said it was a mistake on our part. We had accepted in the first argument.
What was the mistake?
My lord, it was a mistake, my lord. We had received the calls. But I had said that in the first day, the call issue cannot be, we cannot raise
Well,
this.
if the call issue goes,
Well,
well,
we-
then
You are intimated by them.
Well, by phone calls. Well, I had said that by phone calls.
I have
Well,
forgotten that.
Well, difficulty is by phone calls. I cannot prove what was said. Difficult. That is the difficult part. My lord would appreciate. Someone has
filed any rejoinder to this or something like
They
that.
have filed. My lord, we had.
What is
My
that
lord, I had said I had contested.
I'll
this-
definitely forget what you said
Well,
now
I
today
may-
also. So
I
there
had-
must be some indication in some of your pleadings.
It was not because after rejoinder, when they had pointed this out, we did not use any affidavit thereafter. My lord, I had said specifically submitted on instruction that we are not contesting this particular issue. I have said this.
I don't recollect at all.
Mr. Dhod was possibly there. Mr. Mojumdar was not there.
God's memory I know is as good as
But I had specifically, can you take
he
this?
will also not remember.
My lord, kindly record this.
We have to bank on Mr. Mujumdar. If he
No,
does not remember, nobody
My
remembers.
lord,
I was not there.
Mr. Agarwal
Gone.
was there.
Gone.
My lord,
Mr. Dhod won't remember.
My lord,
Mr. Agarwal, I
believe
said,
he
my
was-
lord, my lord, kindly record this today, my lord, because the issue
Yes,
has
I have to record it here.
Yes, my lord, kindly record this intimation.
But it has. Well, Mr.
My junior says that he made this up.
My lord, I
Well, have to be a
specifically-
man, I'm officer of the
No, we are not blaming him.
No.
But it has to be on
My lord,
somewhere.
my lord,
Otherwise, this will not be reflected.
because
in
my
my
lord,
judgment.
in my
And I may hold in their favor also in
No, no,
regarding
my lord,
phone
in
calls.
my
I was inclined to do so actually.
no, my lord, in my
Because I was not convinced about your phone calls
my
unless
lord,
they-
in my argument, my lord, I have stressed on the validity of the virus of the action, my lord.
phone intimations are admitted.
My lord, on instruction.
I won't
So
write
far
that.
as, so far as I am concerned,
Chakravarti, because you are the officer of the court, you are submitting.
Yes,
your
my
report.
lord, yes.
After I'm taking down your, you
No,
get.
no, my lord,
Why
my
did
lord,
you add on instruction
lord,
afterwards? You are very confident before that.
no, my lord, but how do I did not receive the call.
Mr. Tanay Chakravarti, on today we are on 29th of November 24.
But I specifically
So
submitted.
whatever is-
Don't waste your time.
so I'm
So
not.
you had phone over the
So
phone.
I
you did.
had given them inadequate notice.
Yes.
End of the matter.
My-
So my lord, now
Adequacy is not
No, my adequacy have not
timing. He's admitting.
my lord, adequacy.
sufficient time to arrange their affairs.
Should have informed them 1 year back.
So my lord, had they should have pointed it out in our affidavit in the reply.
Forget that.
We forget that. My lord, we
He's
forget.
admitting the times and the hours of your calls, and he's admitting the phone calls.
Yes, ma'am.
And intimation also.
And intimation. Now, my lord, now kindly come to my lord the validity part. Then my lord, this phone call part, my lord, I have
So you had intimated, but still they flouted 51.50 hours.
5-7 hours.
For-
5-7-5 hours.
75.
51.75
Oh,
hours.
acha, acha.
51.75 hours, correct?
Right. Yes.
I'm sorry, my lord. Total restriction was for 51.75
Total
hours.
for about
51
51.75 hours of restriction. The
Out of which, my lord, they flouted for about
51.5.
50.
So they failed to flout only for 0.25 hours.
0.25 hours.
Yeah, good performance. Yeah. Yes.
So, my lord, this part, my lord, I have made my submission.
So now on the
Validity part.
meat of the matter.
Yes, my lord.
Yes.
Let me address it. My lord, I will be taking a stand slightly different. Permit me to do so.
From Mr. Dhar.
Yes, my lord. because
Slightly. You have to argue contrary to the WBRC.
That is, my lord, I have to do that, my lord.
Yes.
But my lord, since the regulator has taken a stand, my lord,
No, that's their interpretation.
that's their
Definitely.
interpretation.
But
My
that is not
interpretation-
final on that also.
That my
It's like a good poetry. It's the writer's interpretation, but that does not matter. I mean,
my
critics
lord,
can
will
also
kindly
change.
take the later part of my note.
Yes.
The portion Provisions of Electricity Act and Regulations 2011. That's at page, what page number page এটা? Page 4. Page 4.
Page 4.
So my lord, regulation 4.4.
Yes.
So this is the regulation which is now the subject matter of challenge. If in a 15 minutes time block a consumer
No,
draws,
you are placing from page.
my lord, page 4.
Page 4, which paragraph?
My notes, my notes. I'm
Yes,
sorry.
your notes.
Page 4, under the head Provisions of the Electricity Act.
The head has gone in the previous page, the last.
Right.
Yes, because it's not.
I'm sorry, I'm sorry.
আমার আছে আমার কাছে ঠিক আছে জাস্টার কো তোমরা দাওনি ঠিক
No, your head is at the proper place.
Yes.
My head has gone to the tail.
Yes. But that is the mistake with
No difficulty, but give me the paragraph number A, B, C. These are.
This is paragraph A and B. I'm starting from A and B at page 4.
In exercise of the powers.
In exercise of the powers conferred by subsection 1 and subsection 2 of section 181 read with sections 41, 45, 2, 51, 62, 63, 64, 65 and 86.
A and B are statements. You're reiterating what they've said.
Yes. Now
come to C
from
executive
C
policy. That is the
yes. What the petitioner seeks to question is the executive policy behind regulation 4.4. On the ground that the regulation does not define restricted drawal and vest the distribution licensee with an uncanalized power to impose restricted drawal and saddles the consumer with additional energy charge at a rate twice the applicable rate for that consumer at that time block. The additional energy charge so levied for violation of restricted drawal in my respectful submission is regulatory in nature. This is the first submission I'm going to make, that this is a regulatory provision.
Regulatory provision, so what? I mean,
regulatory provision is not akin to penal provision. Regulatory provisions are generally incorporated in the statute, or there may be regulatory statutes also.
Even then, there has to be proportionality and rationality.
Yes.
Like
absolutely, this is the key which I am to address your lordship, because I am relying on a judgment which says that whenever a virus or a constitutionality of provision is challenged, one has to also address the issue of proportionality.
Mr. Mujumdar, you mean to say this is regulatory as opposed to penal?
As opposed to penal. And my lord, there is a what should I say? There is a fine balance between
literally fine balance.
Fine balance.
If you lose the balance, you have to pay a fine.
No, my lord, between the needs of a consumer,
yes,
the commercial needs of a consumer, and my lord, the overwhelming or the supervening public equity.
Yes.
Because my lord, there may be 20 consumers or 5 consumers or 3 consumers
definitely
with 132 kV energy supply.
Absolutely, yes.
Now, my lord, to protect the interest of the community of consumers as such, my lord, the individual interest, my lord, has to make way.
True.
To some extent.
Yes.
Well, it is not a case of load shedding for 51.75 hours. Well, that would have caused irreparable loss and injury to the consumers as a community. It is a case of imposing a restricted drawal that you arrange your affairs accordingly, and so that everybody can carry on their manufacturing activity, but may not be with full vigor, maybe with a lesser target.
But Mr. Mujumdar, you are being given the uncharted license by the WBERC.
Because why it is necessary?
After you have agreed to a contract demand, that is also to be kept in mind.
The contract demand is there.
While you fix the contract demand, Mr. Mujumdar,
absolutely,
you have to take into consideration these aspects
contract demand
also.
is there. Absolutely. That is why I read the recital, clause 3 and clause 24. My answer to the contract demand would be clause 3, clause recital, the second recital, clause 3 and clause 24 of my contract with the consumer, which says that I will supply power to my consumer subject to the availability of the electricity.
Yes.
And he has agreed to that.
That is the justification, the ratio behind the contract demand.
Contract demand.
But yes, if you don't have that supply, you cannot supply, we can understand. But you are imposing a fine.
My lord, I cannot supply. My lord, kindly, this is where, my lord.
But this has to be read with the contract demand. You have to keep on a minimum
Yes,
supply.
I have to mean that I kept a minimum standard.
Otherwise, you should pay them.
I kept a minimum standard. I kept a minimum standard that look, for this period, you will be allowed to draw power at this rate. But
Mr. Majumdar, let me put it this way, in a
Right.
different way, against you, obviously,
Certainly,
because
ma'am,
you are
certainly.
arguing.
I am to answer.
Now, if you fix a contract demand, I am speaking from a layman's term and I am a layman in electricity. A contract demand, that means that you have to keep up that supply minimum, right? So when you fix that level, you have to take into account the grid situation, what may be somewhat prospective. You have to be somewhat prophetic that this might happen up to a limit. Upon that, you fix that contract demand and you agree with them. If you can't meet the contract demand, you have to compensate them.
My lord, may I just answer to your lordship's query straight away? My lord,
I'll add one sentence. If there is a supervening impossibility or an act of God, as you say, or some accidental failure, then we can appreciate.
Right.
That clause must be there somewhere in your power supply agreement. Otherwise, as a routine matter, you can then this can be a license to
My lord,
you to do
kindly
this, to
visualize
flout the contract demand.
These are the maintenance works which are necessary for supplying energy.
But is the statutory or regulatory requirement on you to justify your
My lord,
reduction
may I
with
just
that?
answer to your lordship straight away, one by one. My lord, as the questions have
Yes.
been raised. My lord, may I just answer first question first? My lord, there is a contract demand. There is a contract demand that contract demand or the contract would be, we can get the contract demand from the power supply agreement. That is the 132 kV electrical energy I have to supply. The power supply agreement also has certain conditions which are, my lord, which are provided for in the contract itself. The one of the condition is that I will supply power to you, but there may be certain interruptions or subject to the availability of the electrical energy as the recital clearly says so.
But that recital, does it counteract, does it negate the contract demand?
It does not negate the contract demand. Well, let's suppose, take for instance,
yes,
there may be cases of load shedding, my lord. There may be cases of load shedding. Kindly take clause 4.3 of the regulation. Regulation 4.3 both. তাই না? Right. 4.3. Yes, my lord, 4.3.6.
Where is it annexed? Just
it is page 79 of the writ petition, right? 4.3.6.
Yes, 3.6, right.
Well, no demand charge shall be payable by any consumer for that period when the load of the consumer is interrupted, totally shed, partially restricted because of any fault of any licensee. But this is not a case of fault of the licensee. So the regulations are clear.
This is something different.
But this is, my lord, we have to see the entire regulations as a whole. My lord, how the regulations evolve. First, it addresses the issue of load shedding or my lord, some kind of, what should I say, the partial restriction on account of fault of the license.
All right. Yes.
But this kindly now take, my lord, then there is a method of computation. That how it is to be built.
Yes.
Your lordship has seen that. Kindly take H1. This is the duration for the incidence of interruption, total shed, total part in supplying, which is not considered as per this regulation. So this is the protection which is given to the consumer in so far as there is a deficiency in supply. If I may use the term deficiency in supply to the consumer during the contract period. Nothing more. Then কি বলছো? For to the extent
if you
of
can't supply, they won't have to pay.
No, to the extent of restriction.
You're protecting them from yourself. If you don't supply, they obviously don't have to pay.
What we have done for the period for which this restricted drawal was imposed, we have not imposed any demand charge, contract demand charge to the extent of this deficiency. Suppose, my lord, for defi for a
But you
for-
defy the contract demand itself by reducing the load which they can
my lord,
consume.
this is an exigency, my lord. This is an
That is what is missing
this is
from
an-
their regulation.
This is an exigency.
That is what is missing.
Well,
What kind of exigency? This objective exigency has to be there, this sort of exigency, so
Yes.
that there is some transparency. Otherwise,
Some
you can do it
transparency,
at
my
your
lord.
own will.
My lord, if I may say, if your lordship kindly reads 4.3.6 once again with me, subject to your
Yes.
lordship's kind consideration. No demand charge shall be payable by any consumer for that period when load of the consumer is interrupted, totally shed, partially restricted. My lord, kindly take note of the following words.
Yes.
Because of any fault of the licensee, when it is the fault of the licensee, obviously,
or non-availability of power with you.
With the licensee due to lower availability of power from its own generating station or other suppliers
or its system,
or its
because
system
of any
or
fault of the licensee or its system,
system.
or for non-availability
Of
of,
the
power
power
supply with you, with the licensee.
With the licensee.
So you don't have available power supply.
Yes.
For that, you will not charge them.
We have not charged that.
But you are reducing on the same logic.
We have
That it's not.
reduced, we have charged on the reduced quantum. We have not charged on 132 kV. It is nobody's case before your lordship that
Obviously, if you don't supply, you can't charge for
we
that.
can't charge.
You
But
can't.
it is not a charity.
It is not a charity.
It is not a charity.
4.3.6. Even if it was not there, courts would have interpreted. If you don't supply, Mr. Mujumdar,
yes.
Let us forget what courts would do. It's there. It's fair. It's very fair.
There is no charity, obviously.
But it's fair. You are right.
Yes.
If they don't consume, they don't. If you can't supply, they don't pay.
We don't charge.
But why should they pay you if you reduce arbitrarily?
Then the question would arise whether I have, in the facts and circumstance of each case, arbitrarily invoked 4.4 and imposed a period of restricted
No,
draw.
Mr. Mujumdar, your argument was at the inception that just because somebody has abused or there is a chance of abuse, it cannot be a ground for striking down. But now you are doing a volte-face.
No, I'm not doing
because you are saying that I have not abused it, therefore it's valid. No, not that. The question is the potential of a particular regulation to be abused. That is what is to be seen.
The potentiality
or
of-
the arbitrariness which is delegated to you.
The arbitrariness which is delegated to me or the discretion which is left with the licensee. Well, let us not use the term arbitrariness
Very well,
for the
discretion.
time. The discretion which is vested with the licensee is a discretion which is warranted in these kind of situations where, my lord, the licensee or the distribution where it involves, my lord, generation and distribution of power.
But you give it a stamp of validity because, Mr. Mujumdar, you cannot supply.
Yes.
Because for whatever reason, if you cannot supply, you cannot meet the contract demand, then you have to pay. You should pay them because you are not meeting the contract demand. Here it's a reverse. You are saying that I can reduce the amount which I would supply. And if they don't comply, that reduction can be contrary to the contract demand, Mr. Mujumdar.
Right.
And there is no ground on which you have to do that. It can be any and every ground. Because no, the regulation does not provide.
Right.
You can tomorrow say every day I'll ask you to reduce and you flout the contract demand by that, and they will have to pay if they flout that, if they go above that.
I have understood.
I mean,
your
this
lordship.
is impossible logic.
Whether the provision is wide enough to, my lord, invite situations of arbitrariness.
Not only that, yes, right, but you are curtailing your contract demand concept entirely. You agreed to them that I have to give this minimum supply. We can understand if under duress, under certain conditions, you cannot supply, you don't take payment for that.
For maintenance work.
Instead of you paying them, you reduce and ask them to pay.
Let us take of any consumer, forget about an industry. Let us take a consumer in the streets of Calcutta. My lord, often, but nowadays there is no load shedding as such. Thankfully.
Less, very less.
Very less. But sometimes what happens, for 1, 2, 30 minutes, 20 minutes, 40 minutes, immediately we get an SMS from our supplier that there is a maintenance work going on. So bear with us for 30 minutes or 40 minutes. The power will be restored in another hour or so.
Precisely so. You don't get the supply during that period.
I don't get the supply. I don't have to pay because I am not
getting the supply.
I am not getting the supply.
Right.
Similarly, kindly take the situation of a consumer, but we also have a contract demand. We also have a contract demand which is reflected in our electricity bills.
Is it? I have never seen.
Absolutely, my lord.
Is
In
there?
fact, if we have 5 ACs or 6 ACs in a residence, we are required to apply for, my lord, the higher wattage. Say for example,
But does the licensee agree that they will supply that minimum amount?
absolutely, this is the contract between us and the licensee.
All right.
For
I've
every,
never seen the clauses.
my lord, any bill, your
The
lordship may pick
litigation
up.
comes, I'll see.
My lord, it may come, my lord, because these litigation generally goes to the, my lord, the GRO or the ombudsman,
Obvious.
whatever. My lord. These litigations do not come to the court. My lord, here we have a case that restricted drawal has been imposed. We have given a justification. My lord, I am not going into the facts of one case. Let us, if, my lord, if restricted drawal, this provision can only be invoked, my lord, in case of exigencies, in cases of, my lord, maintenance, my lord, it cannot
That's
be,
not provided in the
my lord,
regulation.
it may not be provided. My lord, this amount of discretion has to be left with the licensee. This is my respectful submission.
The amount of discretion you're asking for, Mr. Mujumdar, is to choose the goalposts after the game has begun.
No, my lord, the amount of discretion which I'm asking for,
You
from
can
your
choose the yardsticks.
lordship, my lord, I'm asking from your lordship is that suppose this is the discretion left with any distribution license. It is left with all the distribution licenses within West Bengal. It may be WBSEDCL, it may be CSC, it may be DVC. Right, my lord? There is no difficulty. Now, my lord, when a case arises like this, that restricted drawal is imposed by one distribution licensee, and the consumer is agreed, but this is not a justified reason for which restricted drawal could be imposed.
Suppose you do it at your whims.
At
What
my
is the
whims.
protection? Yes.
Protection is that the matter has to go before the GRO, and the GRO has to decide, or the matter has to go before the WERC, which is an independent authority. WERC is the author of the regulations. So WERC is,
this cannot be a justification. I mean, unfettered discretion is given to you to do it without any reason justification. And your solution is that they will have to make a complaint and get it adjudicated at their cost.
we have to make a complaint, register a complaint. My lord, it's not that in every case bills are raised. Bills may be paid, may not be paid. At
Complaint redressal system is not a remedy.
The
It's not a,
complaint
a
redressal
deficiency in the statute cannot be, or the regulation cannot be cured like that.
My lord, suppose, my lord, every case, my lord, if this discretion is taken away from the licensee,
It's inbuilt, the
if
arbitrary.
this discretion is taken away from the licensee in these
Yes.
kind of situations, when these are, my lord, public utility services, my lord, which
True.
there is no.
You have to protect your grid.
I have
can
to protect
appreciate
my
that.
grid. My lord, if then every time a consumer, a distribution licensee decides to enforce this kind of this regulation 4.4, he has to give a pre-judicial hearing to the
Mr. Mujumdar, there can be a better option also.
Right.
There can be in the regulation itself, there can be a rider that these are the scenarios where you can
Well,
do
can it be
And the
exhaustive? I put the question to myself.
We are telling you,
Yes.
the WBRC is the best judge for that.
Yes.
I mean, regarding the science behind that.
Right.
Now, you have to, what is the basis of your doing it? Tell us, give us one justification. Why are you doing it?
In my case,
Yes, in your case, suppose.
maintenance.
Or give us two or three, at least one reason. why.
Maintenance, my lord, then there may
This
be
maintenance is very vague.
no maintenance. We have given the specific.
For maintenance, you have to shut down the grid.
No, for maintenance, my lord, we have to shut down one line.
You have to shut down one line.
There may be 220 lines. We have
So
to
there
shut
can
down
be a
one line.
mathematics involved, Mr. Mujumdar, which will say that if the shutdown involves such and such wattage or voltage or whatever kV,
Well, that's technical.
then it can be proportionate. Then that much reduction can be done.
That is what we have done.
You have done, but the regulation does not mandate you to do it, Mr. Mujumdar. Tomorrow you cannot do it also. You may not do it.
My lord, that
You
is
can just say reduce it by 10.
My lord, the question would arise.
That is precisely what we're doing. That mathematics has to be there. That this for 20% or such and such, or this much load, there will be a chart, there will be slabs.
Your lordship is in that under those circumstances, your lordship is of the view that some kind of formula which is for 4.3 should also be there for 4.4.
Yes, more than a formula. Specific yardsticks. When
Well,
tariffs are
I tell
determined,
you,
Mr.
Lordship,
Mujumdar, when tariffs are determined, you have to undertake a much fine exercise, much
Right,
elaborate
right,
exercise.
right.
You as well as them.
Right.
Why shouldn't it be put in the regulation?
Well,
I mean, just let there be a proportionality that this much load will be These are the grounds, 2 or 3 grounds. One is maintenance.
Right.
Maintenance, suppose the this much load is, the difference is this much,
right.
then it will be reduced by this much for each consumer, divided by the number of consumers or something like that. And another ground may be supervening impossibility. If there's an accident, then the entire system has to be shut down. That you need
But
not reduce
suppose there
it.
is a case of
It will
blackout.
stop.
It's a blackout.
Blackout, the entire supply stops, they don't have to pay.
They don't have to pay.
So blackout is not such a scenario. Reduction is only at your discretion. And you have to give a justification for the
My
discretion.
respectful submission.
They
to
have
your
to
lord.
put those
I
justifications.
have understood
only
my lord,
that.
whatever has fallen from my lord. I have understood that. Then in that event, my lord, your lordship is it's a kind of ironing out the creases in the legislation.
You may say that, yes.
Because if we
Yes, you
go
may
through
say
that the Lord Denning's judgment of Seaford Estates, where ironing of the creases was done.
Yes.
But later on doubted in Mayor and
No, Lord Denning himself says, as in our administrative law book, remember, I may be always wrong, but
yes, ironing out the creases is there, my lord. Ironing out the creases.
we don't intend, we are not experts. We don't want to iron out the creases ourselves.
Right.
We want to, I mean, we can.
Then, my lord, this gap filling
They have to do it. The
if it is
WBRC
a gap
has the
filling
authority.
exercise. Now, let us presume for the time being that this regulation gives a certain amount of power to the distribution licensing.
Unfettered.
That I'm coming to
so
that.
that is the difficulty.
Well, I don't want to use that expression.
Unfettered is not an abuse.
Well,
Unfettered means it's not fettered.
It gives wide discretion to the licensee. That
What is the
wide
fettered? Tell us
discretion
one fettered in the discussion.
without any fetter, my lord.
That is unfettered.
Yeah, without any fetter. Without any unshackled, unfettered, unbridled, uncanalized.
Prefer shackled to fettered then?
My lord, I want to use the expression white.
Shackle is both left to the left.
Yes. My lord,
Nothing to lose but your shackle.
What my submissions would be that under these circumstances, my lord, it should, my lord, the WBRC would be the competent authority.
Absolutely, not the court, the last of all the court.
Last of all the court.
Yes.
And these regulations, whatever the regulations are now, if they seek to amend, that would be with prospective effect. But that cannot.
So that is a good argument, yes.
That cannot, my lord, attract or
prospective overruling sort of. Yes.
That cannot cover past transactions.
I'm not committing to that, but it's a good argument.
This is the argument, this is the last argument I was supposed to make. Because I know that.
Why waste time? You're right.
Well, this is the last argument because in these cases, suppose an amendment is brought about to the regulations. The regulations are to be amended with prospective effect.
The WBRC can invite suggestions from all stakeholders.
All the stakeholders.
That will be easier for the WBRC.
That
has to be
that is necessary.
Very well.
But my lord, in those under those circumstances, whatever upon receipt of the suggestion.
But till then, we have to set it aside. That is a difficult.
Otherwise,
the unfettered discussion
we
can fix a timeline which will be reasonable after asking
this cannot, if it is set aside, my lord, I cannot be faulted for exercising my discretion in the facts of my case.
3 components of the argument. One is that prospective, it has to be prospective. Till date, whatever you have done, that cannot be set aside.
Right.
That is one component. That is one argument. The other aspect is what the court may do.
Certainly.
The court may not leave the unfettered discretion with you till it is reformulated. We may either set it aside or read something into it. Reading something into it.
Lordship may give guidelines.
Guidelines, but that is very risky in this case. We can.
Never risky, man. It's never risky.
Electricity
Guidelines,
is a very
your lordship may fix a time period within which the regulations are to be amended.
That we'll ask them also that what will be a reasonable period, and we can do
6
that.
months, whatever. Till that time.
Till then, what happens?
Till then, my lord, your lordship has to provide the guidelines.
Yes, that is the risky zone.
That's a risky zone, but that is a
risky zone, not in the sense that
it's not the forbidden zone.
No, not a forbidden zone. Nothing is forbidden for courts, but
nothing is forbidden.
Reasonability test also has to be made by the courts.
I was about to
rationality, reasonability. Just because you are a court, you do not
just to assist your lordship. Some judgments I would like to cite just on
that. The court can.
To what extent court can go?
Any extent. Every other judgment, every other day, directives are coming from superior court.
That is lordship.
On every aspect of life.
I tell you, lordship, my personal experience.
Every aspect of life.
There were no guidelines for my lord regulating my lord this performance at bar or my lord this nightclubs, etc. The court.
Oh, that bar. I thought
Not this part.
Yes.
The court framed the guidelines. Your lordships had framed the guidelines.
Yes.
First set of guidelines, I
I would
believe,
love
was
to do
framed
that,
by
but
my
not in electricity matters.
Justice Datta as his lordship then was. Then in another set of cases, I don't remember something.
Justice Datta was an unlikely candidate to formulate guidelines for bars and nightclubs.
Very.
Not competent even.
Not competent.
No, not.
Yes, yes.
Just imagine a CCTV. Why not in the bathroom?
CCTV has to be there. Then, my lord, some kind of grill has to be put around the.
Wrong judge to give those right directions. Anyway, let us not comment on Justice Datta. He's in a different place now. I'm
My
not
lord,
even competent to.
Just some of the, my lord, your lordship may kindly take note of. Kindly come to my.
No, regarding electricity matters or general power of court too.
My lord, in matters involving regulations.
That court can formulate guidelines.
No, no, not
What is the proposition?
What is the proposition is that, my lord, there are 4 or 5 tests.
Yes.
Which the court has to apply for determining that the regulation or the law is valid.
Please cite it.
Kindly take, my lord, for once. Kindly take, my lord. First is, my lord, this 2020 Akshay Patel ta there.
2022.
2022 3 SCC.
Yes.
Copy the Josh. Kindly take from paragraph 21.
Yes.
Paragraph 20, my lord, the Modern Dental College is referred to. Then, my lord, 21 is, my lord, summary of that privacy judgment.
Yes.
But this test was laid down in the following terms. The test was laid down following terms. This discussion brings out that the following 4 subcomponents of proportionality need to be satisfied. A measure restricting a right must have a legitimate goal. The legitimate goal stage, my lord, I have crossed. Regulation.
Mr. Mujumdar, I mean, in the electoral bonds case, test of double proportionality was used, which is one step ahead of this. Justice Khanna's part of the judgment. In that portion, concurring in the conclusion, but there were other tests applied. Justice Khanna applied. This is single proportionality actually, called proportionality. This applied with when there is a conflict between 2 fundamental rights, suppose.
Yes, madam.
Then double proportionality, it was taken one step further, and certain judgments of these of
to 21.
South African judgments were cited, and
I have not gone through that yet.
I've gone for a particular purpose, but I went through that, and this has been taken one notch higher. I mean, in that. Puttaswamy was one of the contexts.
Puttaswamy was one of the
contexts. So there were several things which
one thing.
Anyway,
319.1.
Yes.
That, my lord, I believe regulation 4.4 satisfies.
Very good.
Then, my lord, the means that also is satisfied.
Yes.
Then, my lord, 319.3, my lord, your lordship can examine that issue.
Yes.
Subject to lordship's kind consideration.
Right.
Then, my lord, 319.4, the balancing stage, that can be done by the guide.
Yes, definitely. Yes.
So these are the 4 tests. Kindly come now come to, my lord, why I was referring to this judgment. আমার নোটটা there, give me my notes. The copy আছে? কিছু prospective overruling ভাই কোড দিতে পারবেন। 1920 করতে। My lord will kindly take.
Yes.
Then, my lord, paragraph 29. Kindly take, my lord, the quotation from Shaira Bano. 87. The thread of reasonableness runs through the entire fundamental rights chapter. What is manifestly arbitrary is obviously unreasonable, and being contrary to the rule of law would violate Article 14. Further, there is an apparent contradiction in the judgment of McDowell when it is said that a constitutional challenge can succeed on the ground a law is disproportionate, excessive or unreasonable, yet such challenge would fail on the very ground of the law being unreasonable, unnecessary, or unwarranted. The arbitrariness doctrine, when applied to legislation, obviously would not involve the latter challenge, but only involve a law being disproportionate, excessive, or otherwise being manifestly unreasonable. All the aforesaid grounds, therefore, do not seek to differentiate between state action in its various forms, all of which are interdicted if they fall foul of the fundamental rights guaranteed to persons and citizens under Part 3 of the Constitution. Now, along with this, but this is not a Part 3 case even. This is not a Part 3 case because only would be 19(1)(g), otherwise there is no Part 3 involvement in this case. Now, paragraph 63. Instead of wasting your lordship's time, paragraph 63, what happens when, my lord, the business interest has to give way to, my lord, the public interest. This court must be circumspect that the rights and freedoms guaranteed under the Constitution do not become a weapon in the arsenal of private businesses to disable regulation enacted in public interest. The Constituent Assembly debates had carefully curated restrictions on the rights and freedoms in order to retain democratic control over the economy. Regulation must, of course, be within the bounds of the statute and in conformity with the executive policy. Then, when the regulated economy is a critical facet of ensuring a balance between the private and business interest of the state role in ensuring a just polity for its citizens. Then, when the Constitution bench in modern dental college is relied on, your lordship may put a question that why this is an economic issue, but this is also an economic issue. Well, any involvement with regard to usage of power and their entire case of the petitioner or any consumer who is a commercial consumer would obviously be based on the economic interest of that particular class of consumers. It is not a consumer like me or my learned friend Mr. Dhar or my learned friend Mr. Chakravarti. It is not a consumer like, my lord, the High Court. So, my lord, this is a case, my lord, the business interest has to be, cannot never outweigh public interest. Then, my lord, the next judgment I would like to cite is this is, my lord, 2024 4 SCC 215 on the simple ground, my lord, that the judicial review of 4.4 would involve examination of soundness of a technical policy. Kindly take, my lord, paragraph 17 of this judgment.
Yes.
Kindly take from 17A and C. A, B, C. This was obviously with respect to SEBI's power, but, my lord, this is also WBRC, this is also a regulator which has expertise in this field.
Yes. So,
17A, B, C. Lastly, my lord, this is a very interesting judgment, my lord. This is Jal Mahal Resorts versus K.R. Sharma. 140. Para 140. Da?
140 or 141?
I'm sorry, 140, 41. 140, my lord.
Yes.
Well, this is an observation made by Chief Justice Neely of, my lord, US Supreme Court.
Yes.
140. At this juncture, we take note of two overriding considerations which combined narrow the scope of review. First is that of deference to the views of the administrative experts, and the other we take assistance from the words of Chief Justice Neely, who expressed as follows: I have very few illusions about my own limitations as a judge, and from those limitations I generalize to the inherent limitations of our appellate courts, reviewing rare cases. The learned Chief Justice further observed as follows: I am not an accountant, electrical engineer, financier, banker, stockbroker, or systems management analyst. It is the height of folly to expect judges to intelligently review a
Mr. Mujumdar, this is the precise reason why I was not inclined so much to fill in the gaps.
No, not filling the gaps. The gap filling has to be done by WBRC, but guidelines regarding the general guidelines, well, not the mathematical exactitude, general guidelines like what are the situations under which and what should be a reasonable notice your lordship can always give.
We'll continue on the next day.
My lord, I'm in the verge of conclusion, my lord, because
they'll also reply, give a reply.
they will also
So
reply.
conclude if you
But
have
my lord,
anything to add. Yes.
Usual consumers like us, small consumers, they only have one energy charge which they pay. But the big consumers, they pay energy charge and the demand charge.
Exactly.
So as far as the 4.4, which is under challenge, that is only within the domain of the energy charge.
Achha.
As far as the demand charge,
I'm grateful to
Mr.
Mr.
Mujumdar has read out, there will be no demand charge.
Yes.
So I was just because
So we'll take that clarification when we we'll take that clarification on the next.
But my lord, I
Hard part for further hearing.
But my lord, obviously, my lord,
if it can be on
for further hearing on December 6, 2020.
my lord, if I have some difficulty on 6th, my lord, I have to reply on 13th, subject to my lord's concern.
The December 13th, December
13th is a good day. Another contempt is coming up in the
December 13th.
কি দাদা এরকম ভয়
Grateful, my lord.